Good afternoon. This is House Judiciary Committee. It's the 12th. It is of February 2025. Delegate Rosenberg is not here, so I see Delegate Roberson is here, and we will take House Bill 435 first. Do you have witnesses? Just you? You are more than enough. That's fine. Go ahead.
All right. Well, good afternoon, Mr. Chair. It's good to see you, Madam Vice Chair, in her absence, and to the hardest working committee in the Maryland General Assembly, the Judiciary Committee. It is good to see you all once again. I am, for the record, Delegate Kent Roberson here on House Bill 435, which deals with jury. It says on there jury disqualification, but I like jury inclusion, actually, because we are looking to include more in our jury pool when it comes to individuals who are previously incarcerated. Right now, as law stands, if you have served more than 1 year, you are not allowed to serve on a jury. And so we are looking to expand that to allow those who have already been through the parole system, have already served their time, to reintegrate them into society. Right now, as you all are aware, these individuals cannot vote, they can have records expunged, but they cannot serve on juries. And so we want to expand that here in our state to include those individuals. This has passed since I have been here and prior to out of the Senate. It has, in previous years, has passed out of the House. Grateful Delegate Williams, in her absence, gave this bill to me. Prior to, she was the sponsor, and so we've been continuing to advocate on this issue, and are hopeful that this year we can get it done. I do note, just so we're all clear, there's a fiscal note of $25,000 just to update everything as far as the standards, just so that websites are updated. So that is what the fiscal note refers to. But I am happy to take any questions when it comes to this issue. Have had many conversations with some of the lawyers on the committee, so they can also weigh in as well. But hopefully we can get this done this year and continue the conversation with the chair on that. With that, I'll yield the balance of my time. Thank you all so much.
Hey, thank you very much. There are two people who signed up, three people maybe. I didn't see Vanita. Is Vanita Taylor here? Is Vanita Taylor there? Okay. Dewan Burton and Andy Jezik. Okay, we'll hear from Mr. Jezik as soon as we can pull him up. No luck? All right, there he is. Mr. Jezik, please, for 2 minutes.
Yes. Good afternoon. My name is Andrew Jezik. I am a criminal defense attorney speaking in favor of the juror disqualification bill. There are studies around the nation that have been put out in the last 4 years that indicate that Maryland is now in the solid minority of states around the country, including solid red states. And Maryland is now in the solid minority by excluding people who should have the right for one of the most sacred civil rights, which is to serve on a jury. And I can just go through the statistics here. Approximately 40 or so, 35 or 40 states allow jurors to serve at some point after a felony conviction. Some states allow it immediately when a felon gets out of jail. Some states, approximately 10 of them, approximately 10 of them allow jurors to serve, felons to serve on a jury after they finish their parole or probationary period. So all I think this bill is essentially doing is two things. One, aligning Maryland with the solid majority of states around the country that allow former felons or somebody who is a misdemeanant who served a year or more in jail to eventually serve on a jury, to perform their civic duty after they serve their debt, after they are finished their parole or probation. So if anybody has any questions about where I'm getting these statistics, it's from a Harvard Law article that was published in the last several years doing a 50-state survey.
Okay, are there questions for the panel? Seeing none, thank you both very much. That appears to conclude the testimony for House Bill 435.
Thank you, Mr. Chair.
See Delegate Rosenberg, who is here. Delegate Rosenberg for House Bill 434. Slap suits. We've been here before, everybody. Rebecca Snyder is coming in favor, and there she is. There are 3 people testifying in opposition, 2 of which I just want to see if they're in the room. Claudia Barber and Laura Bogley. Laura Bogley from Right to Life. All right, Gordana Schifanelli. Might be virtual. All right, that's fine. We'll get started with the 2 of you, and then we'll go from there. Delegate Rosenberg.
Thank you, Mr. Chairman. Yesterday, I was with you on an issue where I was 14 years old when I first became aware of right to counsel. The genesis of this bill, of the SLAPP bill, is one of the episodes of LA Law in prime time when the bad guy in the firm brought a SLAPP suit. And we then brought a bill. I brought a bill before this body. It didn't pass the first year, but then Judge Joe Murphy, myself, and Buzz Winchester, who was the lobbyist at the time for the Bar Association, worked on a legislation that did eventually pass. The problem has never been this House. Senator Baker, of blessed memory, was the chair of JPR, and it never got out of his drawer. So we are hopeful that this year we'll get it out of the drawer and onto the governor's desk for signature. The main change that this bill would make in the law that we did pass nearly 20 years ago now, I guess, is the requirement that under existing law that the suit be brought in bad faith, that the injured party, the neighborhood group, or the individual who has been wrongfully sued has to demonstrate that the party bringing that suit was acting in bad faith. That even a recent court decision dealing with a project in Baltimore City that was opposed by the community, the trial court judge, in his opinion, makes reference to the fact that this is an onerous burden in these kind of lawsuits to have to demonstrate bad faith. And it's the very nature of the suit itself that it is bad faith. These are occurrences. There's one most recently in the 46th district in Baltimore City regarding a expansion or new site for a restaurant that led to community opposition, and then a lawsuit brought against, I think it's one of the defendants at least, was the spouse of the comptroller, Brooke Learman. And I believe he testified, did he not, over on the Senate side?
I think he submitted testimony.
Submitted testimony. So this committee well knows, for those of you here who've been on the committee the entire term, this is our 3rd go around. We hope to get action moving over on the other side, but would of course appreciate yet again this committee acting favorably. Thank you.
Good afternoon, committee, and my name is Rebecca Snyder. I'm not, thank you. For the record, my name is Rebecca Snyder. I'm the Executive Director of the Maryland-Delaware DC Press Association, and we do strongly support strengthening Maryland's anti-SLAPP statute. This bill has passed out of this committee in the same posture several times previously. It has been heard in the Senate. There is a work group that has been assigned to work with it on the Senate side, and this fixes a problem that we're seeing in a wide swath of communities. This is not just a media bill. It's not just journalists who are getting hit with with SLAPP suits. It's community activists. It's people who are in domestic violence situations. It's weaponizing the court systems against people. This bill does not preclude options for suing someone for defamation or libel. What it does is create a situation where someone who feels like they're being slapped can ask a judge to make a determination whether or not the suit has merit and can continue on. It is not going to toss millions of lawsuits out of the court system, but it does allow for people who are being sued unjustly for speaking their mind, not in a defamatory or libelous way. It allows them to stop the bleeding. It is very, very expensive to defend against lawsuits. I think everybody knows that. And we're trying, and this bill, by removing the bad faith provision, by by creating a process by which the judge can dismiss more readily and defining clearly what the SLAPP suit is, and offering the possibilities of shifting attorney's fees. All those are tools to help make sure that we don't have frivolous lawsuits. So we ask for a favorable report. Thank you.
All right, questions? Seeing no questions, thank you both very much, and we'll hear from those people in opposition. Ms. Barber, if you'd like to come forward. Laura Bogley? Don't see Laura Bogley. Gordana Schifanelli? Not on virtually. So we'll hear from Ms. Barber now for 2 minutes and go from there.
Good afternoon, Mr. Chairman and Vice Chair. I urge you to vote against House Bill 434. The strategic lawsuits against public participation bill looks very meaningful on its face. However, it definitely has grave consequences against public figures by arming citizens with the right to report anything and everything to public entities and rewarding those citizens with ulterior motives who do the reporting with blanket immunity and attorney's fees. Not even civil rights litigants enjoy this special attention to resolve a case quickly by making a special motion. On January 6, 2021, now known as Insurrection Day, we saw how people engaged in conspiracy theories wrongly claimed First Amendment protection for their insurrectionist acts of terror. And the First Amendment should never again be used as a reason to harm individuals or destroy human beings. One of the pitfalls of this legislation is that it does not protect innocent victims such as public figures or politicians who may have rivals instigating stories by using public records, resources, and government agencies to create news stories to smear an opponent. It particularly impacts people of color in their communities when misinformation is spread to newspapers and destroys individuals' livelihood and reputation. In 2016, an ex-judge filed an ethics complaint against me, asking my employer to remove me from office because I ran in a partisan primary. What the complainant did not do is tell my employer that the office of judge for circuit court is not a partisan office. It was important not to tell this truth because that would have destroyed his plan to have me fired for an ethics violation, which was later used on campaign literature by 4 sitting judges.
Other questions for Claudia Barber? Delegate Conaway.
Thank you, Mr. Chairman. Thank you for coming in to testify. Did you submit a copy of your testimony?
I did.
Thank you so very much.
Any further questions? Seeing none, thank you very much. And that concludes the testimony on House Bill 434. House Bill 660 is next. That's Delegate Terrassa. Delegate Terrassa will be joined by the Register of Wills for Howard County, Byron McFarland, also Mary Rowley, and Joseph Griffin. Delegate Terrassa, you get 3 minutes. Everybody else gets 2.
Thank you, Mr. Chairman. Good afternoon, Chair Clippinger, Vice Chair Bartlett, and esteemed members of the Judiciary Committee. For the record, I'm Jen Terrassa. Thank you for the opportunity to present 660, which is a straightforward measure to streamline the opening of estates in Maryland. Losing a loved one is never easy, and it's especially challenging for folks who have to undertake the unwelcome tasks following the passing, arranging a funeral, paying bills, clearing out homes, selling and transferring property and vehicles, et cetera. To do these things, many Marylanders have to go through probate and open estates for their loved ones with their local Register of Wills. While the General Assembly has given the registers broad administrative authority to administer estates, our probate code needs to be continuously updated to reflect modern life and noticeable trends. One such trend is our reduced reliance on original paper records in practically every aspect of our lives, particularly since COVID, as you all know. The legislature has already taken steps to make probate less reliant on original paperwork. I think your committee passed, and we passed House Bill 244 in 2023, which permits use of copies of signatures and e-signatures in probate, and also authorizes registers to implement an e-filing system. And those have made life easier for everyone. What 660 does, and what we're doing is building on that. It allows the register to accept a copy of a will. When they're presented with a valid copy of a will, a petition by an interested person can send from all interested parties. Currently, following the death of a loved one, a family member or other person seeking to probate an estate must present an original version of the decedent's will. If they have a copy, they need to go before a court, the orphans court, or in some counties, the circuit court, if there's no orphans court. This requires a minimum of public notice and a hearing date, which adds cost to probate, and a return to the courthouse, which is more time off of work, et cetera. These delays can cause additional problems for the person trying to administer the estate, because these matters, because basically until those matters are resolved, there's no money available for funerals, for getting the car titled, paying bills or debts, or even keeping the electricity in the decedent's house. This added layer of bureaucracy provides no benefit. Removing it creates no risk. In fact, Register of Wills scrutinize original wills and determine their validity every day, and to the tune of 10,000 wills per year in Maryland. So in conclusion, for the growing number of Marylanders who want to honor their loved ones' final wishes, get their estates open so they can resolve them as quickly as possible, this bill removes an obstacle. Thank you.
Whoever would like to go next?
Okay.
I was told I had to tell you.
Good afternoon, Chairman Clippinger and Vice Chair Bartlett, members of the committee. My name is Joe Griffin, and I'm the Register of Wills for Montgomery County, and I'm here testifying in favor of this bill. While we have one of the smoothest and most efficient probate systems in the country, we can always find ways to make improvements to better serve the public. As you all know, the registers come here almost every session with reforms we feel will make people's lives a little bit easier and support them through the system. To provide a little history, in 1970, the General Assembly gave the registers the duty to probate wills and appoint personal representatives, replacing the colonial-era system, which required hearings before the orphans court. It made this change because of a growing caseload and the fact that orphans courts were and are mostly part-time courts. Under this reform system, families can visit their local register any day and open their loved one's estate with a single trip to the courthouse. However, we do have a big problem when we're presented with a copy of a last will and testament as opposed to the original. Current law allows us to use copies under two circumstances. One, if you file a copy of the will along with a petition and consents from everyone involved, the Orphans Court can order the register to probate the will. Or two, you can go through the judicial probate, which requires a notice in the paper and public court hearing to determine if the will can be used. The first method was authorized by the legislature in 2009 to make it easier to probate copies when everyone is in agreement, to avoid cost and the inconvenience of the court hearing. The second is based on old common law. We've seen the use of copies steadily grow since 2009 and have included an annual breakdown in our written testimony.
Good afternoon, Chair Clippinger, Vice Chair Bartlett, members of the committee. My name is Byron McFarland, Register of Wills for Howard County, and I chair the Register's Legislative Committee, and I'm here to express our unanimous support for this bill and thank Delegate Terrassa for sponsoring it. I also want to recognize a few of our colleagues, the Registers from Carroll, Garrett, and the Dean of the Registers, the Register from Calvert County, who are here as well. To pick up from my colleague, it's clear we're seeing people relying more and more on copies of all kinds of papers, including wills. In our world, we simply don't need original papers like we used to, so we don't store them like we used to. But the current law essentially penalizes and creates an undue burden on people for what is essentially normal behavior. When someone presents us with a valid copy of an executed will, a signed petition, and consents from everyone who has an interest in the estate, they overcome that common law presumption that the original was revoked or destroyed. They are coming to us in unanimous agreement where the validity of the will is not in question and there is no discord whatsoever in the family. They are doing precisely what we all know our judicial system is designed to encourage: people to come to consensus and reach agreement without a judge having to do it for them. So we should respect families coming together in consensus and make their lives a little easier by passing this legislation. If not, we leave families with the status quo, having done all the legwork to search for a will, locate a copy, put differences aside, file all of the appropriate paperwork, but left sitting waiting for a signature, sometimes days, sometimes weeks, sometimes months, depending on the jurisdiction. We actually found one case where a copy of a will sat for 28 weeks just waiting for a signature that the registers could have done the same day. It's undeniable that this extra procedural hurdle is merely an imposition at this point, and given the legislature's desire to promote efficiency in probate, we should pass this legislation. Thank you.
Good afternoon, Chair Clippinger, Vice Chair Bartlett, and the other members of the community. My name is Mary Raleigh. I am the Register of Wills of Frederick County, and I do support this bill. I'd like to concur with my colleagues and also add my perspective as the only register to have also served as a judge on Orphans Court, and also as an emeritus professor who taught the role of the Register of Wills and the role of the Orphans Court judges. We are presented, as a judge, we were presented with copies of wills. And each time that we were presented, I always went to the Register of Wills to ask their professional guidance. And we would then follow what the Register of Wills said. I'm aware that there's a handful of judges who oppose this bill, but as a former judge, I support it, and also the Orphans Court judges in Frederick County also support it. Opponents may say the judge needs to scrutinize what the registers give them, but in my experience, this simply is not true. There are times that wills are incomplete or they have handwritten notes, and the courts need, to that point, they need to review them. There's clear that there's no problem here, but we've already explained that the delays that do occur. They may say that the wait isn't that long and people can just deal with it, but let's keep in mind when someone dies, their assets are effectively frozen until an estate is opened. In the meantime, bills pile up. People can be forced to pay for things out of pocket that they can't afford, and we know that now, especially with this economy. They say that this body changed the law in 2009 and this was somehow the final word on how to treat wills, copies of wills. In 2025, the world has changed. To summarize, the public is relying more and more on copies of wills to honor their loved ones' wishes. The current law, and thank you very much.
Finish your thought.
Current law requires an unnecessary hurdle in probate. This bill fixes that and will make probate more efficient and more fair for the people of Maryland. Thank you.
Questions? Delegate Conaway.
Thank you, Mr. Chairman. Thank you, panel, for coming in to testify. Does a copy of the will need to be notarized?
No, it does not.
And how do you authenticate that will was written by that person?
I'll answer. Delegate Conaway, so the requirements for a valid will in Maryland is that it has to be in writing, signed by the testator, and 2 witness signatures. A notary may serve as either or both of the witnesses, but a notary itself is not required.
Okay, but the 2 witnesses are required.
That's correct.
Thank you so very much.
Yes.
All right, seeing no further questions for this panel, I believe that concludes the testimony for House Bill 660. It does. Thank you all very much. Delegate Long. All right, so fair warning, announcing to the committee, we're waiting for the Chief Judge and other members of the Judiciary to join us from across the street where they're testifying in the Senate. Should they arrive, we'll be preempting any other bills on the list until we deal with the Judiciary's bills, but being that all that's left is Delegate Long's bill and Delegate Miracuse North's bill, we should be able to get those 2 bills in, I hope, prior to doing that. But now that I've said that, I've jinxed it. Delegate Long, why don't you present the bill, and then is Mr. Silver here? James Silver? He's on virtually? Okay, that's fine. Delegate, go ahead, and then we'll bring up Bob Enton and Mr. Silver. Go ahead.
Thank you, Mr. Chair, Madam Vice Chair, members of the Judiciary Committee. For the record, I'm Delegate Jeffrey Long, presenting to you House Bill 756, which I brought to you last year and passed the committee and the House unanimously. This legislation is aimed to enhance the adult guardianship process in our state. As we deliberate on this crucial matter, we must consider the impact that this legislation can have on the lives of vulnerable Marylanders who require legal protection and support. This proposed legislation seeks to introduce a temporary stay on provisions such as we see in the bankruptcy stay. Much like the bankruptcy stay, this provision would offer a critical break to individuals facing financial and housing crises due to their disabilities. It would temporarily halt eviction proceedings and creditor actions, allowing these individuals to have a court-appointed guardian manage their finances and affairs until a more permanent solution is reached. For example, individual A could have been diagnosed with dementia, faced the loss of their home due to unpaid taxes. Despite having sufficient equity and resources to rectify the situation, individuals A cognitive impairment prevented them from acting. The absence of a temporary stay led to the unfortunate sale of their home. Had such a provision been in place, a court-appointed guardian could have intervened, preventing the loss of a home and safeguarding individual A's assets. Lastly, for example, individual B. Similarly, they were living alone with dementia, facing eviction from their apartment due to unpaid rent. Despite having the means to fulfill their financial obligations, individual B's condition impairs their ability to do so effectively. Without intervention, eviction not only deprive individual B of shelter, but also expose them to harsh realities of homelessness, particularly during the winter months. A temporary stay provision would enable the appointment of a guardian to address the arrears and ensure the stability and well-being of individual B. These examples, which are real-life examples, show the urgent need for this legislative measure that prioritizes the protection and rights of individuals with disabilities. Again, I ask you all for a favorable report. I believe we've worked out something with the Senate this year to get it finally through, and I believe it can pass again this year. So thank you, Mr. Chair.
Delegates, questions to the delegate? All right, let's go ahead. Mr. Enton, come up. Mr. Enton is coming up. We'll ask Mr. Silver, please, to testify for 2 minutes. They're favorable with amendments.
Thank you very much.
We'll let Mr. Silver go first. That's fine. Mr. Silver, go ahead.
Thank you, Chair Clippinger, Vice Chair Bartlett, and committee members. Maryland Legal Aid is the largest nonprofit law firm in Maryland. Part of our work is providing court-appointed representation for alleged disabled persons and guardianships in multiple Maryland counties. As the delegate described, our clients often come to us during or right after lengthy hospital stays. We've worked with multiple clients who, while in the hospital, have also faced actions that could result in a loss of their home and their worldly belongings. at the same time that they're facing a loss of their decision-making rights and guardianship. HB 756 would provide a useful tool for us in representing our clients, not just in guardianships, but in other matters around the state when those clients are also subject to a guardianship action. We're requesting a minor amendment so that not just petitioners, but parties to a guardianship can seek a stay. It's my understanding the delegate agrees with that amendment as well, he's willing to make that amendment. That would allow us to use this bill to support our clients and would put all guardianship parties on equal footing. So with that minor amendment, we encourage you to return a favorable report. I did describe that amendment marked up in an attachment to my written testimony. So we appreciate that, and thank you very much.
Thank you very much, Mr. Chairman, members of the committee. Robert Etten on behalf of the Maryland Bankers Association. This bill passed out of the committee last year. I went over to the Senate. I worked very closely with Chief Judge Morrissey on this bill. We both had concerns, not really with the idea behind it or what the bill did, but how it would be processed by the court. How would parties get notice of the proceeding? What period of time would there be? We worked with the sponsor and had a set of amendments, and I dropped it off for staff this morning for committee counsel, a reprint of the amendments to last year's House Bill 359 from the Senate. And it's dated April the 4th. So this was right at the very end of the session. We worked it all out. They're all procedural changes, but the bill never went on a voting list. Just to give you a quick example of what some of the changes are, they added a line to the first section, 13223A, where it said that, talked about a stay of any of the following civil actions against the alleged disabled person, but it doesn't say what court it had to be filed in. So Judge Morrissey and I worked out the language that said it gets filed with the court presiding over the civil action or proceedings. So that's the kind of amendments we had. We had amendments further down in subsection, added a new subsection B that provides for notice of the petition and the request to all parties to that action. So they're nothing but, they're not substantive, but they're all procedural. I spoke with Judge Morrissey last week about it. He agreed that he supports these changes, and with these procedural changes, we have no problem with the bill. We support it fully. Thank you.
Vice Chair with a question.
Mr. Chair. Mr. Silver, my question is for you. How many parties are there in a guardianship complaint or petition?
Delegate Bartlett, Vice Chair Bartlett, I should say, it depends on the case. Typically, it's what the law says is that interested parties are anyone who would be heirs to the alleged disabled person, and also the local Department of Social Services or Division of Aging. Now, typically Division of Aging and Social Services wouldn't be involved in this, but family members, for example, might know of the property actions that are facing the alleged disabled person, and they would be able to then introduce the stay as well, just to make sure that their fathers or mothers or sons' property is protected.
Well, that's why I was asking my question, because those are interested parties. But they're not named parties, right?
That's correct.
So do you want your petition, I'm sorry, do you want your amendment to say interested parties? Or do you want it to say party? Because I read it as whoever's above the V or after the V.
I was trying to cast as broad a net as possible, honestly. I do think in our case, we are interested in being able to request, should the bill pass, we would be interested in being able to request to stay on behalf of our clients specifically. And I know in some cases petitioners are related, but in other cases it's hospitals, and they wouldn't necessarily be interested in or have the motivation to file the stay. So I just wanted to make sure that someone who would be able to know about the disabled person's property would be able to seek the stay. But as you said, I am trying to cast a broad net. I'm amenable to it. I really would like to make sure that we can do this on behalf of our clients, certainly.
Okay, all righty, thank you.
Seeing no further questions, thank you very much. That concludes the testimony on House Bill 756. We thank you very much. All right, here's what we're going to do. We're going to hear House Bill 487, and that's you. And so just for the committee's edification, we're waiting to see when the judges get here. Obviously, we're going to finish this bill. We're going to do this bill now without question. When the judges get here from across the street, we're going to let them intervene. Well, we'll finish your bill and then start their bills. But if your bill finishes before they get here, we're going to be going to Delegate Phillips's bills, including 325, 592, and 635. So just to give everybody a heads up, we're trying to be flexible because they're over in JPR right now, and we all know how that can be. House Bill 487, though, Delegate Miracle U North, you go right ahead.
Good afternoon. If I can, I believe we have one individual. This would be my first panel, but he's virtual. Is it possible to bring him up, Mr. Chair?
Sure, let's see.
David Prater from the Attorney General's office.
David Prater and Vanita Taylor?
Vanita.
Yep.
Okay.
Yeah, we're bringing them up.
Okay, great.
All right.
May I proceed?
Please.
Thank you, Mr. Chair. Chair Clevenger, Madam Vice Chair Bartlett, and esteemed members of the Judiciary Committee, I come before you today on House Bill 487, Unhoused Individuals' Rights, Civil Action, Affirmative Defense. This is an expansion upon last session's Bill 734, which passed out of the House successfully, and thank you to your work for that bill. But that bill removed vagrancy as a tool for municipalities to criminalize homelessness. What has happened since then? The Supreme Court decision in the city of Grants Pass, Oregon versus Johnson, which is basically giving a license for localities to move an unhoused person, even if there are no safe spaces for them to go. While not every law enforcement agency or jurisdiction does this, there's no law prohibiting the practice. Currently, Worcester County and Hagerstown have legislation pending post this Supreme Court decision. And there's new data that's come out about the older and the unhoused. Those 55 and older make a disproportionate amount of bookings of unhoused people in the U.S. And per the Maryland Housing and Community Development Department, there's a 59% increase from 2022 to 2024 of those 65 and older and unhoused. This bill is simply introducing a new idea on how we're approaching homelessness. It's permitting law enforcement to remove an unhoused individual from a public place if there's an alternative indoor space available elsewhere and the affected individual can be transported to it. So this is not a license for criminal activity, but rather establishing the rights of unhoused individuals to engage in essential life-sustaining activities in public spaces. And there's 9 listed in the bill. So law enforcement can still charge when necessary, and we're going to introduce amendments to clarify that. But at a minimum, this bill is asking for law enforcement just to inquire whether there is adequate alternative indoor space besides just resorting to incarceration or a fine. And like I said, some jurisdictions are doing that. In Montgomery County, when an unhoused individual, there's an issue with an unhoused individual, it's the Health and Human Services that step in and address the shelter options before further police intervention is necessary. So we welcome amendments to this bill. I think it's a better use of time than trying to stoke fear of misinformation, because there's been a lot out there. But I'll tell you what hasn't changed. That vagrancy laws has always been a pain point for Black Marylanders. Historically, I mentioned this last year, vagrancy laws used to be exploited to detain free Black Americans. Currently, there's 60% of the unhoused population that's Black. So yes, any solution is going to have a fiscal commitment to it. And the fiscal note is really based upon a lot of what ifs, but once we get the amendments strained out, I'm confident our fiscal note will be lowered. But the cost of our elderly and our Black Marylanders being criminalized because of their housing status is going to cost the state more. So I'm amenable to amendments and working with the stakeholders, and I ask for a favorable report on House Bill 47. Thank you. Go ahead.
Thank you, Delegate Miracle North and members of the committee. My name is Eric Tars, and I'm here on behalf of the National Homelessness Law Center. We, along with everyone here today, I'm sure, wants to see a Maryland where no one needs to sleep on the streets. I helped draft the model bill that House Bill 487 was drawn from in the wake of last year's awful Supreme Court ruling in Johnson versus Grants Pass, where the court said that our Eighth Amendment doesn't protect unhoused Americans from the cruel and unusual punishment of being ticketed or arrested for simply trying to sleep and keep themselves warm outside, even when they have nowhere else to go. But this bill takes on elevated importance today, as just Monday night, the Washington Post broke the story that President Trump is now planning an executive order that would implement his campaign pledges to criminalize homelessness nationwide and force unhoused people under threat of arrest into government-run detention camps. The legislation before you today is crucially important to restore the protections lost in the Grants Pass case and help ensure Maryland residents who can't afford the rent don't end up in one of Trump's homeless detention camps. There may be those today who tell you that this bill will limit how communities can respond to encampments, but let me tell you, that is not true. Communities in the Ninth Circuit and across the country have lived with similar laws for years and have successfully reduced encampments. Under this law, Maryland communities are still free to respond to encampments with any of the many more effective methods than trying to arrest and ticket people. They are even still free to use the ineffective, expensive, and counterproductive criminalizing approaches if they want to. The only thing that they can't do is use law enforcement methods against people for surviving without first ensuring people have an alternative place where they can undertake these basic life-sustaining activities. They're still free to enforce that without a check if unhoused people are breaking any other law. So the only reason someone doesn't want this bill to pass is because they want to be able to arrest Maryland residents who can't afford the rent, not for any violent crime, but just for the act of trying to sleep or shelter themselves. Please pass this bill.
Go ahead, Ken.
Good afternoon, Mr. Chair. Good to see you. Madam Vice Chair, thank you for the opportunity to testify. My name is Kevin Lindemood. I'm the president and CEO of Healthcare for the Homeless and the president of our subsidiary, HCH Real Estate Company. We're Maryland's leading provider of integrated health services and supportive housing for people experiencing homelessness. We're serving about 11,000 people annually in Baltimore City and Baltimore County. We're here in strong support of HB 487. Let's start with a shared understanding that no one wants there to be homelessness in public spaces, least of all those who are experiencing it. I started my career 30 years ago as an outreach worker for Healthcare for the Homeless, and I can tell you from personal experience that the forced closure of encampments, the issuing of citations, is cruel, costly, and utterly counterproductive. Today, we engage people into care through the provision of outreach services, under bridges, on park benches, throughout our communities. We employ a mobile clinic, a clinic on wheels that takes people out of our 4 clinical spaces out into the community. We're about to launch a street medicine program later this year where we take care directly to where people are. We know that effectively engaging trusting relationships can take months and even years, and those relationships can be damaged in about 5 minutes. We know that it's the state's intent to have organizations like ours increase access to health care, increase access to addiction treatment, lower public costs, move people into housing. Sweeps make all of that work harder. HB 487 is hardly the solution to homelessness, but not passing this bill would make the proven solutions that we try to achieve every day so much harder to achieve. Thank you for the opportunity to testify.
All right, 2 people virtually now. Mr. Prater, we'll hear from you, and then Ms. Taylor.
Good afternoon, Mr. Chairman, members of the committee. My name is David Prater. I'm an Assistant Attorney General in the Civil Rights Division. The Attorney General supports HB 487 with amendments. Just briefly, that amendment would remove the Attorney General's authority to enforce this statute against local jurisdictions. We would fully expect that local jurisdictions and municipalities would comply with the will of the General Assembly should the bill pass. Just 3 quick points. First, what this bill does is it restores a common sense rule that it is cruel and ineffective to criminalize people who are experiencing homelessness for merely existing in public spaces. And it does that through a 2-step legal analysis. So first, is the person engaged in life-sustaining activity? And that is a term of art defined by the statute. That definition does not include things like harassment, public urination, other criminal activities. It is a very narrow definition of what a life-sustaining activity is. Second, the second step in the analysis is whether there is adequate alternative shelter. And again, that is a defined term. So it would require looking at whether there is, in fact, shelter space. If those two elements are not met, then enforcement action is an option. But as referenced by some of the other other panel members, that may not be the best and most effective way of addressing issues of homelessness. Just very quickly, I want to point out why this is an issue of statewide concern. Because one of two things happens when these ordinances pass. One, people go to jail. May I briefly
If you finish
conclude?
up, yes, please.
So one, people go to jail, and that's very expensive. It's about $5,000 a month to house people in Maryland prisons. Or two, people go to another jurisdiction. And that just makes it another jurisdiction's, another municipality in Maryland's problem to try to solve. So it's really important to have a comprehensive statewide approach to this issue so that it doesn't lead to some sort of spiraling effect where people just move from jurisdiction to jurisdiction.
Thank you. We'll hear now from Vanita Taylor, please, for 2 minutes.
Good afternoon, Chairman Clippinger and other delegates from the House Judiciary Committee. This is Vanita Taylor from the Public Defender's Office. I am here to testify in support of this legislation. I would first like to start that we have had other bills that have been presented to this honorable group of individuals and to talk about getting rid of vagrancy, getting rid of other items that are on the list of nuisance. If you look at the public defender's testimony, you will see the list of charges that someone could be find themselves up against as a nuisance. And it is actually labeled nuisance in the state of Maryland. And most of those charges are based upon someone's status as being unhoused. We are very well aware that in the state of Maryland that we don't have we don't have adequate housing for people who are low income. It does not exist. And we have tried to do better, but it has been a challenge, especially in these difficult times. But what we in the Public Defender's Office, we went and ran the numbers, and I'll tell you the numbers for disorderly, there were 6,217 charges last year. Of those charges, only 289 were guilty dispositions or finding that the person was involved. This was for disorderly. For trespassing, which is the major charge that we see our unhoused folks come against, is there were 1,116 charges, only 13 guilty dispositions. I would say that that's not an efficient and effective use of our time and money in the state of Maryland to deal with the issue of someone's status of being unhoused and having to live on the streets, which comes with its various difficulties. We urge a favorable report with the amendments of this bill.
All right. Questions now for the panel. I have a very quick one for Ms. Taylor. Would you get back to the committee, please? You indicated that there were 1,100 charges or so for trespass and 16 were found guilty. I'm assuming of just trespass.
I'm sorry, it was for trespassing, it was 1,116, and there were total guilty disposition 113.
Okay, were they found guilty of any other offense at the same time?
Not from the statistics that we ran, no. That was what the charge was. The primary charge was trespassing or disorderly.
And nothing else?
Yes.
All right. There are lots of questions. I'm going to start from my right this time. Delegate Schmidt.
Thank you, Chair, and thank you for everyone for testifying today. My question is specifically around the numbers. Do we know the number of unhoused individuals in the state currently? I looked for some statistics online, and I see the last report was either 2018 or 2021, so I don't know if there's an updated report.
The last one that's up there from 21, go ahead.
Yeah, but no, I was going to say, I know that there's a Assistant Secretary of Homeless Solutions, was a person not part of the panel, but I can find that out from her, is what I'm saying.
Yeah.
I don't have the exact numbers of the total amount for the homeless for state.
Okay, some of the numbers Ms. Taylor provided help, right, with the number of charges.
Well, yeah, at least
right?
those individuals.
And just a brief word on the numbers. The numbers that do exist, and as you mentioned, are somewhat dated, derive from HUD's definition of homelessness, which is one of 7 federal definitions, and it happens to be among the narrowest. And it derives from a single point-in-time estimate that takes place generally in January, so one of the coldest nights of the year. It doesn't include people who are doubling and tripling up, living transiently from place to place, living in abandoned buildings. They're taking those broader definitions and even taking the narrowest of definitions. There was an 18% increase in 24 over 23, and a 12% increase from that year over the year before nationally, also reflected very much in Maryland's numbers. So it's something that even by the narrowest and most insufficient count, we know is going up.
Yeah, I see there's some delineations here of veterans for one, families are another, 65 and older is another. So I see there's some different categories here.
And rates of older adults have particularly been increasing. The stat that you mentioned Daniel Meister has in Maryland is rather alarming, but it certainly tracks with what we're seeing on the ground level. I mentioned starting this work 30 years ago. If I was working with someone who was 55 and had a disability, I could get them housed in a matter of weeks. Now we're routinely working with people who are 75, 85, and lack a regular place to stay. The cost of housing in Maryland has increased. Private market rates have increased 41% over the past 3 years. Which is alarming. Wages have not matched that at all. It would cost you in Maryland more than you'd have to earn more than $30 an hour to afford the average 2-bedroom apartment, more than twice Maryland's minimum wage.
Yeah, I see some testimony here. A lot of our smaller rural cities have really weighed in on some testimony. I'm sure there's some amendments that we probably need to work on there. And I agree with you. The affordability index for the state has changed immensely over the last 4 or 5 years. Right. So if you could get us those numbers, that'd be great.
We absolutely could.
Yeah, thank you.
Delegate, in the testimony of the Attorney General, the last HUD point-in-time count from 2004 was 6,069 households. And as Mr. Lindemoon pointed out, that's the narrowest definition of homelessness. So that is a very conservative estimate of households experiencing homelessness.
Thank you. In honor of my good delegate, Delegate Simmons, who's not here, the numbers are important, but I appreciate that.
Delegate Pasteur.
Thank you, Mr. Chair. Those who are unhoused come in a number of different categories. Yeah. So what do you see as what is effective in changing that? We often see the police engaged. We have all sorts of outreach. But with the numbers that you are sharing and the variety of folks and circumstances, what, with all the discussion of Bill, what is going to be effective in bringing people in? Even if you have the accoutrements, what will be effective in bringing people in?
Okay, I'll start, and then I'm sure you got plenty more to say. But what we've seen in other places, in Miami, Florida, the law that we're suggesting here today is kind of based on a court decision from Miami in 1991 called Pottinger versus Miami, When the courts there ruled that this same standard, that you can't arrest somebody or ticket them unless you give them an alternative place to go, was put into an injunction, what they did was they redirected some of their tax dollars to affordable housing, to the Miami-Dade Housing Trust. They created more shelter beds, and they created more housing. And it cut their homelessness rates by more than half. They brought people inside. They ended encampments. That's how they did it, by housing people, by giving them adequate shelter. When that injunction was removed just a few years ago, the homelessness rates, the encampments, went back up. So if we want to end encampments, if that's all of our collective goal, the way to do that is by passing this bill to make sure that communities don't backslide. The problem that we have with these criminalizing laws is that they're very politically convenient. It allows an elected official to say, I've done something about homelessness, and I can hide the cost of it in my police budget, my jail budget, but it's actually going to cost 2 to 3 times more to run a person through the jail system, and then they come out the other end with an arrest record with fines and fees that are just a barrier to them saving up their first month's and last month's rent. So you've actually prolonged that person's homelessness. So the ways that we know to get people inside are through outreach, figuring out who's out there, what their barriers are to getting into housing, and then addressing those barriers with the adequate resources to do it. We know very well the numbers of people, veterans experiencing homelessness have gone way down, and it's by housing them. It's by this outreach method. It's not by arresting them.
Yeah, I appreciate what you said. That's truth there. And that goes as well with female veterans who are homeless, and they tend to be ignored greatly, and who have families, because those who have families can't always go to places where they're taking individuals or men or whatever. And so it is a large problem, and you hit it when you said sometimes there are those politicians and others who come up with a quick fix and say, I've done my job. It's very heavy. So thank you. I appreciate your answer.
And I would just underscore that the only solution that I have seen to be effective over 30 years is patient engagement and outreach and ultimate placement in housing with the support that people need to not only get housed, but to stay housed. And when you're trying to establish those relationships, if you go back to the place where someone was and the place they had been staying has been destroyed, it can take you weeks to find them again, if they'll even talk to you. And if people wind up arrested, it becomes, you have to start the process all over when they come back out with helping people get ID so that you can help people get into housing. Some jurisdictions, as Eric mentioned, have made great strides in housing-focused solutions. We've seen in Baltimore City, just in recent years, with help from Medicaid in Maryland and from the Department of Housing and Community Development, who's having its budget hearing today, wonderful strides in creating housing that's accessible to the most vulnerable among us and matching people with that housing and supporting them there. That's what ends homelessness, and we're hopeful that as a community we can do even more of it.
Thank you.
Delegate, just from the Attorney General's office and from a law perspective, or law enforcement perspective, I would just like to add, it also encourages good community policing practices for police to develop relationships with social service organizations, homeless services organizations, because the reality is police are going to encounter people who are experiencing homelessness. And it's not a job that they're well equipped for. But by encouraging that collaborative community policing model where police know who to contact, who to go to help people, that's the sort of model that we would like to see implemented statewide. And I think this committee has passed a bill on Center for Excellence in Crisis Intervention Training. So I think that melds nicely with the way in which this committee has addressed these sort of issues with community policing and law enforcement in the past.
Thank you. Delegate Tomlinson.
Thank you, Mr. Chair. I know that the Supreme Court decision, I think a few of you brought it up. I want to talk a little bit about that. So, City of Grants Pass versus Johnson, it looks like the decision basically established a local government ordinance with civil and criminal penalties for camping on public land do not constitute cruel and unusual punishment of homeless people. And I'm finding different articles about San Francisco and Portland, cities that are associated with homelessness, and it looks like they've been using this Supreme Court decision to kind of crack down on things out there. So I'm trying to understand how this bill, and I understand there's amendments that are coming forth, you've mentioned that. I'm trying to understand how the Supreme Court's decision, how that interacts with what's being proposed here in this legislation, and how there's not a conflict there.
So the Supreme Court was really clear in their decision. The Constitution is just a floor, it's not a ceiling. So all they said is that the Constitution does not protect this right, but any state court could find that it exists in the state constitution, or a state or a municipality could pass a law saying we in fact do want to include this protection under our law. So there's no conflict. And they were really explicit about saying any community is welcome to deal with homelessness in the same manner that was the law of the land in the Ninth Circuit previously. And right now we have bills in 4 other states that have already been introduced doing something similar to what's being suggested here. It's been resolutions have been passed in Philadelphia and in Hamden, Connecticut, kind of endorsing the same approach. So yeah, the Supreme Court was really clear. States are free to put these protections in place if they want to.
Has San Francisco or Portland or Seattle, to your knowledge, passed similar
laws
like this?
As you said, and since the decision has come down, they have gone to a more enforcement-heavy approach, which is short-sighted and isn't going to be effective. The issue, rents are going up everywhere, and in particular in those cities. And Zillow has found that for every 9% increase, or for every 9% increase in rent, or every $100 increase in rent, homelessness goes up by 9%. So what's driving homelessness, the growth of homelessness, is not the permissiveness of people allowing them to live in their communities. It's the fact that there isn't enough affordable housing and people are getting forced out as the rents go up and wages haven't kept up. And so when communities see this growth of homelessness, of visible homelessness in their communities, they want to react, and the best thing to do is to get people back into housing. But the most politically convenient thing, unfortunately, is to use law enforcement to force people out of public view in one place and satisfy the constituents who are complaining about them there. But because you haven't solved their homelessness, because you haven't given them another place to go, they just have to go somewhere else. And so you've recreated the problem, and it's very inefficient. These cities are spending tens of millions of dollars every year just shuffling people from corner to corner, not actually solving the problem when they could be spending that money creating housing and actually making things better.
Thank you.
Delegate Cardin.
Thank you, Mr. Chairman. Thank you very much for this very interesting legislation and for your thoughtful comments to all the folks that are testifying. I'm going to take off my Judiciary hat for a second, put on my former committee, Ways and Means hat, which I believe is the committee that you're on, correct?
Yes.
So in the fiscal note, it says state expenditures could be significant, local expenditures could be significant. I'll just give you one example and maybe you can respond to it. I guess this isn't really for the for your witnesses, but really for you. Special funds may increase significantly, particularly the insurance trust fund. That's for the state, and the comptroller's office would be very concerned about how to fund it. In addition, MDOT advises the bill will result in fiscal and operational impacts, including increased legal risks. They will be required to hire numerous attorneys, could cost a significant amount. They don't give the, except the only thing they say in terms of specific numbers is that there's like an $890,000 cap per incident. So we could be talking about millions and millions of dollars.
Thank you, Delegate, for the question. So as I hinted in my initial comments, that fiscal is really based upon the bill as written. There are amendments that are forthcoming. I know one of them is the AG's amendment to no longer have them pursue any civil actions. And so also what this fiscal note doesn't consider are the existing resources already to use. So there's this presumption that these agencies are suddenly going to have to come with all this money, but the alternative is just to look at the existing resources that are already doing the work and simply just giving them a call. So I think the fiscal note is kind of, superfluous is not the right word, but it's making a lot of assumptions. And I think once we whittle down the details, we'll have a clearer understanding of how much it's going to cost. And honestly, it's going to cost a lot less than we think. I think a lot of the initial response is, oh my gosh, what are we going to do as state agencies or as counties? But when you already have these existing resources there, like these nonprofits that are willing to step in, that's when the fiscal is going to come down. So,
and I would just emphasize, in communities where they have taken a housing and services-based approach, they've seen jail nights go down significantly. They've seen ER visits go down significantly. And studies have shown it actually costs 2 to 3 times less to take the housing and services approach. So the fiscal note is projecting these costs, which probably are like some of them, the note about like the tort threat, there's no damages provision in the bill. So that's not even, like, that's making up a cost where there actually isn't one even in the bill. But it's not anticipating the massive savings that we're going to see. It costs $100 plus a night to keep somebody in jail overnight. A week in jail, and for homeless people who usually can't pay bail, they can sit in jail for weeks waiting for trial. And so they, a week of that person in jail could pay for a month of that person in an apartment. And then they're housed, they're safe, as opposed to coming out of that jail still with nowhere to go and with an arrest record, a conviction, fines and fees that are going to be a barrier to them getting out of housing. So the fiscal note does not anticipate the massive cost savings of taking a better approach.
Just quickly underscore the tremendous cost of criminalization, as Eric mentioned, and I would note that the bill does not require communities to make these other investments. It just says that if there's not sufficient resources, you shouldn't be criminalizing the people that are experiencing homelessness in your community because of it. Let's hope that people want to invest in housing and invest in effective outreach and support nonprofits that are doing this work, but this bill doesn't require them to do that. So I find the fiscal note a little spurious.
And just to go back one to the point that the Public Defender's Office made, most of those charges for disorderly or for trespass ended up being dropped. What was the cost in man hours of the police having to write all those tickets, go down to the courts, bring those people in, push them through the court system? If they had just stopped before they, wrote that ticket and said, do you have another place to go to? No. Okay, well then, I'm going to stop writing this ticket. That would save them, millions of dollars a year. So the fiscal note really doesn't anticipate a huge amount of cost savings just by having the bill in place.
Delegate Conaway.
Thank you, Mr. Chairman. Thank you, Madam President. I just want to be clear on last statement that was made in reference to trespass. Are you saying that law enforcement ask people, did they have somewhere else to go before they
remove them?
I guess I'm not aware that they did or not. No, that's a good point.
You shouldn't have said that, I don't think. So thank you very much for clarifying that. Thank you.
Thank you, Delegate.
Any other questions? Seeing none, thank you all very much.
Thank you.
We're going to go to those people in opposition now. Angelica Bailey Thupari, Mimi Schwartz, Bill Castelli, Sarah Sample. I don't think any of them are Sarah Sample is virtual. Okay, that's fine. Yes, we can hear you, but hang on. We'll hear from the people inside the room first, starting from my left now, because she got there first, and going to my right, then we'll go to Ms. Sample. So please, go ahead for 2 minutes.
Good afternoon, Mr. Chair, Madam Vice Chair, members of the committee. Angelica Bailey Thupari for the Maryland Municipal League. We are in respectful opposition of this bill at this point. Our members, to be frank, find it confusing, difficult to implement, and they are concerned about the potential increased costs. But we understand that there are amendments. We are analyzing them. We appreciate the sponsors' willingness to collaborate. We'll continue those conversations. In the meantime, we are opposed. Thank you.
My name is Mimi Schwartz, and speaking as a concerned citizen of Maryland, I urge an unfavorable report. This bill allows for homeless individuals to live in public spaces and ensures privacy for their belongings. That's chaotic for the rest of us, and I believe of no help to the homeless in the long run, because it normalizes homelessness instead of trying to fix it. I read a USA Today article saying that as homelessness increases in the country, more cities and states have passed laws making it illegal to live out of tents and cars or sleep in public spaces. But Maryland is intentionally making it legal, bringing action against towns when they try to manage or address homelessness in public places the way they think is best. This might have the effect of people coming from other states to live as homeless in Maryland. Yes, homelessness is an issue. Why don't we continue to let each community decide what's best for their residents, those with homes and without homes? That's part of the beauty of municipal governments. They get to decide. Some towns might want to help the homeless by working hard to fix the problem that typically lead to homelessness, like the lack of affordable housing, mental illness, domestic violence, and substance abuse. And they might want to work more with nonprofits. Please let communities in Maryland continue to handle things the way they think is best. Don't mandate what they must do. I ask for an unfavorable report.
Mr. Castelli.
Thank you, Mr. Chairman. Bill Castelli on behalf of the Maryland Realtors. We are also opposed to the legislation, but really only the section where it intersects with private property. Of the public spaces as defined in the bill would include private property. And so we don't think the language is very clear in terms of what the responsibility would be. And as an example, it mentions a courtyard, which could be many garden-style apartments. So if there is an encampment in a garden-style apartment, we're just not sure what the responsibility of the property manager is, the landlord, in terms of securing, personal property, what happens when tenants complain. So there's a lot of questions that we have in terms of what those responsibilities would be. We appreciate the sponsors' willingness to sit down, and we certainly plan to reach out to her to discuss these issues. Thank you.
Ms. Sample, please, for 2 minutes.
So thank you to the chair and members of the committee for having me today. My name is Sarah Sample. I'm here on behalf of the Maryland Association of Counties, and we are here in opposition to House Bill 487. I do want to start by saying that even though we are opposition as the bill was originally drafted, the sponsor has been incredibly open to working with us on this. So I would just go ahead and point to our major concerns in our written testimony, but they are broadly to do with the bill in its original form, and they are about some of the things you've already heard: the increased potential civil liability exposure, having a potential chilling effect on service delivery and intervention, mainly for our social worker teams, our human resource teams, and our public health officials. And so And that's when housing is available and doesn't necessarily meet the exact definition in the bill. I do have a copy of the amendments from the sponsor. I got those today, and we're still analyzing them and collecting some feedback from our jurisdictions. That way we know the exact extent to which they could be helpful in terms of addressing our concerns. But again, as you see, we are opposed on House Bill 47 as originally drafted, and we're going to keep that conversation open and get the feedback to the sponsor. Thank you.
Questions, Delegate Kaufman?
Yes, I have a question for the lady in the pink jacket. I'm sorry I didn't catch your name.
Mimi Schwartz.
Ms. Schwartz, my question is, in my count, you lamented the fact that this Delegate Mayor Kuhnor's bill would allow people to live in, homeless people to live in public spaces, right? And that's what I heard you say. So, but in my county, Montgomery County, the shelters often fill up at night, and so people are out of luck in terms of shelters. So my question to you is, if you don't like the current bill, where do you suggest homeless people live? Thank you.
I don't think there's too much of a problem with the typical person that's homeless getting arrested. I could be wrong. Why don't you leave it the way it is and not say, hands off, you can't do anything? And let's put our efforts towards figuring out what's making them homeless.
Thank you, Mr. Chair.
Delegate Conaway?
Thank you, Mr. Chairman. Thank you.
Coming in to testify, could you make a comment on trespass in a public park after dark?
Did I?
Any one of them.
I mean, I think the way the bill is drafted, that there wouldn't be an action for trespass in a public park. And it does define public spaces, not just as public spaces that are owned by local governments, but it also defines public spaces like courtyard, shopping centers, and other private spaces as well.
Thank you.
Thank you, Mr. Chair, and thank you, Delegate, for sponsoring the bill and the panel that's before us. I think it's Angelica, is that correct? Okay, and you're representing MML. I wanted to know, when you arrived at, or your municipalities arrived at the opposition to the bill, did you look at any best practices that are out there, meaning that in the city of Salisbury, they have the 24 tiny houses that they have in place, and it hasn't been too long in operation, but it has been able to house significant amount of individuals, and they have that wraparound services. So we can't ignore that this is real, that we have homelessness, and there's some paths to help correct it. But has that been discussed at the MML? And is there anybody interested, or any municipality interested in addressing another best practice?
Yes, absolutely, Delegate. Thank you so much for that question. We have looked at best practices. We have, as of this morning, 161 members. So that's quite a wide range, all different sizes, all different populations, all different kinds of demographics, and unique challenges spread across the state. So many have looked at best practices. All of our members are very invested in the housing crisis that the state of Maryland faces. We've worked closely with the Second Floor and DHCD on their housing packages this year and last year. Many of our members, like the city of Salisbury, have implemented some really exciting programs for their unhoused and housing instability populations that have been really successful, that they're really excited about. I won't waste your time now, but if anyone is interested, I have a whole write-up on them. We're very excited and very proud of our members. They are definitely invested in being a part of the solution to this crisis.
Okay, so we can address the issue. So there's hope through the 161 members to move in the direction of addressing the unhoused statewide?
Absolutely.
Okay, and would there be like a timetable of when you may see some progression there? You know, just a strategic plan maybe of at 5 years we'll have this X amount of best practices in place, et cetera.
We don't. That's It's an interesting idea. We do a lot of member education. We had a housing symposium in August, for example, where we had over 150 attendees, members, and actually representatives from the General Assembly attend and talk about, what our different towns and cities are doing that's been successful, that hasn't been, sharing resources, sharing stories, talking about potential legislation. So we have had that kind of conversation, but we haven't talked about putting together a best practices kind of document or resource for our members. But that's a really interesting idea. I can definitely take that back.
Okay, thank you. Thank you, Mr. Chair.
Thank you. Are there further questions for this panel? All right, seeing none, we thank you all very much, and that concludes the testimony on House Bill 487. Now, the judiciary has not yet arrived, so we're going to jump forward to Delegate Phillips' bills in the following order. House Bill 592, and then we need we need to let Ways and Means know on 625 that they may be coming up next now. But Delegate Phillips, if you'd like to begin on House Bill 592, and you gave me a list, didn't you?
I think of 592, yes. 592. I think all of our witnesses are virtual.
All of them. Ann Hansen, Cynthia Lewis, Paul Niestat, and Michael Young. They're getting there. They need a second. We'll work on that on this end, but if you want to go ahead and begin, give Kara a chance to figure it out.
Sure, Mr. Chair, in the interest of time. My first opportunity to be before my colleagues in Judiciary in 2025. Thank you. Chairman Clippinger, Vice Chair Bartlett, and members of the committee. Delegate Phillips, representing the 10th District, I'm here to request a favorable report on House Bill 592. This critical legislation seeks to add individuals under assisted outpatient treatment to Maryland's list of those prohibited from possessing firearms, a necessary step to safeguard both public safety and well-being of individuals receiving AO2. Maryland law currently prohibits firearm possession for individuals who have been involuntarily committed for inpatient psychiatric treatment, recognizing the heightened risk during acute mental health crises. However, this protection does not currently extend to individuals under AOT. Despite these individuals being under court-ordered psychiatric care due to severe mental illness and a demonstrated history of treatment noncompliance, these individuals have been legally determined to require ongoing intervention to manage their mental health effectively. Many people under AOT, including veterans struggling with PTSD, depression, or other service-related mental health conditions, are at a significantly increased risk of suicide. This is not just a mental issue, it is a public health crisis. Suicide prevention is one of the most urgent challenges we face today. In Maryland and across the nation, the majority of firearm-related deaths are suicides. Research consistently shows that restricting access to firearms for individuals in high-risk mental health situations dramatically reduces suicide rates. AOT programs are designed to ensure that individuals at risk receive the necessary care and support to stabilize their mental health. However, without corresponding firearm restrictions, the law leaves a dangerous loophole that can have a tragic consequence. HB 592 addresses this gap by providing temporary firearm restrictions for the duration of the AOT order. This measure gives individuals the critical time they need to stabilize, engage in meaningful treatment, and reach a point where they can safely possess a firearm once again, if appropriate. This legislation is about saving lives. It aligns with Maryland's best practices in suicide prevention and responsible firearm policy. It is not about stigmatizing mental illness. Rather, it's about acknowledging the realities of mental health crises and taking evidence-based steps to prevent preventable tragedies. We owe it to the most vulnerable among us, including those who we have bravely served in our country, to ensure they are protected during the most vulnerable moments. I request a favorable report on House Bill 592 and stand with us in taking a very positive step to protect our communities and save lives. Thank you.
All
All right, I think we figured out at least some of the people who are going to speak virtually. So we'll start with Ann Hansen. I think we're still looking for Cynthia Lewis. Can't find Cynthia Lewis. So we'll hear from Ms. Hansen, then Mr. Neistat, and Mr. Young. Ms. Hansen, please, for 2 minutes.
Hello, Chairman Clippinger, members of the committee. Thank you for allowing me the time to testify today. My name is Dr. Annette Hansen. I'm speaking on behalf of the Maryland and Washington Psychiatric Societies in favor of this bill. Last year, we supported the AOT law, but at the end of the process, they added in this amendment, which says this subtitle may not be construed to abridge or modify any civil right of the respondent. This could inadvertently be interpreted to mean that a dangerously mentally ill person could retain their right to own a legal weapon. We thought this bill would be appropriate to correct that oversight. It's important to keep in mind the definition of who would be eligible under the AOT law. It's restricted only to people with serious and persistent mental illness with a documented history of dangerousness to themselves or others. But in addition to that, they have to be so symptomatic that they're unable to meet the ordinary demands of everyday life without intensive treatment. This means they can't provide for their own food, clothing, housing, or medical needs. People this symptomatic are not going to be out looking for jobs, so the entry into NICS is irrelevant for this population. Baltimore City has had a pilot program for AOT for 4 years, and only 9 people have been placed under AOT orders in that pilot program. So this is not going to be applied willy-nilly. Now, the other issue is that, why don't we just use IRPO laws? Well, the problem with that is then you're going to have 2 separate processes running in parallel that are going to be desynchronized. It would require 2 petitions, 2 hearings, potentially 2 different judges, 2 orders that expire at different times, and that would not be the most effective way to do it. Having a single combined process is much more efficient and less burdensome for all concerned, to include the respondent. Okay? Now, even people with serious mental illness and severe disabilities who are potentially dangerous would not necessarily have their gun rights removed. So AOT allows a mediation agreement, so if they voluntarily agree to treatment, they would not be covered by this bill. And I'm available for any questions. Thank you.
Mr. Neistat, please.
Thank you, Delegate Clippinger, my delegate, and the committee. My name is Dr. Paul Neistat. I'm a psychiatrist and suicide researcher at Johns Hopkins, where I'm medical director of the Center for Suicide Prevention. I'm also chair of Maryland's Suicide Fatality Review Committee, but I'm here speaking on my own behalf and not on that of Hopkins or the state. I'm speaking in support of HB 592 to close the firearm access loophole in Maryland's new AOT bill. People who suffer from mental illness, severe mental illness, are not generally a risk to others. In fact, my patients are more likely to be a victim of a violent crime than the perpetrator. However, they're at extreme risk of self-harm if armed. Suicide rates in this country have been climbing. They're currently the highest that they have been since World War II. The majority of suicides in this country are completed by firearm. In fact, most gun deaths are suicides. Suicide attempts are an unfortunate symptom of mental illness, but fortunately, most suicide attempts are survived. Only about 8% of people who attempt suicide die. And the vast majority, 94% of attempt survivors, continue to survive and never die in subsequent attempts. This is because suicide can be impulsive, and if the impulse passes or the attempt is non-fatal, help can be sought, and those impulses often never return. However, if that person has access to a firearm, and so a firearm is used in the attempt, the chance of survival is very slim, and a survivable suicide attempt becomes a final deadly act. By assuring that those at highest risk do not have access to lethal means for suicide, we're saving lives. I want to point out, the amendment to the AOT bill was very well intentioned. The idea that anyone in AOT should not have their rights or privileges or licenses or certifications taken away because they're in AOT is a good idea. We don't want people losing their teaching licenses, fishing permits, real estate licenses, et cetera. But gun access is a different animal. By putting that amendment into the AOT bill, we shielded people who are at high risk from things like, as Dr. Henson mentioned, extreme risk protection orders, or from other aspects of Maryland law that would have prevented them from getting a gun. If they were a felon, if they had been involuntarily hospitalized for psychiatric illness. These are things that normally would have led to them not having gun access and being able to stay alive. But with this amendment, we sort of create a loophole that people in AOT are invulnerable to those sorts of laws, like extreme risk protection orders, and hence we put them at risk. So I'm in support of this bill.
We finished listening for the person from Fells Point. Mr. Young.
Thank you, Delegate, Committee. My name is Dr. Michael Young. I am a psychiatrist, medical director of a residential program in the Baltimore area. I'm a associate training director of one of the large residency training programs in the state, as well as an attending psychiatrist. I've worked in inpatient, outpatient, residential settings, as well as general medical settings. AOT is a less restrictive alternative to repeated inpatient hospitalizations for individuals with severe and persistent mental illnesses who are not adherent to their outpatient treatment. Restricting firearms, as Dr. Nestat shared, is incredibly important at preventing suicide in this population. Those with severe and psychotic and mood disorders have a highly increased risk of suicidal ideation and attempts. Access to firearms greatly increases the risk of dying from those suicide attempts. Individuals with psychotic illnesses, which are those that will be subjected to AOT, are at the highest risk of suicide attempts, even more at risk than those with depression. An argument opposing this bill is that firearms are already restricted for this patient population due to other mechanisms. While it's true that patients certified inpatient facilities are subject to an order for firearm restriction when they go to the involuntary hearing, it's important to realize that individuals frequently do not have a hearing with administrative law judges during their hospitalization because they're discharged from the hospital or converted to voluntary status before the hearing. Therefore, they would not have their guns automatically restricted. House Bill 592 will help assure that individuals under involuntary commitment, whether they're inpatient or under AOT, are restricted from owning firearms. When the individual is no longer subject to AOT, the firearm restriction no longer applies. This is not an infringement on the rights of individuals who no longer require AOT and can maintain safe firearm ownership. This provides a balance between individual and public safety with individual right to bear arms. Maryland was one of 3 states that did not have AOT until 2024. 39 states and District of Columbia have laws restricting firearm possession for patients committed to AOT. For the above reason, Maryland Psychiatric Society asks for a favorable report. Thank you.
All right, go to the Vice Chair first, then Delegate Eric Hand, then Delegate Kaufman. The Vice Chair.
Thank you, Mr. Chair. I just want to make sure I understand the process. And it sounds like, I can't see his name, but one of the gentlemen that were testifying just now said that there isn't a hearing. So is there an AOT, is there like a form and we would check the form? How would it work that this person would be prohibited other than the fact that they're in the list of individuals who are prohibited?
I'm not sure if that should go to Dr. Nestat.
Dr. Nestat, please.
Sure.
Okay.
Thank you. So I should point out that AOT, even though it was passed in this House last year, hasn't actually gone into effect yet. It won't until July, giving the counties time to get things ready. So there's a lot that hasn't worked out on the details of AOT, but based on how other situations like this are handled, like for instance, if someone's involuntarily hospitalized for mental illness and deemed to be dangerous and so put on the list, the judge that adjudicates that person fills out an extra form that checking a box essentially saying this person should be put on the NICS list. Then they're put on the NICS list, which is the federal database of people that have been deemed unable to get a firearm. I'll point out the NICS list is only accessible by federal firearms dealers. So it's not used in employment checks. It's not part of a background check or anything like that. Only federal firearms dealers can use it to check on the purchase of a gun. So they can't even use it if they're going to hire someone themselves, like to hire their own employee, a clerk in a gun shop. They can't run the NICS list on them. Only if that person tries to buy a gun. So that's how it gets to the NICS list. The NICS list is protected. It's only for the use of preventing firearm access, not like having a criminal record or something else that might get you in trouble with a job application, something like that. But yeah, that's how they would get on. Presumably there'll be a form for the judge to further sign, check a box, get on NICS.
Okay, thank you. Thank you, Delegate.
Delegate Eric here.
Thank you, Mr. Chair. The Vice Chair started my question process. I'm just really not familiar with the AOT process really at all. So I don't know if you can sort of walk us through. So let me just restate what I've heard and make sure I'm not hearing it wrong. So right now, if there's an involuntary situation, the person can be in hospital, a hearing is scheduled, but the person's often shifted over to AOT where they're then outpatient, and so the hearing gets canceled. Is that currently what's happening?
Dr. Hanson, would you like to respond to that?
Yes. No, we're talking about 2 separate issues. So if someone is involuntarily admitted to the hospital, oftentimes they're released from the hospital before a civil commitment hearing. That's a separate process. Under the AOT bill, the way it was amended and we supported, the respondent has the opportunity to participate in essentially a mediation hearing. So the psychiatrist does an evaluation, sets up a treatment plan, ensures that the resources are available, then presents that plan to the respondent who's given notice of a hearing, and they can meet together. And if the respondent voluntarily agrees to follow the treatment plan, then the case stops right there. There is no hearing, there is no order cut. So it's purely a voluntary agreement. And in those situations, even though the person is mentally ill and symptomatic, they retain their rights, including the permit that they're allowed to have weapons. So not even people who could be subject to an AOT order actually has their guns taken away.
Okay, and just help me a little bit. So what kind of things would be in this? So it would be like you need to stay on your medication? Is it like a certain period of time? I'm trying to understand how long could this drag on, you know, even if they say, what happens if they say no? So we automatically take their firearms. Is there a point in time where they could be eligible to get them back again?
Absolutely, and that's the nice thing about the way this bill is crafted. The AOT order can last up to 6 months.
Okay.
Okay, and at the expiration of that 6 months, then everything stops. You know, all the restrictions and mandates stop. And public safety already has statutory mechanisms for essentially a relief of disability. That's for both theoretically people under AOT or people who have been civilly committed and had their guns taken away. They can go through the statutory process to get a relief from disability.
Okay, that's very helpful. And so my last question, sorry to belabor this, but this is kind of complicated. Do we have any stats on how many Marylanders under AOT have committed suicide or have harmed another using a firearm?
So I'll turn to once again, our experts, but I will say this, once again, AOT is new.
Oh, right.
Right, and so it actually has not been implemented fully yet.
Okay.
And so I don't believe we have any stats that will refer to that. However, I did ask our subject matter experts to talk about persons who have harmed themselves when they're going through psychotic-related
other
episodes.
states, maybe?
Other states. So any comments on that?
I can take that.
Go ahead, doctor.
Suicide, you're asking how many people that might be eligible for AOT might die by suicide.
Right.
Reasonable question. So suicide rates in this country, as I mentioned before, are very high. In the general population, it's still only about 1% of people die by suicide. In populations with serious mental illness, as Dr. Young alluded to, it's much higher. So people that have major depressive disorder, about 5% will die by suicide, which is a lot. People with schizophrenia, which is probably the condition most likely to result in an AOT order. Studies show about 1 in 10 people who suffer from schizophrenia will die by suicide. And I'll point out that most suicides are by firearm in this country. By far, it's the most common cause of suicide, method used in suicide. More than half of people that do die by suicide use a firearm. Second to that would be hanging at only a quarter of people. So it's generally firearm. We know that people that are in treatment start to have much less of a risk of suicide as long as they have the insight to pursue treatment. But the AOT population, by definition, as Dr. Hansen pointed out, sort of don't have the insight into their illness to accept treatment. That's why they have to go through this process and have this essentially involuntary outpatient treatment. So it's very high. It's a very high number of lives we would be putting at risk if they have guns.
Okay, all right, I appreciate that. If you have any stats from other states where they have this similar process set up, I'd like to see, you know, are we really saving lives? I want to make sure that the juice is worth the squeeze. Are we really saving lives? I mean, I understand the theory behind it, and I've, you know, had a lot of personal experience with severe mental illness and firearms, and it's a nightmare. But I want to make sure that we're not putting something in place that's not actually going to benefit anybody, because it's not actually a problem on the ground. I can understand the theoretical problem certainly, but I want to make sure that we're not just taking away people's rights without a real clear benefit.
Understood, and I'll work with the subject matter experts to get those stats for you. Those stats probably will not be specific to AOT, once again, right? But they will be, we will provide more specific stats as it relates to persons going through psychotic episodes and their likelihood of potentially taking their own life. Is that fair?
Thank you, yeah, I appreciate it.
Yes, Delegate Phillips, can you hear me?
Yes.
The Maryland.
Hang on 1 second, because I think we're having a problem with the It's frozen.
There they go. I think they're coming back. No, we're frozen.
I know.
Everybody just hang on if you can still hear me. We have the, want to make sure that people can see Delegate Kaufman.
Yes, and
Hang on.
The Zoom is still frozen.
They're now talking to each other.
Yeah, they are cut off.
They can't hear us. So our audio is not going to them and thus probably not going out to the public, so we need to fix this.
Okay.
And we're on it. One moment, please.
Court's indulgence.
Court's indulgence.
See, you are a lawyer.
Delegate Kaufman has learned.
That's part of that legal education he's getting.
You can't go back to your desk, though. I didn't say that.
You all aren't calling her Lauren, but I can call her Lauren.
Oh, my.
Are you able to let them know that we're?
Okay, we can hear you.
Yeah,
They don't know we can hear.
so that's why I'm on.
Delegate Simpson now.
Delegate
I'm a little
Simpson.
straggler.
Oh, jeez.
Oh, boy.
My dog's at the right now. That's why I'm home, actually.
Oh, boy, you did.
Sick.
Yeah, well, I came home to get the husband stick instead of the
Oh, Lord.
188 in Minneapolis. I don't know that was very fair. Oh, they can hear us.
I'm getting some indication that some people can hear us on YouTube. They may not be able to. We're still trying to work this out there with us. IT is on their way. IT is heading over. Can we, do you want to just give a short recess? Do we just 10 minutes? All right, we're going to go to a recess till 3 o'clock. We're going to do a recess until 3 o'clock so that we can figure out what's going on here. Apologize for the delay, but we'll let people get up and stretch their legs for a second. We'll be back at 3 o'clock.
They're taking a 10-minute recess. I don't know if you were able to hear that. They'll be back at 3.
All right, we're going to try and restart. We're a couple minutes early, but we're going to try and restart because we need to get back on the road here. We've got a bit of a long day in front of us. Could we have the virtual testifiers? There's Mr. Young, Dr. Young. I think we may have lost Dr. Neistat, and we apologize for that, but we're hopefully not having too many technical difficulties. So if we see Dr. Neistat get back on the line, if we could have him join. But for now, let's go to Delegate Kaufman for a question, please.
Yes, and I have my laptop up because I want to quote the right thing. Delegate Phillips, I think it's a good bill. I'm a co-sponsor, but I do want to point out to you that the Disability Rights Maryland, which is the state's protection and advocacy system in our state, they are very opposed to your bill. And one of the things they say is that what you want to accomplish, and you're a lawyer, so you'll know this, not me, what you want to accomplish can already be accomplished through Maryland Annotated Code, Public Safety 5-133, parentheses B, parentheses 8. And they also say that your bill infringes on the civil rights of the disabled, so I wanted to give you a chance to respond to both of those points.
Sure. I think one of the things that we kind of looked at in terms of process to ensure that these things are addressed and to make it streamlined is the use of AOT. This does not, in my opinion, abridge civil rights. At the end of the day, we look at particularly firearms laws, and we determine who should and who should not have firearms. At a minimum, what we're doing is a temporary order, similar to a temporary order in a protective order case, right? We have methodologies for that as well. So this is not a permanent taking of anyone's firearms.
And what about my question regarding the section they cite of the annotated code, which they say automatically already accomplishes what you desire?
My sense is that it does not, but I'll have to go back and I'll look at that in more detail and give you a response.
All right, that's terrific, and you may want to meet with them.
I will be glad to meet with them. As a matter of fact, I think that they did reach out, but I think that was today, so we hadn't had an opportunity to respond to them. So thank you, my good friend.
I saw Dr. Neistat raise his hand, but if you want to be brief, can answer, that'd be fine. Then we'll go to Delegate Embry.
Just in terms of the process and not infringing on the rights of the disabled, which is obviously very important to us as physicians who treat people with psychiatric illness. The idea here is that currently in Maryland law, there are restrictions on firearm access for people that are adjudicated to have mental illness, for people that are involuntarily hospitalized, all these sorts of things. And you know, it's a risk-benefit analysis where you don't want to take away anybody's right. You don't want to involuntarily hospitalize anyone, taking away the right to freedom, but you do it in situations of life or death, when not doing so would result in death, generally by suicide. But there's also worries about danger to others. And so this is the give and take. It is in the law right now, but the amendment to AOT sort of created a loophole that made those laws not apply to those adjudicated to AOT. That's what we're trying to correct. So going back to how it was before the AOT law was passed in terms of restrictions on firearms for people who are at risk themselves or others.
All right. Delegate Embry now for her question.
Thank you, and thank you for the bill. I may be missing this in the bill, so I want to start with that. But as I read it, the bill doesn't legislate notice to the person if they do own a firearm that they no longer can have it, or a process for taking a gun from someone who has one. And I just wondered, I'm not saying it should or shouldn't, I just wondered what the thinking was on that.
So I'm going to refer to Dr. Neistat on that as well. And to be quite honest, that was a concern of mine. But this does not necessarily, it definitely addresses putting them on a prohibited persons list, and it notifies that they should not have a gun. We don't address how you take a gun out of someone's home. Dr. Neistat, any comment on that?
Sure. So unfortunately, that's not legislated for any of the categories where someone wouldn't be allowed to have a gun. It's just it's done at the point where that right might be lost. So for instance, if you're a felon, you can't have a firearm, as an example. But there's nothing legislated in the Maryland Code that says that and here's how you notify people when they're convicted of a crime. It's sort of handled on the judge's end. So similar to when someone's involuntarily hospitalized, which is the system that I'm most used to for gun removal, it's up to the judge that adjudicates them, the paperwork being filed to let people know they shouldn't have a gun. It's also when someone goes to purchase a gun and they fill out some forms that allows them to be checked against the background check system, the NICS system. Those forms do ask questions about eligibility. So if they went to buy a gun, there is no removal of guns in this proposal. So unlike the extreme risk protection order law, where someone, if they're petitioned because they risk themselves or others by the police or family members, and guns are not only forbidden from being bought, but they're also taken away from the person. That doesn't exist here. If they already have a gun, no one's going to come to their house and confiscate the gun, but they cannot possess the gun. The same way as if they were convicted of a crime and they got back to their house and there was a gun there, no one's coming to take the gun away, but they need to be informed that they cannot be owning a gun. And they need to turn that over to police or something like that. But it's not legislated.
There are differences, though. I mean, because a felon, there is a court proceeding. You're convicted, you're advised of rights, and that is typically a right. So the person is subject to being charged criminally if they go to their home and the gun is in the home. So I just raise the issue of something you might want to think about, because I don't think this is identical to the situation where a person is convicted. I think there are lots of ways that they are made aware that they could be charged.
Yeah, maybe it's more like when someone's involuntarily committed, where there's also sort of an administrative judge that handles it and handles that paperwork and handles that notification.
Thank you.
All right, that appears to be the questions in favor. We're now going to switch to the people testifying against 592, and thank you all for joining us today. Courtney Bergen is here. Natasha Dartigue, the Office of the Public Defender. I saw her. I don't see her now, but I'm guessing she's in the hallway, but we'll find out. Virtually, we're supposed to have Evelyn Burton, and she's here for informational testimonies, but she's not there. So please, Courtney Bergen, please, for 2 minutes.
Good afternoon, Chair Clippinger, members of the committee. My name is Courtney Bergen. I'm an attorney and Equal Justice Works Fellow at Disability Rights Maryland. I'm also a resident of District 43A. And I'm also a person living with what is often termed serious and persistent mental illness. And I know many of the physicians testifying on this bill said this wouldn't impair other rights. But I would caution you otherwise. And that is exactly why DRM is testifying in opposition to House Bill 592, we're not a gun rights organization, and we would never come out in support of gun rights, but we are a civil rights organization, and we are extremely concerned about disability rights. And as someone who is currently in NICS, because of a voluntary hospitalization, I want to let you know that this does impact other rights. So this came up when I was trying to get a bar license, and the humiliation I went through during that process made me suicidal again. And I know the physicians on this bill said this, people with serious mental illness aren't going to be the people looking for a job. But I'm eligible for AOT based on the criteria in the law at this moment. And I am someone who works and loves my job, and I don't want that to change. I also was told 5 years ago I would never work. So things change, people get better. That's why we give them treatment. So if we're gonna do something, this is a lifelong impairment. Once you're in NICS, yes, you can ask to be removed from it, but the secondary concerns that Disability Rights Maryland is concerned about don't get removed. This can impact security clearances for people who are federal employees. And yes, there are federal employees who've been involuntarily committed. This can impact ability to get a medical license for people in all aspects of medical careers. So this has very serious implications that we would really like you to consider. And when you're discussing this bill, and we would ask that you do something more tailored, such as a separate finding that someone is both eligible for AOT and dangerous, that doesn't include entering them into NICS and provide safe storage. Thank you.
Delegate Erican.
Thank you, Mr. Chair. I just wanted to thank you for coming and candidly sharing what has got to be a really difficult story.
Thank you.
Further questions for this panel? Seeing none, thank you very much. That concludes the testimony on House Bill 592. I'm going to go now to House Bill 625. Again, this is Delegate Phillips. Call up Ida Williams, Jane Sternecki, Stephen Leitis, Megan Good, Aisha Sneed. If we need to pull up another chair, we can do that. We are supposed to be joined by friends from the Ways and Means Committee, and I see Delegate Merrick North coming back. I'm not sure who else is here. Maybe they're in the lobby. But we will figure that out. We're looking for Ways and Means now. So I see the one.
Got the one.
Saw the one. Okay, so several of the people you listed, I think, are virtual, so that's fine.
That's
so we'll
correct.
start working, putting them on the screen here. Delegate Phillips for 3 minutes, please.
Mr. Chair, Madam Vice Chair, members of the committee, my name is Scott Phillips, delegate from the 10th Legislative District, and I'm before you to request a favorable report on House Bill 625, Transfer on Death Deeds. So why are we discussing deeds? Estate planning is a critical aspect of financial preparedness, yet significant portions of Americans have not formalized their end-of-life plans. As of 2025, only 24% of Americans have a will. For most people, your home is your largest asset in your estate. Unlike insurance, where you designate a beneficiary, or your bank account, where you designate a pay on death, we can't do that with real estate. Our system today is geared to wealthier individuals who are more inclined to engage in estate planning. About 77% of people with a household net worth income exceeding $1 million have an estate plan. On the other hand, 36% of those with net worth of below $1 million have an estate plan. So failure to plan for the transfer of real estate at death is a major contributor to all kinds of things: tax sales, foreclosures, and related property losses. So why a transfer on death deed, also known as a TOD? This tool provides a property owner with a simple, straightforward option to pass on their homes and other real property to their loved ones or beneficiaries without the need for a will and without probate. This simple form is already in use in the District of Columbia, Virginia, and 30 other jurisdictions. Unlike an estate plan, which can cost thousands of dollars, a TOD is a low-cost method for transferring title of one's property to their loved ones. So why haven't we passed this legislation in Maryland? You will hear that Maryland already has a mechanism for effectuating the transfer on at death, a life estate deed. This is true, but with this tool, it also requires precise crafting by an attorney. The deed must be prepared under the supervision of an attorney. You will hear from the judiciary, who suggests that this will create challenges with the recording offices and the court and will be required to provide legal advice. This bill does not require legal advice. The court today provides guidance for filling out things like divorces pro se. The bill would ask the court to do the same thing here. I know our judiciary, clerk's office, and title company community are as capable as Virginia, D.C., and 30 additional states that have adopted this tool. I look forward to working with all of those who are concerned to address their concerns while implementing a tool that makes the transfer of estate at death more accessible to 77% of our community. For these reasons, I ask for a favorable report on House Bill 625.
Good afternoon, Chairman Clippinger, Vice Chair Bartlett, and members of the committee. It's a pleasure to be here. My name is Steve Leitis. I am a member. I'm here as a member and the chair of the Maryland Commission on Uniform State Laws to testify in favor of House Bill 625 with amendments. Technical amendments will be addressed by another witness who's appearing virtually. You'll hear from her shortly. And as you just heard Delegate Phillips tell you, for most Marylanders, the largest asset they have is their home. House Bill 625 will make it easier for Marylanders to handle estate planning issues that arise with real property and in an amazing number of cases. The Uniform Law Commission approved a similar act to 625 called the Uniform Real Property Transfer on Death Act in 2009. The Uniform Act and substantially similar laws have already been enacted in nearly 36 states. All of them are working well. We expect that real property transfer on death laws such as this will be enacted in every state in the country in the near future because of the great value these laws give to citizens. The Transfer on Death Act was created through the customary and nonpartisan inclusive process that the ULC uses, the Uniform Law Commission, which started with a one-year study period around 2006, followed 2 years of drafting in the drafting committee, and finally was approved by the ULC for recommendation to the states in 2009. And as you see, it's having great success nationwide. A great deal of work contributed to the Uniform Act, and it's helpful to understand the ULC's role in drafting the uniform law and as context for the comments you will hear next from another witness, Jane Sternecki. Maryland and every other state, the District of Columbia, Puerto Rico, and the U.S. Virgin Islands send delegations to the Uniform Law Commission. There are over 350 volunteer commissioners nationwide. Since 2006, I've been one of those. All commissioners are attorneys, judges, law professors, and legislators. Commissioners are from every part of the political spectrum, but do not bring politics to their efforts. The goal is better laws for our citizens. Thank you for the time, and I'd be happy to answer questions about my comments.
Yep, we'd like to go to Mr. Sternecki, Mr. Chair.
Yes, Mr. Sternecki, please, and then Mr. Donaldson, and then Ms. Sneed. So Ms. Sternecki for 2 minutes.
Thank you, Chair. Good afternoon. My name is Jane Sternecki, and I'm Legislative Counsel for the Uniform Law Commission. I'm testifying today in support of House Bill 625, creating transfer on death deeds in Maryland. HB 625 is based off of a Uniform Act drafted by the ULC. We anticipate that Delegate Phillips will be making amendments to this bill to prevent a fiduciary from unilaterally revoking a TOD deed, and to allow TOD deeds to be revoked only through the recording of a revocation form contained within the bill or through other express revocation. Allowing real property to be transferred to a beneficiary with a TOD deed will provide significant predictability for property owners with smaller estates whose home is their largest asset. Maryland already allows assets such as IRAs, bank accounts, and securities to be transferred to a beneficiary at death and outside of the probate process. Under current law, Marylanders with simple estates may name a family member as a joint tenant in order to ensure this beneficiary receives the property upon the transferor's death. This is a dangerous strategy because it exposes the property to the joint tenant's creditors and allows the joint tenant to control the property during the transferor's life. Enacting this bill will ensure that Marylanders have a safe alternative to maintain control of their property while they live, while still transferring the property to their designated beneficiary upon their death. TOD deeds have been used to safely transfer property in the 30 states and 2 jurisdictions that allow them, and we have not seen an increase in the incidence of fraud in any of those states. Regarding general concerns about TOD deeds eliminating the need for other planning mechanisms or the need for probate altogether, please note that TOD deeds are not for everyone. Rather, they are merely a tool in the toolbox for people with simple estates who have recorded beneficiary designations for their other assets and whose estate would be forced into the probate process without the option of a TOD deed. Marylanders should have the ability to plan for the orderly distribution of their estate to their designated beneficiary without the unnecessary expense and delay associated with probate. I encourage you to support this bill, and I welcome any questions. Thank you.
Mr. Donaldson, please.
Good afternoon. My name is Christopher Donaldson, and I am a student at Howard University School of Law. I am a student attorney in our estate planning and heirs property clinic, which provides free legal services to Maryland residents and DC residents. Today, I am speaking in support of brighter futures for Maryland families, and I fully support HB 625 with the noted amendments. In our clinic, we believe in the mantra that estate planning is for everyone. However, we have found that everyday Marylanders, in contrast to the bourgeoisie elite, do not have an efficient and equitable way to transfer their homes upon their deaths. Enacting HB 625 solves this problem. Enacting HB 625 would allow Marylanders who own property at their death to transfer their interest in real property to their designated beneficiaries using a simple form. This form, a transfer on death deed, is a standardized form that allows Marylanders to self-sufficiently use and efficiently and effectively pass on their real property to their loved ones, fortifying their legacies. This form document is already available to the citizens of over 30 states and counting. There is no persuasive reason to deny Marylanders the opportunity to have a cost-effective and time-effective instrument by which they can perform the basic act of leaving their homes to the preferred beneficiaries without undue complexity. HB 625's transfer on death deed is an easy-to-understand and an easy-to-complete form that will provide Marylanders with self-autonomous, revocable way to ensure the legacies of their homes while they are alive. To connect theory to reality, DC is one of the jurisdictions that utilizes the transfer on death deed. For our clinic clients in DC, the transfer on death deed is often the most popular choice for our clients whose homes constitute the centerpiece of their estate. We believe Marylanders should also be availed of this instrument. Thank you for your time.
And if we could, Mr. Chair, could we go to Ms. Ida Williams?
That's fine. Ms. Williams? Ms. Williams? We don't have her.
We don't have Ms. Williams.
We don't have her. Could we go to Ms. Sneed?
That's fine.
Ms. Sneed, please, for 2 minutes.
Thank you. Chair Clippinger and distinguished members of the committee, thank you for the opportunity to testify in support of House Bill 625. My name is Aisha Sneed, and I serve as the Advanced Planning Coordinator at the Maryland Volunteer Lawyer Service. At MVLS, through our Advanced Planning and My Home, My Deed, My Legacy projects, we work with families facing significant barriers to keeping their homes, especially the high costs of probate. For many low-income Baltimoreans, their home is their most valuable and often only asset. Without affordable estate planning tools, these homes are vulnerable to loss, contributing to Baltimore's more than 15,000 vacant properties, many which are tied to unresolved heirs property issues. HB 625, with sponsor amendments, introduces a simple, accessible, and affordable solution: the transfer on death deed. This tool allows homeowners to legally transfer property directly to their heirs without the financial and legal hurdles of probate. While the amendments that we have discussed with the sponsors seek to prevent fraud and elder abuse, it's a powerful way to preserve generational wealth and keep families in their homes. Research we conducted with the SOS Fund and Baltimore Neighborhood Indicators Alliance found that between 2009 and 2019, over 3,300 homes in Baltimore faced potential heirs property issues, a number that continues to grow unresolved with each generation. HB 625, the creation of transfer on death deeds, is a vital step toward preventing housing loss, curbing property vacancies while tackling the systemic inequities that have long impacted historically disinvested communities. we strongly urge a favorable report on this bill to help protect homes, preserve generational wealth, and strengthen Maryland's neighborhoods. Thank you for your time and thoughtful consideration.
Megan Good. Megan Good for 2 minutes, please.
Good afternoon, members of the committee. My name is Megan Good. I'm a tangled title attorney with the Maryland Volunteer Lawyers Service, an organization that provides free civil legal services to individuals throughout Maryland. My team works to help low-income families preserve and pass on their family home. And I'm asking for your support with revisions of House Bill 625 because the transfer on death deed is an important tool for low-income homeowners to pass legal title to their home. Right now, thousands of homeowners across Maryland have a tangled title because their name is not on the deed. Tangled titles heighten the risk of housing loss because many programs designed to support low-income homeowners are only accessible to individuals whose names are on the deed. Tangled titles are preventable, and the transfer on death deed can help by filling an unmet need for many homeowners since it functions differently from a will and it's more accessible for homeowners who cannot afford an attorney. Although new to Maryland, it's not a new concept. 32 jurisdictions provide for transfer on death deeds, and we strongly believe Maryland should join the list. I'm seeking a revision to this bill that makes the deed available to co-owners in addition to sole property owners. This change will address many of the concerns opponents expressed the last time this bill was introduced. The bill's current limitation to only sole owners is contrary to the uniform version, and it will create barriers for property owners who should be able to utilize this deed. For example, when co-owners hold property as tenants in common, an individual co-owner's share will not pass automatically to other co-owners when one dies. When a co-owner's property share passes through intestacy, the title to the property quickly fractures. Allowing co-owners to use a transfer on death deed is essential for this legislation to meet its stated objectives. The revision should also address the effectiveness of a transfer on death deed when property is held by joint tenants with rights of survivorship. It's our position that transfer on death deed should control, and my written testimony provides additional support. The transfer on death deed is a unique and valuable tool that can help reduce the volume of clouded property titles throughout the state. For these reasons, we support with revisions House Bill 625. Thank you.
Okay. I believe we, just double checking, did we hear from Mr. Donaldson? Mm-hmm. Yes, okay, I'm just checking. I see one more person, I think, that was going to testify in favor. Nika Namdi?
Yes,
and we'll
thank you.
Go ahead for 2 minutes, that's fine.
All right, perfect. Good afternoon, my name is Nika Namdi. I'm the Executive Director of the SOS Fund. I also am the founder and Chief Operating Officer of Fight Like Be More, and we support this bill and encourage a favorable report on this bill with amendments. For all of the reasons, we support the transfer on death deeds for all of the reasons that my colleagues have mentioned. In fact, we just received data back on a heirs property project that we've run for Baltimore City, and we've identified 7,700 or more properties that currently are heirs property and have a tangled title. And with the passage of this law for transfer on death deeds, many of those properties would not be put into legal limbo as a result of having a clouded title. One of the there are three things that we think should be amended about the bill. One, we think that homeowners should receive notifications of transfer on death filings in order to thwart fraud. We also think with fiduciary powers should be limited, like powers of attorney should be limited from filing or changing transfer on death deeds. And then the final amendment we would like to see is just like with a life estate deed, the property tax record is amended to show a life deed designation next to the property owner's name. We'd like to see a TOD designation next to the property owner's name. And again, we do encourage the Judiciary Committee to pass this bill favorably, to pass a favorable report on this bill. Thank you.
That should be all the people who signed up in favor of the bill or favorable with amendments. So now we'll take some questions. Went a little longer than we usually did, but it was easier because some of them were virtual. Delegate Cardin for a question.
Thank you, Mr.
Thank you very much, Delegate Phillips, for bringing the bill, and I understand the intent, and it's hopefully coming to our subcommittee, we'll see. But so first of all, let me just understand. So one of the issues you have is that the cost of probate sometimes just it becomes impossible for many of these people to be able to pay for a will and then pay the taxes?
No. So if you think about just the cost of estate planning in and of itself, let's go back to the very beginning. A TOD deed actually becomes an estate planning tool because I can determine well before my death, just like my insurance policy, just like my bank account, who is going to take title to my home once I pass. Right? So that's the concept.
Okay, but I mean, you can do that through the instrument of a will if you wanted to.
You can do, now, when I do it through the instrument of a will, what do I have to do? I now have to go to probate.
Right.
I don't go to probate on my life insurance. I don't go to probate on my bank account.
I understand.
I don't go to probate necessarily on my vehicle.
Right.
So,
I
and
understand.
particularly for those individuals who, often families, if I go to probate generally, I know people will walk you through it, often then I've got to get some type of legal advice, assistance. It's not immediate. I don't get to stay in that home. I've got to go through a process. This basically eliminates that process.
Okay. Well, we can argue that. I think you can stay in the home during the course of that. You can get the permission from the court. That's relatively easy.
But then what do I have to do? You said you can, but then I have to get permission where?
Through the courts, through the probate process, right?
Correct.
Okay. I believe that it says that you avoid transfer tax. Is that correct?
That's no different than a life estate deed.
Okay.
I don't do transfer tax today with a life estate deed, particularly with family members.
Okay. The fiscal note writer mentions that that ESTAT is going to potentially lose money in taxes because of this. We maybe need to talk.
I'm not sure about money in taxes. There may be some transfer taxes associated with it. But once again, I can do the same thing with the life estate deed, but with this, I don't need an attorney. If I do the life estate deed, right, we're trying to make this simpler for people who don't necessarily have the same level of access to legal services, have the same wherewithal, financial wherewithal, to do this whole estate planning process. So it simplifies the process, and it gives what I would call the common man the opportunity to do the same thing that I might do in my professional life for my clients.
Two more quick questions. First is, if you happen to have written a will and bequeathed your house in the will, and you also did a TOD,
The TOD takes precedence.
But then there's going to probably be some sort of litigation, possibly be litigation if those two.
That's possible, but there's always a possibility for litigation in an estate
The last witness
disagreement.
had spoken about some elder care abuse issues.
Correct.
It would seem to me that with less court oversight, and I remember we passed the SAFE Act about 5 years ago, creating a new cause of action. Like, we just need to make sure that we're not giving people an easy way to try to acquire.
Yeah, I believe, if I could, and I hear your question, Jane, if Jane could speak on that, because I believe in the Uniform Commission, there's some protections for that. Is that correct, Ms. Dunnicky?
Yeah, can you restate the question again? I didn't quite catch it.
I worry that with elder abuse, that it makes it easier for savvy people to be able to convince a person to give them the TOD. And I mean, I heard everybody said statistically that hasn't demonstrated, but I would be very concerned about making it easier for people to do this.
Thanks for that question, Delegate. So I think it's our position that we aren't creating any new avenues for fraud, right? And there are certainly ways for folks to already engage in fraudulent and deceptive behavior, and this isn't creating anything new. One very notable thing about a TOD deed is that it is revocable up to the time of the person's death. And so if there is fraud that's noticed, we can undo this and act like it was never recorded at all. And that is a very significant improvement from something like a joint tenancy that's going to have an immediate and very significant effect. So it's not a new vector for fraud, and that revocability really is a very serious protection against concerns about fraud. I will note also that the AARP National Office has endorsed this act, and they're of course in the business of protecting seniors and making sure that they're not victims of fraud.
Thank you.
All right, here's what we're going to do. We're going to go around, starting with Delegate Boucher, then Congolo, then this person who came from Ways and Means, don't know what they're doing here, then Delegate Conway, and I'm sorry, Delegate Sample Hughes and Delegate Conway. Please, sir, go ahead. Delegate Boucher.
Thank you, Chairman, and thank you, Delegate, for bringing this bill forward. I was curious about the joint ownership. It was referenced earlier, and I was getting a little bit confused how it was being explained. So if someone has joint ownership on a property, they could do this individually on their half of the equity or the value of the house? Does that create any conflict? How does that work?
I'm going to turn to Mr. Stenick. I want to quote that wrong.
Thank you for that question, Delegate. So actually, as the bill is currently drafted, it only allows sole owners to record a TOD deed. Ms. Good's suggestion, which is in line with the Uniform Act, is to expand it to joint tenants. And the way that would work is that, let's say my husband and I record a TOD deed. That TOD deed will have no effect until after one of us dies. So it's functionally allowing a couple to do the estate planning ahead of time, but it's still going to have the same effect as if a sole owner had recorded it, because it doesn't take any effect until after that second owner dies.
So I have ownership in real estate that's someone who's not my spouse. So this wouldn't be applicable to me in my situation?
That's right. So as currently drafted, you or that other person who has ownership could record a TOD deed after one of you dies. And if the amendments that Ms. Good is suggesting, which would be in line with the Uniform Act, go through, you and that joint owner, just like two spouses, could record a TOD deed with both of you as the transferors. But again, it wouldn't take effect until one of you dies.
But you couldn't do it individually. It'd have to be in partnership.
That's right. Yeah, if it's owned as joint owners, you would both have to record.
Thank you very much for the clarification.
Delegate Congolo.
Thank you, Mr. Chair. Delegate Congolo, and thank you for this legislation. I actually feel very relieved because, you know, just thinking about the next generation, and I'm like, I was able to go on the MVA's website, and my kids, the cars are taken care of, bank accounts, just like you said, but now where do we stand with the properties? And looking at how much it costs to put together an irrevocable trust, or, you know, like you said, the will and the probate, that can cost into the thousands. And we have a lot of heir properties. I think one of the witnesses mentioned it. And these heir properties are costing us money because they're not able to do renovations. They're not able to maintain the upkeep, or, you know, do a refinance, take money out, equity, sell the property even. So this could potentially, you know, benefit all of us in our communities, you know, if this were to pass. My only question or maybe concern is, are there any mechanisms in place to prevent fraud? I know that someone mentioned there haven't been any issues, but just, you know, just wondering if there are any mechanisms in place for that.
So actually, and I think Ms. Aniki said it well, the same mechanisms that would be in place to prevent someone from defrauding you of your insurance or your vehicles or anything else are in place, right? Person has to be of sound mind in order to execute the document. We do not allow a power of attorney or anyone who is not court appointed to exercise this document.
Thank you.
Gentleman from Ways and Means, Delegate Harburger. Delegate Simpson's desk.
Yes, thank you, and appreciate you having us. Great bill. I just want to share an anecdote with you as it relates to sort of this elderly abuse and whatnot, and what would be the solution with this. So, you know, we had a situation where a grandparent passed away, and just prior to that, we had some bad actor relatives that kind of showed up and manipulated the will, kind of at the twilight hour there. So my question is, what happens when you have this TOD and then you have a direct conflict, for say, with a will that might have been executed under duress, or when someone was not of sound mind? I'm hearing more and more of these examples happening as time goes on. So what does that look like?
So first, the TOD supersedes a will.
Okay.
Generally, you're going to be looking at a TOD, which is not generally. The TOD would have to be completed and filed, right, prior to death.
Okay.
One of the challenges that often happens with wills is those wills may be completed near the time of death, potentially family influences because now we're at the end of life.
Yep.
And it's not even filed, right? So then the will is presented after death.
Yep.
At a minimum, this has to be done before death.
Okay. All right. Thanks for answering the question.
Delegate Sample Hughes.
Thank you, Mr. Chair. Thank you, Delegate. Just a quick question. I just want to understand. So with this bill, you would not have to pay transfer tax or recordation tax?
That is correct. And it's the same thing, once again, you may have to pay recordation tax. It would be dependent upon how it's implemented, but you would not pay transfer tax. Once again, we have an existing tool, a life estate deed. When you do a life estate deed, you do not pay transfer tax because there's no transfer between, if it's a relative, there's no transfer with a life estate deed between related parties.
Okay. And this has nothing to do with the inheritance tax as well?
Has nothing to do with inheritance tax.
Okay. Are you in favor of it? Getting rid of
I'm not going to comment on that. When the time comes for you to vote, you'll
Just
see.
messing with you. Thank you, Mr. Chair.
Vice Chair, last question.
Thank you, Mr. Chair, and thank you, Delegate. I'm always asking, whenever I think of TOD deeds, what is the difference between life estate and this? But now I'm asking a different question because you all have answered that one. What happens in the event of a divorce if there is a TOD deed?
So in the event of a divorce, if there's a TOD deed, I'll ask Mr.
And I didn't say that obviously there was a joint,
a joint tenancy.
Yeah.
Or tenancy by entireties.
But I mean, we have a joint TOD deed. That's what I meant.
Right.
Yeah.
So I'll let Ms. Dunning, but in my mind, I mean, what would end up happening is you probably end up having to revoke the TOD.
Okay.
But you'd have to take an affirmative action. What does that look like from a Uniform Law Committee perspective?
Yeah, thank you, Delegate. I think that's right. That ideally what you would do is if you had recorded it jointly and then the property is no longer owned jointly, whoever has the property, whoever ends up with the property at the end of the divorce would need to re-record a TOD deed that effectively states their wishes.
Great. Thank you.
All right, seeing no further questions for this panel, we thank you all very much, virtually and in person. I see one person seeking to testify in opposition, and that's Dawn Lindsay, and she is virtual. And Ms. Lindsay is joining us virtually, and we're ready for you for 2 minutes, please.
Chairman Clippinger.
Oh, I'm sorry, Jeffrey Thompson, please. Yes, that's right. Thank you. I apologize, it was on the next page. We'll hear from Ms. Lindsay first, or if I got that right. Yes, Ms. Lindsay. All right, thank you.
Yes. Hi.
Go ahead for 2 minutes.
Hi, my name is Dawn Lindsay, the Clerk of Court in Allegheny County. I'm providing this testimony in opposition to House Bill 6. Okay, sorry. My name is Dawn Lindsay, the Clerk of Court for Allegheny County. I'm providing this testimony in opposition to House Bill 625 on behalf of the Maryland Circuit Court Clerks Association. Our Clerks Association submitted an unfavorable report in 2023 with the same bill was submitted as House Bill 1270 and House Bill 986 in previous years because we had major concerns then and those concerns still exist. For one thing to clarify, you do not need an attorney in Maryland to submit a deed. You absolutely do not need one, has been stated here earlier. Another issue is the fact that The clerk's office is going to have no idea when a property is transferred. If the transfer to death goes through to the beneficiary, we will receive no notification. There's nothing in the legislation proposed to provide that to us. In addition, the big problem is there's no notification required to the beneficiary that they're going to inherit this property. So they may be assuming a mortgage, tax bill, and not have a clue until several months later when somebody tracks them down to let them know they now own this property. In addition, in the form itself proposed by the legislation, it says on page 22, line 1, the instructions say, do I need to tell the beneficiaries about the transfer of death deed? It says no, but I recommend secrecy can cause later complications and might make it easier for others to commit fraud. This is our exact concern that we have, is that it's going to open the door for a lot of fraud. No one, including the beneficiary, the State Department of Assessment and Taxation, or the clerk's office will know there's a new owner. The opportunity is very fraud for this bill. Now is not the time to make it even easier for criminals to use the transfer of death forms to commit illegal transfers. It has been stated that this is a simple document, which it is, and that's the problem. Property transfers are not a simple procedure. For instance, the legislation does not require on the form that we receive a library folio for the piece of property that's being transferred. In closing, we see the good intention of the proposed legislation has with this bill. However, we've experienced firsthand how a poorly executed deed can not only cause a financial burden, but be extremely stressful for the parties to clear up. We suggest that the Register of Wills would be a better location to record a transfer and death deed than the clerk's office.
Thank you very much. Mr. Thompson, please.
Thank you. I'm Jeffrey Thompson, Mr. Chair, Madam Vice Chair, and members of the committees. I'm here on behalf of the Maryland Land Title Association. And the Maryland Land Title Association is a professional organization that's working on behalf of the title industry providers and consumers. It's comprised of agents, attorneys, abstractors, and underwriters, of which I am one. We are seeking an unfavorable determination. And I'd like to thank Delegate Phillips, as well as his Chief of Staff, Vanessa Brooks, for meeting and talking to me for over 2 hours. My children will tell you that, they deserve medals for that. But about the possible alternatives. And one thing that you did not hear from the witnesses that were testifying in favor of this is that Maryland already has exactly what they're telling you you need. We have a life estate with powers deed. And if you wanted to pull your phones out, because everybody has a phone, and you went into your Google search and you filled in the words, life estate with powers form, you would have a plethora of online information, as well as a company that is willing for $60 to work you through the process of creating a life estate with powers deed. And a life estate with powers deed means that you can do anything you want with your property. And unlike what was said, if you have a life estate with powers deed, there is no way that a judgment creditor can attach the property, because a life estate with powers means that the life tenant has no interest until of death. This is an excellent vehicle that has been proposed by Delegate Phillips. It is unfortunately the wrong way, and it's significant that the Maryland Land Title Association, the Maryland State Bar Association Real Property Section, and the Clerk's Office, the three entities that deal with real property, are all in opposition. I ask that you return an unfavorable recommendation, and I am available to bore you to tears about real estate in not only Maryland, but DC and Virginia.
Does anyone wish to ask questions and be bored? Delegate Tolles. He said, that's what he said. Delegate Tolles.
Thank you, Mr. Chair. Can you explain to me your process that you take now, the normal process, that you all go through when someone wants to,
Yes.
say, deal with someone who passes away to have a house and they have heirs? What's your process for that?
Right now, if you have someone who has heirs and nothing has been done, then by law, the property.
Say they have a will.
Yeah, no will, nothing.
No, I'm saying if they have a will.
If they had a will, even
what's your
if they had a
process
will,
as
it's a little bit easier.
I'm sorry, let me back up. I'm sorry, Mr. Chair. If they have a will, what's your process? And I have two questions. The first question is, if it's okay, Mr. Chair. The first question is, I'm gonna rephrase it. They have an heir, they have a will. What is your process? You indicated that you are an underwriter. What is your current process for dealing with that property?
And when I said underwriter, what I actually do is I am the underwriting counsel for a title insurer. It is my job to determine whether or not we will issue title insurance, without which no lender is going to loan money in order for people to buy a house. So it's my unfortunate job, quite often with deeds that are hand-drawn or form deeds, to have to tell people that we can't insure because they've been prepared improperly.
I'm not speaking for insurance. I'm saying you have different underwriters.
If there is a will, each title insurer has their own underwriting counsel who makes those determinations. But if there is a will, then by law in Maryland, the personal representative of the estate becomes the owner of the property. And it becomes the obligation of the PR to transfer the property.
Correct.
A way around the estate right now is a life estate. And a life estate says that I'm going to reserve the right to live in the property during my life. Once I die, the property becomes yours.
My question to you was,
I'm sorry.
What is your process if you have a will and heir as someone who's an underwriter? Basically, do you make that process smooth for individuals? What is your process for doing that, your current process?
My current process is to determine if an individual is named in a will.
Right.
Whether or not the personal representative has been appointed and whether that personal representative has conveyed the property by way of a deed.
Use your microphone for me, yeah.
I'm sorry.
That's okay.
My process is to determine whether or not an estate has been appropriately opened, whether the personal representative has been appointed, and whether that personal representative has transferred the property by a deed.
And what is, I guess, that process that you take, all that process is done, what is the time frame that you all do? And I'm asking these questions because I do think even at that stage that you're at, it is a long, drawn-out process that individuals can go through. So a bill like this can make it a little bit smoother for someone that's trying to deal with estate issues. Would you not agree with that?
I respectfully would disagree. If there is a deed that has been where the deed creates a life estate with powers of alienation, then upon the death of the individual that created the life estate deed with powers of alienation, the remaindermen or the people named in the deed automatically become the owners of the property, just like the transfer on death deed.
Okay, yeah. So I don't think that you all make the process as smooth as it needs to be. I think you all are adversarial. And so I think a bill like this, not you, the titles association and the underwriter. So I think a process like this can help individuals that have be able to do this form and make it a much smoother process as they go through this estate, as they go through, the full estate process. When you do have the personal representatives, like the delegate indicated, when you have a checking account or a car or something, you just fill out a form. Like MVA, you fill out a form that can be done, and it's a quick transfer. So I will stop there and ask my next question, if it's okay, Mr. Chair.
Yes.
Thank you.
I hear a group of people wearing red robes are crossing the street, so. Shakespeare, brevity is the soul's wits.
Okay, all right.
All right.
Thank you. We've been waiting for them all day. I'm sure they can wait 4 more seconds. But okay, I'm sorry. It's got a lot of stuff going on in my county, so I'm a little agitated today, so I apologize.
It's
about to be a divorce court here.
We're gonna need a divorce court. I know, thank you. How many, this is for the clerk, Madam Clerk, how many life estate deeds are filed without an attorney?
Dawn, that would be for you.
Madam Clerk. We have a tech.
You're on mute.
I'm mute. You on mute, ma'am.
There you go.
Okay. Do you need me to ask the question?
Anymore, we're seeing that increase all the time. Anymore, we're seeing that percentage go up all the time where people are filing all their own documents without the use. I'm not on.
Yeah.
I took it off mute. You hear me now?
Just keep going. I'm sorry. Just keep going.
No, I heard you. Sorry, there's a huge delay in what I'm saying.
YouTube link, that's why there's a delay. So she hears everything you say.
I would estimate roughly for our county, I'd say maybe 20% or so.
Okay.
Okay. We're seeing more and more folks all the time file their own deeds. I don't recommend it. They should use an attorney, but they do not have to use an attorney to file any deed in Maryland.
Right, and probably because the cost of an attorney, would you agree with that? Attorneys, I know most attorneys are probably not free for this type of work. Isn't that so? Thank you, Mr. Chair.
Okay, we're going to stop right here. Thank you very much. That concludes the testimony on House Bill 625. Now, we have friends who have just arrived from across the street. So we're going to hear a number of bills that will go relatively quickly before we shift to bills related to judicial elections. So we're going to hear House Bill 786, the Chief Justice and Judge Wells. And what I will say is, in deference to the Chief Justice, we normally allow the Chief Justice to go and speak for as long as he wants. I would imagine he won't need to in some of these bills, perhaps on some rather than others. Everybody else is getting 2 minutes. So we'll go from there. Judge Fader, please. Chief Justice Fader, please. Let's start it right.
Thank you, Mr. Chairman, Madam Vice Chair. I'm pleased to speak today in support of House Bill 787. Members of the committee, thank you very much. It's good to see everybody again. I'm sorry, 786. 786, okay. This bill is part of the Judiciary's continuing effort to enhance public trust, confidence, and engagement with the communities we serve. We aim to demystify the judicial process and help the public understand what we do and why we do it. Traditionally, both appellate courts in the state have sat only in the city of Annapolis, at least since 1851. The one exception to that for the last many years has been the Appellate Court of Maryland, sitting once a year in each of the state's 2 law schools, both located in Baltimore City. By law, those schools are the only places the appellate court is allowed to sit outside of Annapolis. 2 years ago, having heard that some state Supreme Courts outside of Maryland occasionally sit in their communities, I brought that idea back to the members of my court, all of whom readily embraced the concept. In November of 2023, we sat in a high school in Prince George's County. We believe it was the first time since 1851 that our court has sat outside the city of Annapolis. It was very successful. We resolved to sit twice a year in a secondary or post-secondary educational institution somewhere in the state. We sat at the College of St. Mary's in St. Mary's County in May of 2024, then in a high school in Baltimore City last October, and we will sit at Montgomery College in Montgomery County next month. Each time we sit, we invite local high schools from the area to send students, hold question and answer sessions with the students after oral arguments, and then have lunch with a smaller set of students afterward. Each occasion has been very special for us, and we believe for the communities in which we have sat. The effort has been so successful that we are looking to expand it to the Appellate Court of Maryland. Because of the statutory restriction on them sitting only in Annapolis and the 2 law schools, we need your approval to do that. It will allow the judiciary to further engage with the communities we serve in promotion of our efforts to enhance public trust and confidence and educate the public about government in general and the courts specifically. So we're here to ask for your support. Look forward to your questions. Thank you for your consideration, and we'll turn the microphone over to Chief Judge Wells.
And good afternoon, Mr. Chairman, Madam Vice Chairman, members of the committee. My name is Gregory Wells, and I'm the Chief Judge of the Appellate Court of Maryland. I'm here asking for your support of House Bill 786, which will allow my court to sit outside of Annapolis at high schools and post-secondary institutions of higher learning throughout the state. My court consists of 15 judges, men and women of different backgrounds and points of view, of various ethnicities, who come from every corner of this great state to meet in Annapolis, working together as a team for the cause of justice. I ask you to support the bill because it will allow more of our citizens, particularly our young people, the next generation, to see our judges in person and to understand how we do our job of interpreting the law. We work to resolve disputes fairly and peacefully. By taking the court outside of Annapolis, we hope to inspire our fellow citizens to take a closer look at how we resolve disputes in an orderly and respectful manner. Appellate advocacy is chiefly about making an effective argument. By witnessing in-person oral arguments, citizens will see us as we work through questions about how the law should be interpreted and watch litigants respond to those questions. They will observe firsthand how we work through difficult questions about what the law means. We believe understanding how my court works will have a profoundly positive effect on our citizens. We deal with questions about criminal law, family law, employment cases, as well as business dispute, just to cite a few examples. In fact, there is no area of everyday life that our court will not address at some time or another. And significantly, our court is where many disputes end in the judicial process. Holding hearings outside of Annapolis is designed to promote transparency. We rely on the media to report on our government and hold it accountable, but there's no substitute for personally seeing the process in action. This bill will help the public do that. Thank you, Mr. Chairman and members of the committee. I welcome your questions.
Vice Chair for a question.
Thank you, Mr. Chair, and thank you, Chief Justice and Chief Judge, for being here today. I'd like to talk about security issues when you travel outside of the court. Is there a, what is it called, when you go before the advanced team that goes and does any work for you all to make sure that your security is secure?
Yes, so we have, within our administrative office of the courts, we have a security division, and we have, I believe now 22 special police officers who are part of that. They provide security at our courthouse and at our administrative facilities, and they do go and conduct an assessment. They meet with school board officials. We get the local law enforcement involved as well, and at the entrance to the buildings, they put magnetometers if they don't have them already and make sure that everybody who comes through is secure. And we've been very fortunate to have a lot of excited cooperation from local law enforcement. Incidentally, several, at least on 2 of the occasions, local law enforcement has come up to me in the parking lot afterward and volunteered how great of an event they thought it was and how effective for the students. So they are engaged in the process and are always present.
Further questions? All right, seeing none, thank you very much. That concludes the testimony on House Bill 768. Now we'll go to 767, or 787, sorry, 787. And that is the Chief Justice and Greg Hilton. Or no, it may just be Greg Hilton, actually. It is. How about that? All right. Go ahead.
Thank you, Chairman Clippinger.
We'll give you 3 minutes.
Members of the committee, my name is Gregory Hilton. I'm the clerk of the Supreme Court of Maryland. I have an ancillary role, which is the state report of decisions. In the process of undertaking that task, I reviewed the text of Court Judicial Proceedings Article Section 13203 and found 2 slightly anachronistic parts of that, one of which is gendered language in subsection B, and in subsection D, a requirement that the state reporter secure a copyright for the state of Maryland. It doesn't say exactly as to what. This language has been in the statute since the late 1800s, early 20th century, early 1900s, and no longer is effective, partly because of, in 1988, the United States became a signatory to the Berne Convention on Copyrights, which requires no action by anyone to secure copyright and written materials. There's also a question as to whether the state would ever exercise a copyright as to the reported decisions of the court. In large measure, what was copyrighted up until roughly 1983 was the editorial comments that were added by the report of decisions in 1983 when West took over the contract for publishing the reports of the courts. It took over the editorial requirements for that, and they retained the copyright to their editorial comments. With that, I ask your support and in support of House Bill 787. I'm happy to take any questions.
Vice Chair.
Thank you, and thank you for bringing your testimony. Does this have anything to do with the amount of official and unofficial opinions that may or may not be referred to as precedent?
No, this is entirely in my role as state reporter, which affects only the reported decisions of the 2 appellate courts.
Okay, thank you.
Other questions? Seeing none, thank you very much. Testimony on House Bill 787. Now 788. Judge Albright coming up. We'll give her over to Judge Albright. Well, I have 2 people signed up. That's fine. Whoever would like to go first, give Judge Albright 2 minutes. I don't think I hit the button for that, so I guess I have to say it again. This is House Bill 788. We'll hear from Judge Albright now for 3 minutes. Go ahead.
Thank you very much. Good afternoon, Chairman Clippinger, Vice Chairman Bartlett, members of the Judiciary Committee. I am Ann Albright. I am a judge of the Appellate Court of Maryland, but today I'm here in my capacity as chair of Maryland's Commission on Judicial Disabilities. With me to my left is Executive Counsel of the Commission, Kendra Jolivet. The Commission is the entity that is charged with investigating and making factual findings regarding allegations of misconduct, disability, and impairment against Maryland's Judiciary branch judges. Thank you for the opportunity to testify in support of House Bill 788. Today, we request a favorable report from the committee. House Bill 788 seeks to amend the Maryland Constitution, Article 4, Section 4A and Section 4B, as a way of improving the functioning of the Commission by allowing the chair of the Commission to temporarily fill vacant seats on the Commission when necessary. To fill these temporary vacancies, the proposed bill would give the chair the power to either temporarily appoint former members or to request that the governor appoint a temporary substitute member or to temporarily extend the term of existing members. One of the major constitutional functions of the Commission is to conduct public hearings when charges are filed against a Maryland judge. The Commission is composed of 11 members, judges, attorneys, and public members who are appointed by the governor by and with the consent of the Senate. It is of the utmost importance that as many members as possible, but certainly no less than a quorum is 6, be present to review the evidence and participate in deliberations so that the Commission's findings can then be submitted to the Supreme Court of Maryland. At times, due to conflicts of interest, scheduling, or the end of a member's term, certain members may be unavailable for the duration of a public hearing. During these times, and to ensure that there is a quorum and to conduct a fair hearing, the Commission would like the chair to have the authority to appoint a past Commission member to sit on the Commission for a specified hearing or period of time. The past member would have been previously vetted by the governor and approved by the Senate. If the chair is unable to secure a former member, the Commission chair would request the current governor expeditiously to make a temporary appointment for a specified time, a specified purpose, or extend an existing member's term. I respectfully request that the committee issue a favorable report on House Bill 788. We are here together to answer any questions that you may have. Thank you.
Just here for questions then?
Just here for questions.
All right. Any questions, Delegate Williams?
Thank you, Mr. Chair, and thank you, Judge Albright, for being here this afternoon. One
question I have, I think I understand the need for this. There is a provision in the existing law that says the composition of the commission should reflect the race, gender, and geographic diversity of the population of the state. And so my question is, with that temporary assignment or the person who is being appointed to serve the remainder of a term of a commissioner, if that commissioner needed to recuse themselves or leave or whatever the case, are you still bound to also take into those factors into consideration with that substitute member?
I would say yes.
Yes, of course we are.
Okay, thank you.
Questions? Vice Chair?
Thank you, Mr. Chair. Do we need to have an inclusion of a good standing requirement for former members that they left in good standing? Do you think that's something we should consider?
Well, I will say there is no current requirement for good standing, but I believe that if you rely on the experience of the chair and as well as the staff, which would be me, in terms of successful commission members, I don't think that the legislature would have any concerns about the person that will be selected to replace a member.
Okay, thank you.
Anybody else? Seeing none, we thank you very much, and that concludes the testimony on House Bill 788. I'm going to go to House Bill 864, the St. Mary's Judgeship Bill, because it only has a couple witnesses, and then the next sets of bills have slightly more. Chief Justice Fader and Judge Stanilonis, please. Chief Justice, I believe this involves changing a number from 3 to 4.
It does, but I won't stop there.
Great. Go ahead.
Chair Clippinger, Vice Chair Bartlett, thank you again. The Judiciary is asking to add just one judgeship this year, which would move the number in St. Mary's County from 3 to 4. The circumstances of this request, however, are a little unusual from past requests, so I did want to come and explain. The Judiciary has traditionally asked the General Assembly to authorize new judgeships only when the methodology that we employ, which is based on a model provided by the National Center for State Courts, certifies a need to do so. That methodology is based on an assessment of how long it takes to handle different kinds of cases based on the filings and experience with those filings across the entire state, not jurisdiction specific. And then based on the number of cases that have been filed in each jurisdiction over the course of the prior 3 years. In this case, we're still going back to fiscal year 2019, the last year that wasn't influenced by the COVID pandemic beforehand, and then 2023 and 2024, because those really haven't been greatly influenced. This year, that assessment certified a need for 4 new judgeships across the state. For a variety of reasons, including space limitations and fiscal considerations, we're not requesting any of those 4 new judgeships. 4 other circuit court jurisdictions requested additional judgeships, even though the model did not certify a need. We are not requesting judgeships in 3 of those jurisdictions. To be clear, each of those jurisdictions makes a good case for needing additional resources. However, the bar for the Judiciary making such a request when the model does not support it is extraordinarily high, in order that we maintain credibility with you by adhering to our rigorous methodology. Given the cases those jurisdictions have made concerning the need for additional resources, we are accelerating the process of updating our model. The last full model update was in 2017 to ensure that it does accurately reflect need. The Circuit Court for St. Mary's County's request cleared that high bar because there have been demonstrable changes in that court's workload that we know are not reflected in the model. Although many of our jurisdictions are only now returning to the same caseloads they experienced before the pandemic, St. Mary's has increased caseloads based on that time frame. But perhaps most significantly, owing to policies of the state's attorney in St. Mary's County, its contested criminal jury trials held have increased 261% between 2019 calendar year and 2024 calendar year. That's particularly significant because the model we employ to analyze the need for judgeships is based on filings and doesn't take into account what happens to those filings once they get into the system. And, of course, a case that goes to a jury trial takes far more time, judicial and other resources, than a similar case that's resolved by a plea agreement or in another manner. That additional time is not accounted for in our model. St. Mary's County has also seen a 62% increase over that same period of time in family law merits hearings. Again, because that deals with after the filing, not the filing itself, that's not accounted for in our model. In spite of efforts to address the backlog that they have, those and other changes have not allowed that court to do so. Judge Stanalonis, the administrative judge for that court, can provide more information in that regard, but I did want to explain to you how this diverges from what we've traditionally brought in and why, and it's because of the factors that we know are not accounted for in our model. Judge Stanalonis?
Good afternoon, Mr. Chair, Madam Chair, Vice Chair, members of the committee. I want to thank you very much for your consideration of this legislation. The Circuit Court for St. Mary's County is making this request based on what our observations are in the courthouse. To be quick about it, we have seen over the last 2 years a significant increase in the number of jury trials, as the Chief Justice indicated, on criminal matters, which has had a tremendous impact on our ability to handle all of the other matters that need to come before the court. To give you an example, prior to the last 2 years, typically in a month, we might have 2 weeks dedicated towards criminal jury trials per month, and currently we have 3 and sometimes 4 weeks per month that need to be dedicated towards criminal jury trials. The state's attorney's policies are their policies. They're not negotiating cases, which is their decision to do, but it's requiring us to spend a considerable amount of time in court with the litigation of those cases. We have the judges as a collective have started court earlier. For those of you who are attorneys, most courts in the state of Maryland start at 9 o'clock. There's usually a lunch recess and then stop around 4:30. In St. Mary's County, we typically start at 8:30, sometimes as early as 8:15. We go through the lunch hour on many days, and most days we are finishing court well after the 4:30 hour. Those judges, including myself, then have to spend a considerable amount of time outside of the court day to take care of preparing for the next case, doing research, preparing opinions, signing orders, and we're spending many hours into the evening and into the night doing that. So currently, we have family cases that are suffering. People can't get, I can't give you a day with a judge until September. If you have a contested issue involving child support or access and visitation, that's the earliest I can get you in, even on an emergency basis, and nobody should have to wait that long for their case to be heard. So I'm happy to answer any questions.
Wow, September. Okay, thank you. Thank you, Chief Justice and Judge Stanalinas. Are there any questions? Oh, Delegate Williams.
Thank you so much, Chief Justice Fader, for coming. I guess 2 questions, if that's okay. One, I know you said you were updating the methodology. When do you think that would be completed?
So it's actually a complicated process because it involves an audit for judges around the state, but we're issuing an RFP now. We expect that the full analysis will be ready to be incorporated in our request for fiscal year 2028, and we may have some data that we have seen before the full analysis is complete that would allow us for our request next year, but 2028 is when the full updated analysis would be ready to be used.
Thank you. And then my second question is, I know you explained the number of the increase of cases on the criminal side and on the family side. Is there any reason why you think this is occurring? Is it because of an increase in population? Or is there maybe something as members of the bar we need to do in terms of educating our co-members? Or I guess I'm just trying to figure out why there's this really huge increase.
On the criminal side, on the criminal side, my understanding, the criminal numbers, it's actually the only category of cases where the filings have gone down in St. Mary's. All other categories have gone up in St. Mary's. It's the number of those cases that have gone to a jury trial, right, which my understanding is it's based on the policy of the state's attorney for St. Mary's County of taking cases to trial, which, as Judge Stanalinas said, is absolutely within the discretion of the state's attorney to do, but it has an effect on the workload of the court. On the family side, I don't know what the explanation would be.
So there is, on the criminal side, the current state's attorney is not negotiating in domestic cases. Any cases involving guns, any cases involving sex offenses or child abuse. Murder cases has probably always been the case. So that is a substantial number of cases. St. Mary's County has had, I think overall, like most of the population, has had a decrease in crime as a whole, but has had an increase in violent crime. There is a significant number of murders that have occurred in our jurisdiction, a lot more gun cases, a lot more shootings. So that is part of the increase, but it's all of those cases as a combined that are going up. On the family side, I don't know exactly why there are more contested hearings, but I will say there is a significant increase in the number of family filings as well. It's the combination of the two. And as much as we try to use our magistrate as much as possible to resolve family cases, cases where attorneys are involved, they don't want to try something twice. So they're asking for judges, even knowing that there's a backlog. And typically, whichever side thinks they're going to lose the battle is demanding a judge because they know I don't have to deal with this for another 8 months. Right. So it's causing a hardship.
Got it. Thank you.
Thank you.
Thank you. Delegate Phillips, are you fine? Okay. Okay, great. Seeing no further questions, that concludes the testimony for House Bill 864. We're going to move now to House Bill 789.
And I believe I'm leading off again. So, Madam Vice Chair and members of the committee, I do want to begin by expressing appreciation for your support last year for the Judge Andrew F. Wilkinson Judicial Security Act. Enacted in the wake of the assassination of Judge Wilkinson, that law has made a big difference. In light of national trends pointing toward continuing challenges to the rule of law, these protections are of increasing importance. So thank you. One component of the Wilkinson bill brings us back here today. That law created a task force to ensure the safety of judicial facilities. It was a broad-ranging task force with people from across the branches, across the state, and across the different levels of government in the state. When we were fortunate to have Delegate Valentine as the representative of Speaker Jones on that task force, and he was involved in all of those meetings in that effort. The task force's challenge was to address 3 different areas to identify minimum acceptable security standards related to judicial facilities. As relevant to the bill for which we are here today, one of those areas was security personnel in courtrooms. This is an issue of critical safety to everybody who walks into a judicial facility and into one of our courtrooms. Shortly after Judge Wilkinson's assassination, I was looking for information that I could provide our judges about safety in courtrooms. One of the first things I found was a pamphlet from the National Center for State Courts about safety for judicial officers. The first page of real substance on that 7-page document was the second page. And the top bullet at the top of that page says, "Do not conduct court sessions or hearings in the absence of a court security officer." That is, in fact, the correct minimum national standard. Best practice is actually 2 court security officers in every courtroom. But if we followed even that minimal standard in Maryland right now, we would have a lot of very dark courtrooms. Across the circuit courts, and especially in our largest jurisdictions, there are more courtrooms in family and other civil cases without court security officers present than with them. That's not the case in criminal cases, but I'm talking to family and other civil cases. And that's really important because family cases in particular are among the highest conflict cases that we have. In fact, it was a family case that led to Judge Wilkinson's assassination. The task force identified a minimum acceptable security standard for personnel in the courtrooms of at least 1 qualified court security officer in every courtroom where a proceeding is being held, at least 1 other in every proceeding involving an incarcerated individual or in which an individual may be incarcerated in the course of the proceeding, along with sufficient number of others to be called upon when there's reason to believe it's necessary either in advance or during the course of a proceeding. Statewide, we're currently meeting that standard in our district court facilities, where the judiciary provides security through district court bailiffs, although not without significant effort in meeting that. Security in our circuit courts is provided by the sheriffs in each county and in Baltimore City, according to budgets funded by local legislative bodies. Although we're meeting that standard in some of those counties, we are not in many of them. This bill has 2 main purposes. The first is to establish a minimum acceptable security standard for security personnel in the courtroom statewide. The second is to collect information to help figure out exactly what the gap is now between that identified standard and what is going on in practice. For that purpose, the bill requires the collection of information from each of the 26 different entities responsible for providing security in courthouses across the state. We anticipate that information being helpful to inform legislation next year about how to implement and how to fund that increase to fill that gap. I'd like to end by expressing my deep appreciation to Delegate Valentine and to the other members of the task force, which really did an incredible amount of work in a very short period of time to work on this standard and others. We very much appreciate all their efforts. And I know Sheriff Kogan was another member of that, and I know he's going to be testifying here later. So I look forward to your questions, and thank you for your consideration. And I think next on the order is Judge Audrey Carrion, of the Administrative Judge of the Circuit Court for Baltimore City.
Thank you, Chief Justice. Good afternoon, Mr. Chair, Madam Vice Chair. Good afternoon. My name is Audrey Carrion, and I am the current Administrative Judge of the Circuit Court for Baltimore City. I am here to emphasize the critical need for enhanced security measures within our courthouses. The presence of dedicated court security officers in each courtroom, as well as additional court security officers for individuals who are currently incarcerated or who may be remanded, is not just a matter of policy. It is necessary for the safety of all who participate in our judicial system. Courtrooms are environments where emotions run high. Judges, magistrates, attorneys, witnesses, and members of the public regularly encounter individuals who may be experiencing extreme stress, anger, mental health issues, and desperation. Without consistent security presence, the risk of violent outbursts or disruptions increases, placing everyone at risk. Dedicated court security officers in each courtroom ensures that proceedings can be conducted in an orderly and safe manner. Currently in Baltimore City, we have 35 positions, but 16 of those positions remain unfilled due to the fact that the salary range is significantly lower than those of other enforcement organizations. The disparity in compensation has made it increasingly difficult to attract and retain qualified personnel, placing additional strain on the existing workforce of the Office of the Sheriff and potentially compromising the safety and efficiency of our courts. In our court, in the last year only, we've had the portrait of one of our judges removed from a public hallway in the courthouse and destroyed by a probationer to that judge. We've had reports in a federal wiretap regarding plans to kill one of our judges. We've had harassing emails to judicial officers, defacing signs in a public bathroom with profanity towards a judge, family brawls in public areas, harassments of employees in the clerk's office. This past year only, I've had 3 escort orders that I've had to issue involving 3 separate individuals to limit their movements within our courthouses. I urge you respectfully to support this bill, which recognizes the necessity of these security enhancements. A secure courtroom is fundamental to a fair and efficient judicial process, and these measures will ensure that justice is served without unnecessary threats of harm. I thank you.
Thank you very much, Judge. Okay. Whoever would like to go next.
Mr. Chair, Madam Vice Chair.
Former resident of this room, Judge Wilson.
That's right. Thank you very much. All honored members of this hallowed hall. My name is Brett Wilson. I'm the Administrative Judge for the Circuit Court of Washington County and was Judge Wilkinson's supervisor at the time of his assassination. I had the pleasure and honor to serve on both task forces, one created by the Chief Justice, one, of course, created by your great graces for us to investigate and try to determine what best practices can be done to make sure that our judicial facilities are secure for all who take part in the judicial process. As the chairman of the Standards Work Group, we had a dedicated group from all aspects of both civic and justice life that created or did research to determine what the best practices would be concerning courtroom security. In the process, we examined the National Center for State Courts Steps to Best Practices for Court Building Security, a study that took over 10 years to complete, the Arizona Judicial Administrative Court Security Standards, which was begun in 2015, the Georgia standards for court security. And if many of you may not recall, in 2005, the Fulton County Circuit Court had a horrible act where a defendant who was being transported by a single officer overwhelmed that officer, put her in a coma, killed the judge, the court reporter, a deputy, and also a federal agent outside of the court building. We also looked at the CALEA standards for court security. This is the Commission on Accreditation for Law Enforcement Agencies, which sets rigorous standards for accreditation and court security. Basically, this bill is based on fact, research, and experience. We believe the bill will help to ensure that all persons in a courtroom will be kept safe pursuant to the best practices that we could find nationally. It is based on the findings from extensive research and tragic experience, and I hope that you will support this important step forward towards securing our courts in Maryland. Thank you.
Good afternoon, Chair Klippinger, Vice Chair Bartlett, members of the committee. My name is John Morrissey, and I'm the, did I already use up all my time, Chair? Favorable.
That was because of me.
My name is John Morrissey, and I'm the Chief Judge of the District Court. The security needs of each courthouse to protect not just the judges, but the clerks that work in these facilities, as well as the public, are very real and are the most critical issue facing all 33 courthouses that comprise the district court system. Last year, the district court saw more than 2.5 million visitors. The bailiffs of the district court, to whom I and the public owe much appreciation, confiscated over 70 firearms, 8,000 knives or razors, 4,000 chemical sprays, and more than 1,500 tools. A quick example of some of the actual cases in the last six months may highlight this concern. On September 20th at our Glen Burnie District Courthouse here in Anne Arundel County, an individual attempted to bring in a double-barreled .38 Derringer, one of those very small guns. They also had a metal container containing 7 rounds that went with that gun. The suspect was at the court for a temporary protective order, which is the type that it is always the most volatile. On September 26th at the Hagerstown District Court, an alert bailiff noticed a fully loaded 9mm Smith & Wesson in a bag that went through the magnometer. On October 21st at the Catonsville District Courthouse, disturbingly, a .43 Glock handgun with 10 rounds in the magazine that was wrapped in aluminum foil and duct taped to the suspect's groin area was discovered when the bailiff screened the defendant at the door. During the interview, the suspect indicated that he had wrapped the gun in the foil in hopes that it would prevent detection. On December 5th, an individual coming to meet the parole and probation agent, this individual was already on parole or probation, was detected with a loaded semi-automatic handgun. And as Chair, you know very well, finally on January 31st, 13 days ago, and you all may have seen this on the news, with absolutely no case pending before the court or any business that we're aware of, an individual unfortunately came to the courthouse and committed suicide in the presence of my staff and the public. Bailiffs are my heroes, quite frankly. So on behalf of the 124 judges, the 300 bailiffs, the district court commissioners, the over 1,500 staff members, and the over 2.5 million visitors, I urge you give a favorable report to this bill. Thank you.
Questions for this panel? Do we have someone virtually on this panel? No. Yes. We do? Well, we'll take this panel and then I'll go to the people who are virtually because there's already questions up. We'll go to Delegate Tolles first and work our way around.
Thank you, Mr. Chair, Chief Judge, and all the judges here. Thank you so much for being here. And look, I am full support of having as much security as possible because you do, heavy work in the courtroom. One of the questions that I have, and I'm speaking with a former hat as well, being a former local representative, and without even looking at the fiscal note, looking at the bill, I knew it would cost a great deal of resources to put this effort forward. I know in Prince George's County, we did a number of security enhancements in our courtroom. I know the cost of that. So obviously adding that's just a one-time cost, right? So when you start adding personnel in there, it becomes obviously the benefits a lot higher. And according to the fiscal note, it could cost upwards of $10 million. I know we recently had a conversation with our sheriffs in Prince George's County. And like I said, I just know what it would cost. Do you have any recommendation? I see that you do have it spread out over several years, but do you have an idea of how we can give you what you need? Because Judge Morrissey, I saw you get choked up, and I apologize for that. That's horrible for you to have to witness, you and your staff have to witness that, and I'm sorry you had to, but could you help us out here and tell us how we can do this, with what it would cost local jurisdictions?
Yeah, so I can tell you a couple things in response to that. One is that the work group was very attuned to that. Work group included several local legislators and sheriffs and police chiefs, and it was intended to have a broad range of perspectives. What the proposal was from the work group was that this be implemented over a 5-year period of time, starting with fiscal year 2027, and that in order to fund a transition, because at the circuit court level, this is all paid for by the local, county and city governments. And so the work group thought that it wouldn't disrupt that funding source in a long-term basis, but that the local governments would need some time and assistance in order to ramp up and develop the capacity to provide the security. So the proposal was, beginning in year 1, to have 80% of the cost of the additional security paid for by the state, with a diminishing cost over time. So 80% the first year, then 60%, actually 60% the year after that as well, because that's when the second level of requirement would kick in. It's a phase-in of the requirement as well, and going down to 20% in the last year, and then the local entities would, with that assistance, the idea was be able to then carry forward with that. One problem we were having with figuring out exactly what the costs were, because number one, this was done on an expedited basis. The June 1st was the beginning date, and we had a deadline to get a report into the General Assembly by December 31st. So I think we did a lot of collecting of information in a short period of time, but it wasn't enough to get to real details of the exact numbers for a variety of reasons. There's just different definitions of a court security officer. So some jurisdictions might not have even known whether what they had in the courtrooms qualified under the qualifications that were established as necessary to provide this protection. We also, there's a difference between some jurisdictions, like Judge Carrion mentioned with Baltimore City, have a lot more slots available than, but haven't filled a lot of them. And some of them don't have enough slots available, so we don't have information about that either. And then, of course, there's difficulties hiring law enforcement personnel all across the state and the country right now. And so figuring out exactly what's necessary to meet the standards was something that just wasn't ascertainable to that task force there. So we thought that we needed to collect a lot more information in order to be able to get to what those numbers are and have this body be able to say, here's how we're going to be able to fund this. And that's what I described as the second part of this bill, which is requiring each of the 26 entities responsible for providing security, 24 sheriff's offices and local governments, and then the 2 different entities within the judiciary, one at the district court level, one at the appellate court level, to have them collect information. What exactly is the gap? How many people would they need to hire in order to meet these standards? What's the gap based on what they currently have available? What's the gap based on pins that they currently have available? What is necessary to get to that level? What's a plan to get to that level? And what are obstacles that you see in order to get to that point? So those are all things that are required to be collected in order for us to be able to provide that information. And the idea is to come next year and to be able to have the information necessary. That information has to be collected by September of next year if the bill passes, so that we could come back and say, now we have the information necessary to figure out what the plan is.
Okay. Thank you, Chief Judge. And I would just add, Mr. Chair, again, I want to thank you for the work you're doing. We're having the same problem with our firefighters trying to meet them at a certain national standard so that everyone is safe, whether they're in the courtroom and they're in the field. But again, I want to thank you. I've been in a courtroom where, deputy sheriffs are definitely needed. So again, I want to thank you. Thank you, Mr. Chair.
Delegate Cardin.
Hey, Mr. Chair. Thank you all very much for coming and for the compelling testimony. So first of all, according to the fiscal note, it says that there really are no state resources that need to be used for this, that it's all could be local, the way I read it. Judiciary can comply with the bill's requirements using existing budgeted resources. The bill does not otherwise directly impact state finances, is what it says. That being said, if we passed a bill that actually didn't utilize any of our dwindling state resources, but did put a requirement on local jurisdictions to pay, would you guys still be okay with that? That would be question number one.
So the judiciary funds through its own budget the security at the district court level and at the appellate court levels. And we are meeting this standard for those two levels of court. So as I said before, it's not without difficulty, including using contracted resources in the district court to make up for bailiffs we're not able to hire. So at least at those two levels, that's correct. With respect to the circuit courts, that has always been a local function to provide and pay for that security. As I mentioned, because of this concern about what would be required in an immediate basis for local governments to comply, we did one thing in this bill, which is have that be phased in over time, so the requirement wouldn't fully go into effect in the first year. It would take a little while. The other part of that, from the work group's perspective, that we didn't feel we had the information to work in yet was a state subsidy that would be a diminishing subsidy over time. And that's something that when we get the information, I think the intent was to come back next year and figure out how that would play out.
But I'm only saying that because, I mean, we know that there are cuts coming everywhere. So to increase budgets is like something that is I wouldn't say unlikely, but it's something that's going to be very difficult. So just to, maybe this is for Judge Morrissey. So the sheriffs are in control of the circuit courts, right, Judge Carrion?
Yes.
But the bailiffs are, and they're in both the appellate division and in the district court?
They're a little different. In the district court, the bailiffs are the district court employees. They're bailiffs. In the appellate courts and the security for the administrative office of the courts, they're special police officers that are employed by the administrative office of the court.
And then according to the bill, you want everybody who is court security qualified would have to meet the qualifications of a special police officer, which would be the level of the appellate divisions, right? Is that correct, Judge Fader?
Yeah, yes, and I think the bailiffs all meet that standard.
Okay. Is there any, this is really my last question, is there any continuing training or continuing assessment of bailiffs? I know that the sheriffs, for example, do they have to continue to require, because I know some of the bailiffs are generally retired, police officers, retired sheriffs, and they come in as a second or third career. And is there any additional continuing qualifications for them?
There is, Delegate. There's a yearly qualification both in shooting and in classroom work that each one goes through. They have to go through, in order to become a special police officer, you'll have to have gone through the Maryland State Police Academy, the same one that regular police officers go through.
Awesome.
Most of our bailiffs are retired police officers. We have, in an effort to, we're having staffing problems. In an effort to expand that, we've expanded that to former correctional officers and also former military police. And we've gotten a few of those, but they still have to be qualified as a special police officer and still have to go through all the requirements on a yearly basis. I have a director of security and 2 training people that take care of all that.
Thank you very much for all you guys do. Thank you.
Thank you.
I don't see any further questions for this panel. Thank you all very much.
Thank you.
Thank you.
All right, there's Raphael Santini, who's on virtually. So we'll look to have him brought in. Jason Deloach is also virtual, and Sarah Sample. Sheriff Kogan, come on over to the table. While we get them settled in with our virtual people, we'll hear from Sheriff Kogan from Baltimore City for 2 minutes, and then we'll give everybody else 2 minutes. So,
So thank you, Chair, who happens to be my delegate in my district, so it's a privilege to be in front of you. And thank you for everyone for allowing me to testify. I can't stress enough how important it is for every judge and every court official who takes the bench to have some security in their courtroom. And I think that's like a no-brainer to say that. Like if a judge is on a bench, right, and there are people in the courtroom and they're deciding a controversial issue, there should be a bailiff or a court security officer in there. And I think that's what we're talking about. So those aren't best practices. Those are like what we're calling minimal standards. And in Baltimore City and in other places, it all comes down to funding. You know, when you go for your budget as a sheriff and you stand in front of the county executive, or for my case, the mayor, and I say I have 30-some judges and I need 30-some court security officers plus a relief factor, and I need to secure the doors and have a rover, and here it is, right, whether that county executive is going to give me the funding to do that or not. And they have not historically across the entire state. And this is why we're in this situation where we have a disproportionate amount of judges and a lack of security to keep them safe. And I think it really is as simple as that we have to set a minimum standard that if you're a judge and you take the bench and you're making these decisions and the public is there, litigants and witnesses and people on juries are there, that we have to keep them safe. And that's what I want to do, but I can't do it if I'm not funded to do it. So I implore you to really look at this and really understand that sometimes we have to set a mandatory safety standard in order for the funding to come with it. And I think that's what we're doing here. I really want to do everything my administrative judge Carrion wants me to do to keep people safe. I need to be able to do that. And I can tell you right now as it stands, I can't do that because I'm not funded to do that. And it's a real issue in Baltimore, and I know it's an issue statewide. So I thank you for looking at this. It's incredibly important, and I can take any questions if anyone has any.
Thank you. I believe that Mr. Santini was on there. Well, here they're coming back again. Mr. Deloach, please, for 2 minutes.
Good afternoon. Thank you very much. Good afternoon, Claire Clippinger, Vice Chair Bartlett, and members of the committee. My name is Jason Deloach, and I'm the immediate past president of the Maryland State Bar Association, where we focus on protecting the legal profession. I'm testifying today in strong support of House Bill 789. I came before you last year requesting passage of the Judicial Security Act in honor of Judge Wilkinson. I thank you for unanimously passing the bill to protect the privacy of judges and their families, and for your support as MSBA has continued working with the Maryland Judiciary and partners in the legislatively created task force. MSBA President Santini has been able to share experiences of our members and think through the long-term solutions to provide appropriate security across the state. Today, we ask you to support minimum security standards for all courts across the state, specifically staffing for courtrooms. As we have shared, our member judges and attorneys involved in high conflict matters, including family, juvenile, and criminal law cases, are at great risk of physical harm and threats and have reported feeling unsafe due to their cases. We regularly hear from attorneys who report a lack of any security presence in their courtrooms, where these facts indicate abuse and violence between litigants. House Bill 789 would first provide additional minimum security to those high conflict courtrooms and then expand over 2 years to provide additional minimum standards for all court proceedings. We support this graduated approach. Given the impact this may have on local counties and funding, we ask for continued input from these partners in the future to best implement these standards. Judges and attorneys must be able to decide and present cases without fear for their safety or for their families. MSBA urges a favorable report on House Bill 789. Thank you very much.
All right, Ms. Sample, who is favorable with amendment.
Thank you to the chair and members of the committee for having me. My name is Sarah Sample. I'm here on behalf of the Maryland Association of Counties, and we support with amendments House Bill 789. As you've already heard from the hearing so far, counties fund the operations of the circuit courts, but really have no other administrative involvement. The graduated option to increase this over time is appreciated, but a major concern that has already been mentioned a few times is that an accurate assessment of the cost currently is not possible, and it's anticipated to be significant. We absolutely believe that security of the courts is an important priority, but would request that the state take care of these costs throughout rather than eventually putting an additional new mandate on local governments. And I would also just clarify that locally, we are limited in our capacity to actually raise revenues. So the 2/3 of our jurisdictions are at the income tax cap. The property tax as a mechanism is going to make housing even less affordable. There's the blueprint costs that we all know are historic. And even with that being the case, we're looking at a state budget right now, proposing even more shifts in our direction. And as our position shows, we're not opposed. We support the need for proceedings to be secure, but currently we manage a lot within our means in terms of unfunded mandates, but are getting increasingly more strained, and state help on this would be preferable. And for those reasons, we're favorable with an amendment on House Bill 789.
I think I saw Mr. Santini is also going to testify, but I don't see, there he is. Ask for him and he appears. 2 minutes, please, Mr. Santini.
Thank you, Chair Kleppinger. I echo what Mr. Deloche testified earlier to, but I want you to reflect on this concept. And the concept is, what's a human life worth? We don't want to come back, the Maryland State Bar, and talk about a Judge Wilkins' situation again. I thank you for your time. Maryland State Bar supports this legislation.
All right, are there questions for this panel? No. Okay, seeing none. Thank you all very much. That concludes the testimony on House Bill 789. Now, we have friends who have joined us from the Ways and Means Committee, and they're behind me. And they're going to be here to hear the next two bills, starting with House Bill 778. You're going to hear 778 first, and that's the Chief Judge and whoever he's bringing up with him on his first panel. So we'll be with them in a moment. But Delegates Fair, Roberts, and Griffith, if you have a question, the easiest way would just be to find an open seat. If they're all full at some point, which we haven't had that yet today, just let me know and we'll get you a question, all right? They have settled in, maybe? We'll find out. All right. Chief Justice Fader, please. As I mentioned before, your time is unlimited, but everybody else is 2 minutes, please. I'm sure there will be questions. Judge Fader.
Thank you, and I will not abuse my unlimited. Chair Klippinger, Vice Chair Bartlett, members of the committee, it's a pleasure to be here with you yet again so soon. This is also a bill, as I mentioned earlier, that is aimed at increasing public trust and confidence in the judiciary, minimizing perceived conflicts, and ensuring that every judge in the state is thoroughly vetted and found most fully qualified before taking office. All judicial vacancies in Maryland are currently filled initially by candidates who complete extensive applications about their backgrounds and qualifications, undergo a rigorous interview process with local and specialty bar associations, and then get vetted and thoroughly interviewed by a judicial nominating commission. There's an appellate judicial nominating commission, but we're talking about circuit court judges here for each of the regions. Those candidates are then forwarded to the governor only after being found most fully qualified for the positions. The governor then does another round of interviews and vetting before selecting an appointee. It is an appropriately rigorous process for such important positions. After that, however, the processes diverge. District court and appellate judges are subject to confirmation by the Senate. Appellate judges then also sit for retention elections where the people of their jurisdiction get to vote yes or no for their continuation in office, and they're subject to that again after 10 years. Circuit court judges are currently not subject to either of those checks. Instead, they run in contested judicial elections where they can be challenged by any lawyer who meets minimum constitutional qualifications. The winner gets a 15-year term in office. There are several aspects of this system that can be challenging for public trust and confidence. One is that the job of a judge is inherently apolitical. Judges are charged with being impartial arbiters of disputes and with maintaining neutrality at all times. That is essential to public trust and confidence in the judiciary. Involvement in the politics of an election can create an obstacle to that. A second challenge is what comes with fundraising for a judgeship. The primary contributors to judicial campaigns, it will not surprise anyone, are lawyers, often the same lawyers who appear before the judges in court. That poses a challenge for public trust and confidence in the courts. A third challenge is that candidates are subject to differing rules as far as what they can say in an election. Sitting judges are subject to ethical guidelines that restrict what they can say in an election. Challengers are not subject to the same restrictions. A fourth challenge, and one that we've paid increasingly greater attention to recently, deals with security. Judges knocking on doors encounter individuals who have been in proceedings before them and family members of individuals who have been in proceedings before those judges. That presents a security challenge and a dangerous situation. This bill would replace the current system of contested judicial elections for circuit court judges essentially with the same system that is in place now for appellate judges, meaning they would be subject to confirmation by the Senate and to a retention election initially within 1 to 3 years after they're appointed, and after that on a 10-year basis, the same cycle for appellate judges. It would maintain public input through retention elections while also eliminating some of the challenges of the current system that implicate public trust and confidence in the courts. This proposal comes out of the work group to study judicial selection. 2 members of that work group are here with me at this table today, and we're very appreciative of the work of all members of that work group, which were taken from across the state in many different areas and indeed with different positions with respect to this, and you'll hear more about that in other panels soon. It is not an easy issue. It's a very difficult issue. We understand that, but we believe that this is the best solution to maintain public trust and confidence in the court and in its ability to have judges who are fully qualified to take office in all cases. With that, I will turn the microphone over to one of the co-chairs of the work group, retired Federal District Court Judge Alexander Williams.
Thank you, Mr. Chair, Madam Chair, Vice Chair, and members of the committee. I'm Alex Williams, a retired judge, and I was privileged to serve as a co-chair with Judge Kathleen Dumais on the Judiciary's work group study. Let me say that in order to get a wide range of voices on this issue to consider and to conduct a comprehensive review, the work group reached out with notice to various community groups, bar associations, citizens, individual judges, public officials regarding our meetings, and in particular the public hearing on which was on the website. All our meetings were open to the public, to anyone who wanted to attend or join in the discussion and presentations. We listened to and considered the points lifted by those judges who ran as incumbent judges and those who successfully ran against sitting judges. We examined the material and the data and stats on judges of all levels, and we reviewed the record of the last 9 governors on the appointment history of minorities and women to the bench and courts throughout the state. I will say that we met 8 times over 22 months, and we tried our best to put together an independent, fair, and appropriate recommendation, which we ask that you support this particular bill. Thank you.
Mr. Chairman and Madam Vice Chair, members of the committee, my name is Carville Collins. I'm an attorney from Baltimore in private practice. I'm here today as a member of the work group. While the work group's review covered all aspects of judicial selection, a considerable focus of the work group was on the work of the state's 16 judicial nominating commissions in performing the vetting of circuit court applicants who enter the nomination and appointment process. These applicants face a rigorous review, as the Chief Justice has explained, a 41-question application, up to 18 interviews, and they submit extensive writing samples from their legal work. This exhaustive process reveals the applicant's background, integrity, maturity, temperament, diligence, legal knowledge, intellectual ability, and professional experience. This exhaustive process enables the judicial nominating commissions to nominate the most legally and professionally qualified applicants to produce an impartial and diverse judiciary. The work group found that after all this scrutiny by hundreds of lawyers who comprise the state's judicial nominating commissions and the specialty bar associations, and after all the additional vetting that is performed by the governor when leading up to his or her appointment decision, our current system under current law today is then to unexplainably jettison all the benefits of this extensive vetting when the governor's appointees must run in a contested election against challengers who have received none of this extensive vetting. The work group concluded that the vetting is rendered meaningless as the candidates, both vetted judges and challengers, are simply listed alphabetically on the ballot. The considered recommendation of the work group is to eliminate this vast waste of benefits by eliminating contested judicial elections, but still preserving for voters their say in the form of a retention election, as we do for all our appellate judges in Maryland. So for all these reasons, Mr. Chairman and Madam Vice Chair, and on behalf of the entire work group, we urge a favorable report.
Good afternoon. Good afternoon. I'm BB Berry. I'm one of your circuit court judges. Thank you so much for allowing me to speak today. You've heard about the vetting process. I will say that I've gone through that process. That process is no joke. I remember standing in front of the mirror or sitting in my car talking to myself, asking random interview questions. I think the folks on 270 thought I was crazy. Or I'd be on the floor at 3 o'clock in the morning studying. I basically went back to law school, not just to prepare for the interviews, but to prepare for the job. I didn't sleep very well, very much. Lost a lot of weight. It was brutal. And it was okay. It was worth it because it tested my mettle. I got through it. I took the oath. I meant every word, and I did the work. I posted by my door to the courtroom Maya Angelou's words: people will forget what you said, people will forget what you did, but people will never forget how you made them feel. And I did and do my best to live it daily. Almost a year later, we were fighting to keep doing the work. My 3 colleagues and I took days and days off to campaign. We didn't mind taking off, but 4 of us were just gone from the court for days. The last slate, it was 7, and that doesn't hurt us. It hurts the community because a ton of cases couldn't be heard. Then we got the results, and I was the very top vote getter on the Democrat side. On the Republican side, I was dead last of the 4 Governor Hogan appointees. The other 3 were white men. It wasn't our integrity, wisdom, or sound legal knowledge. It was something else having nothing to do with any of these things. I was lucky, my colleagues were lucky, others in other counties not so much, so let's please do something to make sure your judges are seated based on merit. Thank you.
All right, we will take questions for this panel. I'm sorry, Judge, I
don't know how you wanted to do it. We had 2 others. I don't know if you want to hear them on a separate panel.
All right, well, fine. That's fine. We'll hear these 2 people, and then we'll ask for the judge who just spoke to come back to the table somehow. We'll figure it out. But that's fine. Whoever would like to go next.
Thank you. Good afternoon. My name is James Rhodes. I'm one of the circuit court judges for Baltimore County. On January 26th, I was sworn in as a circuit court judge. I had given up a very successful law practice that I had built over 2.5 decades. During that time as an attorney, I also helped with a community outreach for over a decade. Coming to the bench meant I could still do that community outreach while also assisting the community from the bench. Within 2 weeks of that time, I learned that I had to run for an election, that I did not have a job to return to if I lost the election, and that as part of that election, I want you to understand what I and many of my colleagues went through. When I started campaigning, the challenger involved his campaign in fabricated stories against us, falsely informed voters that I was a criminal. One of the ads that as soon as it came on your computer screen, it showed an African-American male pointing a gun directly at you. That was specifically an ad that was for me. An attack that could have killed my son was used during his campaign. It was falsely and misleadingly put out to the public. During that campaign, the challenger used personal information that he should not have had access to place in his campaigns. And then he courted having the sitting judges place their personal information on public websites. Attempts to place this information out there hurt us all. Not only were my family members out there, but several other friends were also subject to the threats. I ask that you reconsider your position on these contested elections.
And good evening. My name is Judge Cherise Simpkins from Prince George's County. I'm here representing the Maryland Hispanic Judges Association. And as you heard, Maryland has a rigorous judicial selection process designed to ensure that only the most qualified individuals are sent to the bench. I, in my own career, was vetted twice. I sat once for my appointment on the district court by Governor Hogan, and again on the circuit court, my appointment by Governor Moore. I have over 20 years of legal experiences, and my running mates as well had over 20 years of legal experience. However, despite the thorough evaluation process, our system allows individuals with little to no judicial experience to challenge sitting judges in elections. And the Maryland Circuit Court judges, the only judges subject to contested election, must run against opponents who only meet the minimum qualifications, being a licensed attorney residing in the county for 5 years and paying a nominal filing fee. I believe it was $50. I ran and was successful in the 2024 race. However, we did have an opponent who just graduated law school in 2019 and only had 3 years of legal experience, wanting to serve as a judge. And as you know, judges, we hear everything from termination of parental rights, homicides, medical malpractice cases, environmental cases as such, and so on and so on. So this person ran against the seated judges, and it was by ballot placement where he was able to secure 127,000 votes, which is mind-boggling to me that someone with little to no experience would garner those many votes, that people would just go 1, 2, 3, 4 down a ballot. And those cases deserve the attention and the time, the diligence, the legal acumen and temperament to be heard for the citizens to have fair and impartial justice served. Thank you.
Okay. Many people with questions. So I'm going to just ask the committee, as you know, this is the middle, very much the middle of our long day. Make sure that these are questions and not longer discussion pieces. We'll start with the vice chair.
Thank you, Mr. Chair. And my question goes to Judge Simpkins, who just testified. So, my question is, you were speaking of without experience, people may run without experience. Some may say that we, members of the General Assembly, are able to run and get elected, and we may not have experience. But we have 180 other people who can run a checks and balance on some of our wayward thoughts or ideas or whatever you want to call it. How many people do the judges have when they make a decision to kind of keep them in check?
We have the, what is it called? The Commission on Judicial Disabilities. That is our checks and balances. And so citizens can write in anonymously or not to voice their concerns about a judge that's seated on a bench. And then those inquiries or applications are investigated and so forth. And so the process then begins if they find it meritorious.
Right. Thank you.
Thank you.
He just loves me. Thank you, Mr. Chair, and thank you so much for being here, and appreciate all the members of the work group. Just, I guess I'm a little concerned because I hear a lot of times an urban legend, which is that a lot of the diversity on the bench comes from elections. Can you speak to that a little bit? Was there data that indicated that most of your diversity is coming from elections, or is there some other information that you could provide?
So I can start. My understanding is that in times past, there were issues with, there were a lot of issues with diversity on the bench, and it came from who was being appointed. And that there was a time where diversity on the bench, especially in certain jurisdictions, came from elections. But I think that those times are decades in the past, and now the diversity on the bench has come from the last several governors, and I think you can see that by looking at the diversity at all levels of the judiciary. It's not just at the circuit court at all. It's at the district court and the appellate courts as well, and even at the circuit court. I think it comes from governors and from the judicial nominating commissions that have looked broadly to candidates and identified candidates who are most fully qualified, regardless of their demographic characteristics. So I think that there was a time where that was the case, and it is not the case now.
I would also echo what the chief has said, and my position has evolved over the years. Some of my mentors are from Baltimore City, and they ran against the judges, Joe Howard and Ken Johnson and Billy Murphy, and they always stood by the position that we needed to have the ability to run. But now, after having looked at the record of 9 governors, the situation now is far more diverse. When I clerked for the only black judge in Prince George's County, there were only just white men on there, with no women. But right now, again, because of what the governors have done and the legislators pushing the governors, we now have 51% of the judiciary in Maryland would be female, and 30% of the judges throughout the state, not in every county, but throughout the state, are African American. So there's been some progress based on the appointments.
Okay. And is there data that can be shared regarding all of that, or is it in the work group report?
It's in the report. It's in the
Okay.
report on page, I think, 20.
I'm not sure the page, but it is in the report.
Yeah, it's in the
Okay.
report.
And then one other question, that's about the nominating committees themselves. How diverse are those? And you know, again, just to understand a little bit more, because they are kind of the starting point with all of this.
Mr. Collins was a member of the work group, can speak to that.
Thank you.
Delegate, thank you for the question. As to the diversity of the judicial nominating commissions, that has evolved over time in the same way that the bench has evolved. And the input is now much greater than ever before. Since the days of the 1970s, when these judicial nominating commissions were first formed, in the early years, for the most part, the governor made all the decisions. There's much more input now, and there's actually a process whereby it's really opened up to others. The governor still does make the appointments, but there were a number of recommendations that our work group made, and we've also seen some evolution over time of this issue whereby some of the positions on the judicial nominating commissions are selected by the governor from lists that are submitted by the local bar association, or in the case of the appellate commission, submitted by the Maryland State Bar Association. And the governor picks from those candidates offered by those bar associations. There's also to be much more input on the composition of these judicial nominating commissions that are in our recommendations. That is not in the bill that's before you, and one of the reasons is, I'm pleased to report, many of those recommendations, which are in our report, have already been adopted by the current governor. And in his most recent executive order in 2023, Governor Moore did adopt many of those recommendations to ensure not only diversity, but growing diversity of the memberships of those judicial nominating commissions. So that work has been done already for us in large measure.
Okay, thank you very much.
Thank you, Mr. Chair. Thank you all very much for coming. And to my judge, Judge Rhodes, we're glad to see you here, and was happy to celebrate your investiture a few weeks ago. So I'm going to ask, since it was just brought up to Mr. Collins, I had an opportunity to testify before your task force and bring some of the information that I've experienced both here as well as out on the campaign trail. You had just spoken a little bit about the judicial nominating commissions. There were not just like a few recommendations. Weren't there like dozens and dozens of recommendations in terms of reforming the commission to make sure that diversity is not only implemented in the selection of judges, but also, or selection of qualified candidates for judges, but also in the commission members as well?
I'll start, and I'll ask Judge Williams to weigh in if I've missed anything. You're exactly correct, Delegate. There was an array of recommendations in this regard. It spanned on a couple of different fronts. There were recommendations about a code of conduct for members of the Judicial Nominating Commission. There were recommendations for training of members of the Judicial Nominating Commissions. It's really a fairly exhaustive list. There was to be more public input through public hearings to be held by the Judicial Nominating Commissions, rather than being just insular among the commission members themselves, to solicit more input from the public. And also, there was to be greater input from the Bar Association. These types of reforms that were recommended, which have largely been adopted by Governor Moore in his executive order, were all about diversity. And also about many other things as well to improve the quality, the capacity, and the ability of these judicial nominating commissions to do their charge, to fulfill their charge, which is to nominate persons who are most legally and professionally qualified.
Perfect. And Delegate, what we continued to hear at the hearings is that we needed more input from the specialty bars, not just the traditional county bars, the specialty bars that would make up a lot of these commissions, and that's our recommendation.
Okay, and thank you very much. That was very helpful. The other thing is, when I had the opportunity to testify, I talked about fundraising. Fundraising is a public experience. In fact, all the information about the fundraising is viewable to the public. Isn't that correct?
That is correct, Delegate.
So if, let's just say that my Baltimore County sitting judges campaign raised $500,000, we, the public, could know who contributed that money, and it's most likely lawyers and people and special interest groups and businesses that are going to be in front of those, perhaps in front of those judges at some period. Isn't that correct?
Not only is it most likely, Delegate, it is absolutely true based on our investigation.
And so to avoid even the appearance of conflict of interest, we should somehow figure out a way to eliminate, because of the nonpartisan and the non-political aspect of the judicial experience, we should figure out a way to void them from the fundraising experience. Wouldn't that be fair? Is that one of the recommendations of the task force? Isn't that true?
Delegate Cardin, it is at the heart of our recommendations, and it goes back to the main point. If we are to uphold the impartiality and independence of the judiciary, then political contributions from lawyers who appear before those judges is not a good appearance, it's not a good actuality.
And the final thing is, as I believe that Judge Fader said earlier, judges are not permitted to speak about their decisions, or they're not allowed to tell the public really anything except sort of about their demeanor and their judicial acumen. They can't really talk about anything specific in the decision-making process. Isn't that true?
Yeah, they can't give the impression that they would rule a certain way if a case came before them, so they really are limited in what they can say.
But their opponents can do that, can't they? That's right. And so it basically allows a person who is an effective campaigner to be the person who could win the election, not necessarily the person who is most suited to be the judicial officer. Would that be fair to say?
That's correct.
Thank you.
Delegate Tomlinson.
Thank you, Mr. Chair. Of all the arguments you make on the why we should pass this bill, the one that I think holds most merit is what you were just talking about as far as the issue that comes with raising money, which all of us here in this committee all do as well. It's so much fun. I do, that argument makes sense to me. Was the task force at any point entertain or look at the idea of using or starting or, well, I guess trying to push for legislation that would allow for judges to use or public campaign finance dollars?
Yeah, that was one of the recommendations somebody else suggested. No, fiscally, I was accepted that would be, but that was one of the recommendations. And most of the people felt that the public in general is not inclined to contribute. And the only ones interested would be, of course, the lawyers, that sort of thing. And that's something around the country that we've seen as a problem. But public financing, to me, is a decent recommendation.
And Delegate, in looking at best practices in other states, we found very few, if any, states used public financing for judicial elections.
Okay, gotcha. Can I ask another question? Thank you. So with retention races, one of the things that I found troubling this year, last year in November's election was all of us, because we're, involved in this world, we all get asked questions every time an election comes up on, how do you feel about this race? Should I vote for this guy? Should I vote for this person? And this year, November, there was a number of retention races on the ballot, and I'd never been asked so many times, how should I, do you have any thoughts on this race? And I told them I have no idea. And they said, should I vote yes? And they said, well, what do you think about this judge? I said, I don't know. And they said, well, where can I find information out about this judge and about this retention race? And I guess that's the trouble that I have with creating more retention races is I feel like we are basically we're taking away choice from voters. And then on top of that, voters have no ability to learn and to make an educated vote. So my question is, how are voters supposed to make an educated guess if we switch over to retention races?
Yeah.
Delegate, it's an excellent question, and this issue came up throughout the 22 months of our work. Our recommendation, and I think it was unanimous across the entirety of the work group, was that retention elections can be effective if there is public education, and more public education is needed. We looked at other states that are conducting retention elections that have been, some would say, meaningful. Whereas in some instances, rare, but in some instances, people were not elected in a retention election. And what was going on in those other states is that there was more information and education that went on, and that is one of our recommendations. As part of our recommendation for a retention election for circuit court judges, we are also recommending that there be a improved public education campaign, as other states are doing, to address exactly the concern you raise.
And that point was made very clear appropriately by the representative for the NAACP who was on our work committee. He said people have no idea who these judges are, what their record is, whether they're sensitive or whatever. And so that's a strong recommendation to make sure that citizens have an opportunity, not just for retention elections, but also the selection and election of judges. They should have information on these judges. So great point, and that was important to us.
Delegate Tolles.
Thank you, Mr. Chair.
Thanks for your indulgence early. So first, I want to begin by always good to see my mentor, retired federal judge, Alex Williams.
Yes, sir.
We talk often.
Yes.
I love you and I appreciate you and all the work you do for the state. And so you have been just phenomenal in ensuring that we get Black judges in Prince George's County. So, as you indicated, that wasn't in the past, and you have spent your career ensuring that we diversify the bench in Prince George's County. So I'm very fortunate in my county. And we also have very good judges that are not Black judges, and that's critically important as well. I have some folks that I rely on that are not Black judges. So diversity is important, but it's not the only thing. So I want to ask a question to Judge Rhodes. How many Black judges are there in Baltimore County? How many are Black men and how many are Black women?
Currently, there are 6. 3 Black men, I'm sorry, put that down to 5, because I'm including 1 district court judge.
Okay.
On the circuit court, there are 2 Black men, there are 3 Black women. I am the 3rd Black male that's been appointed in Baltimore County. My colleague, Judge DeMayo, was the 3rd Black female, and she was running with me at the same time. So this year was the year for the 3rd Black male and female for Baltimore County.
Okay, and you both won your race, I'm assuming.
Yes.
Okay, so that is great. So how do we deal with jurisdictions that don't have the outstanding Judge Williams doing the work that we've done in Prince George's? How do you ensure jurisdictions will be able to, diversify the bench without having to do an election?
So that's part of what.
And I'm sorry, that was for Judge Williams.
Oh, I'm sorry. I just wanted to let you know that with the contested elections, that's part of the problem in jurisdictions like Baltimore County, where we don't have a history of having many or much diversity on the bench. As soon as we do get diverse appointments on the bench, we're challenged by people who don't want that diversity on the bench. And that's what happened with the election for both myself and Judge DeMayo this year.
Okay.
Well, and another suggestion, members of the General Assembly, obviously, they're concerned about the lack of diversity in some of these counties, and they have to get a little more involved, and we need citizens on the ground. Again, encouraging the governor and others to make sure that the bench diversifies. And we've got a ways to go in some counties, there's no question about it. But we've made a strong effort across the years to get these numbers up, particularly of women. And as I said, I was in a county for years, no women on the bench at all. Harry Hughes was the first governor that appointed a woman judge way back. But it's changed a little bit now because of the pressure of legislators like you have here and community groups and bar associations and so forth. We all have to get together and make sure that we change the culture and the environment.
Okay, another quick follow-up. Thank you both. Forgot what I was going to say. I'll skip to this. I'm sorry. And I don't have a problem with saying this because I'm a Democrat. Would we have a governor in the state of Maryland like we have as the President of the United States? And that's for the gentleman with I'm sorry, I forgot your name.
Carville Collins.
Where we're stuck with retention. And we get a Elon Musk judge, God forbid, ever.
So what our system, Delegate, it's a great question. What our system, as reflected in our recommendations in this report, the system that we are calling for provides accountability at all levels to prevent situations like what you're describing. It starts at the beginning with the judicial nominating commissions.
Okay.
It starts with the input that those commissions must have. And the system that we've been implementing over the years that is working well is for the judicial nominating commissions to nominate the most professionally and legally qualified applicants, and the governor must pick from that list.
That short list, I understand.
Right? That list. And then from there, you go through the whole rest of the process, and then at the end, after the appointment is made, then that judge stands for a retention election, where the voters have the final say. I left one step out, by the way, Senate confirmation.
Right.
It's another accountability step. So all of the work of the judicial nominating commissions, all of the input that goes in through that, then the appointment, then Senate confirmation, and then the retention election, all of that as a package is designed to prevent exactly what you have described.
Okay, thank you. A great point. And final thing, Mr. Chair, speaking of that judicial package and that vetting package, would you agree that we've had some phenomenal individuals that have gone through the vetting process, various commissions? I wrote letters for a few of my constituents that have gone through the vetting process that either got on the governor's short list or did not get on the short list, but nonetheless were very, good candidates. And because you don't have an unlimited amount of vacancies, obviously you have a limited amount of vacancies, so you can only choose one or two, but are still good, that never get chosen and decides to run. What would you say to that argument? Because those are questions I've gotten. Hey, I've been vetted, got on the short list for years and years. I've never gotten chosen, so I want the opportunity to run. And I can direct that to my judge from Prince George's County, Judge Simpkins.
Judge Simpkins.
How you doing?
I'm well. How are you?
Good to see you.
And so, can I just, before I answer that, there was one point, you made the point of the Elon Musk. That could also happen by someone running unchecked, unvetted.
Absolutely.
And then they're on the bench for 15 years, period. Without having that vetting, without having that scrutiny, without answering those questions, without going before those 14 different specialty bar associations, without meeting with the governor, without going through that. And so it could be the flip, and you could get someone, as we had someone, again, who ran, who was 3 years out of law school, who I don't even know knew if he knew where the courthouse was. I don't even know if he knew the address. And so it could be the inverse of the concerns that you might have. As to why someone is picked or not picked or is on a short list and makes it up to the governor, it could be a whole host of reasons why there could have been someone else that was more qualified, or maybe there was an issue with temperament. I don't know. Would be, honestly, the answer. Could be a variable of reasons as to why that person was not successful, either on coming off of the short list and meeting with the governor or being chosen by the governor.
Thank you. Thank you, Ms. Chair. Look, it's definitely a hard thing when you take away, I'll say this in closing, when you take away the right to vote, it's always such a hard thing, particularly with minorities. I would just say that. But you all answered the questions flawlessly, and so I thank you for taking the time to do that, and I thank my chair for allowing me to ask that many questions.
Sadly, I'm going to be limiting time now for questions.
Sorry.
Questions from members will last about 3 or 4 minutes, and then I'm going to ask you to wrap them up. Delegate Boucher.
Thank you, Chairman. And thank you, Judge Williams, for the work you did on redistricting reform. A lot of people are not aware of that. I want to focus on the diversity in the state Senate aspect of this. Can anyone on this panel state for me the last year the existing party that dominates the state Senate did not have control of the state Senate? 1920, that's 105 years ago. Does anyone in this panel think that that is truly diversity and it will not have a negative impact upon the appointment of judges and their confirmation?
Delegate, it's beyond the scope of our work on the work group. I think we've explained what it is we've looked at, what we are presenting, what we are recommending, and you're seeing the heart of that recommendation in this legislation. I cannot make a projection or a speculation about the Senate. It was not anywhere near part of what we evaluated as a work group.
Thank you.
Delegate Taylor.
Thank you, Mr. Chair. Thank you.
We'll get there. There we go.
Thank you very much. We're only talking circuit court, right? How many states, other states, have full elections for circuit court judges versus those that have the elections when you're, being... Retention elections, yes, that's the one.
I can take a try at this. Delegate, we looked at all of the states. Many of the states do it differently. But there is one trend among many of the states, and we are part of that trend, which is that there is a process for vetting of candidates, of applicants, and recommendations, nominations are presented to the governor for the governor to make his or her ultimate selection. What's different is some states then have elections, other states do not, and then there's a whole nother group of states that choose all of their judges based on elections only. So all of the states are in a different place at this time. What we were trying to determine is what are the best practices among all of the states. But we did so in light of the history of Maryland, what we've been, where we've come from, the progress we have made on diversity and other considerations, qualification of judges. We recommended a series of reforms that would be consistent with the structure that we have, taking into account the best practices in other states.
Thank you for that, and I don't want to use up my 3 minutes on that one question. Can I just ask a quick one? Judge Simpson, you and I were out, Simpkins, we were out there campaigning together, so I remember. That's how I got to know you, right?
Yes.
You and your slate. So you guys were out of the courtroom during, I guess, 4 or 5 days during the primary election and the general election.
It was actually, I believe, 10 days for the primary.
10 days.
From 7 a.m. to 8 p.m.
And what happens?
Then the general.
What happens to our courtrooms, our courts in general, when you are not there?
It bogs down the system. The weight falls on the judges that are there. The cases aren't heard. They don't have enough judges to hear cases. And citizens' cases are inevitably continued over and over again, because those cases can't be tended to.
Do you have the option of not taking that time off, but you feel like you have to because you need to campaign, or?
We have to campaign. I mean, there's no end game or end round. There's no way around that.
Okay, and then could somebody comment on what the process is to remove a judge?
I'll just say it's very, very difficult to remove a judge.
Well, it's.
Yeah, Judge.
It's quite difficult to remove a judge. If there are complaints to judicial disabilities, maybe the Chief Justice would prefer to talk about this.
Are you speaking of removing a judge once they've already sat on the bench and qualified?
That's correct.
So the process for judicial discipline is through the Judicial Disabilities Commission. You had earlier testimony on that bill with allowing substitutes from the chair of the Judicial Disabilities Commission, Judge Ann Albright. And that is a body that is created by the Constitution that receives complaints about judges, and they do investigations of those complaints, and then they hold hearings. If they decide to press charges, they issue a public charging document and hold a public hearing, basically a trial where the entire commission sits, or at least enough of them to get a quorum, and the charges are made as you would have in a trial. They actually use our courtroom in Annapolis, and so by that point you've gotten all the way through the investigation. The judges have rights through that process. The case is made in that public forum, and then the commission votes on whether they think the judge committed acts of discipline that fall within their jurisdiction. If they believe that they did, then they identify what they think should be the result of that, the disciplinary result.
Is this a month process, a whole year, 2 years?
Many months. And then if they recommend a discipline that's above a certain level that would be a reprimand, then the judge has the right to appeal that to my court, to the Supreme Court of Maryland. And then they would be able to bring that and brief that and have arguments in our court that would ultimately be responsible for imposing that discipline. So it's an extensive process.
Thank you. Delegate Griffith from Ways and Means, formerly Judiciary.
Thank you, and thanks for having me back, Madam Chair. It's nice to be back. Thank you for being here. I appreciate it. I'll be brief, but I have a couple of questions I'd like to run through as quickly as possible. So first, at the appellate level, how many retention elections has the judge up for election lost in Maryland?
To the extent I'm aware, none. It's a relatively small number of, there are only 22 appellate judges in the state, and I'm not aware of any who have lost.
As far as we know, they've never lost a retention election.
In the state of Maryland. There have been in other states.
In the state of Maryland, yes, sir, absolutely. So my next question is going back to the process and so on and so forth. So with that being said, who appoints the majority of the Judicial Nominating Committee?
The majority is appointed by the governor under current practice.
Absolutely. And so you also
under each governor. So the last governor appointed the majority of those in those commissions, and then the current governor.
Yes, sir.
Yeah.
So with that, you were talking about the process being made more robust and more solid through executive action. So if there was, let's say, a Republican governor coming in 26 or 30, they could very easily undo that process through executive action?
It is all set up by executive action. It has been since Governor Mandel first implemented it, yes.
So under the circumstance, another governor could come in, undo the entire process through executive action, appoint the majority of the nominating committee, and then appoint a judge to, say, Baltimore City. And with the 100% retention rate we have at the appellate level, then that judge would almost, at this rate, 100% be retained under that process.
I think you're describing a much different process than exists right now, so I don't know that you can assume that the levels of success in a retention election that we've seen in our appellate judges would continue to exist under that system.
Because there's no data to support the opposite, because we have a 100% success rate at the retention at the appellate level, so there's no data to support anything other than that.
For the past more than 5 decades, it's been under this system, so yes, there's no data to support another system.
Absolutely. So this could very easily be undone through a stroke of a pen, the entire process that you guys are supporting. And I'm not criticizing the process in place now, I'm just saying it could very easily be undone, and we could go right back to the issues where we may have a governor appointing judges in a jurisdiction that, you know, may not properly represent the jurisdiction, and then the people not really have a say in the process because the education piece. And I guess the last question is, and I appreciate answering all the questions, I'm trying to be as brief as possible. On the education piece you would discuss, which I think is very necessary, who would provide that education? Would it be the Judicial Nominating Committee that's appointed by the governor? Who would create that education on these judges to push out to the voters?
Yeah, I can. Delegate, one of the recommendations that we touch on in our report is based on best practices in other states, and other states, a small number of them, have begun a judicial evaluation system. Now, it's not to evaluate outcomes in cases. It's to evaluate judicial temperament, judicial qualification, how much work, how much work product, how many cases are resolved, those kinds of issues associated with judicial performance. This is not something that we studied or made a specific recommendation on, but we did recommend that that be considered with further study. Should the state want to look into that further, there are states that have judicial evaluation processes in place that are working and have helped to create a meaningful retention election, not a situation where every single person wins every single time.
So I guess to the last follow-up, and thank you, Mr. Chair, Madam Chair, for the indulgence, but just to follow up on that. So right now, it could conceivably be the same people that are creating the education for the people that are ones making the selection on who that judge is. And of course, they would be in there, people want to be right, so they would probably put out favorable information for the judge that they selected. I mean, that's kind of a rhetorical question, but it's conceivable. So I guess my biggest concern with this is, like, President Obama once said, I got a pen and a phone, right? A new governor could come in with a phone, undo through executive action this entire process, appoint judges, and with the 100% retention rate we have right now, could reshape the entire bench in Maryland potentially. So that's my concern. So thank you very much for answering the question. I'm grateful.
And theoretically, Delegate, that's true, but in the past 54 years, nothing like that has happened. Every single governor has followed this process of nominations and issued an executive order to create the situation that we have. So what you're suggesting, yes, it's theoretically possible, but not in 54 years has anyone done anything like that.
Well, I share your hope it doesn't change. Thank you.
Thank you, Mr. Chair. Thank you, Mr. Chair. I'm actually glad someone brought up Elon Musk, and what he's revealed is kind of what happens when you have a closed system. And it's every time a lawmaker here really complains about the nature of the nomination process, it's really about a lot of nepotism, a lot of knowing the right folks. It's really a closed system that doesn't allow the average person to even participate at all. And I think both people from both parties, lawmakers from both parties, have made that complaint as we heard this bill over the last, 10 years or so. I have a couple questions. What is the actual year? Do we know the actual year the last time a retention election was lost?
Nationally or in Maryland?
In Maryland.
Nationally, it was last year, I
Maryland.
believe.
In Maryland.
I don't believe we have that in Maryland.
Okay. So we've talked about money and the need to raise money. Candidates like myself who didn't have net lists or networks or contacts, special interests, the PACs, anyone who's interested in anything in Annapolis doesn't really care about us. And, we didn't have lawyers. And anyone who's done that kind of campaigning knows the first people to actually donate are mom and dad, your Aunt Sue, your brothers and sisters, your progressive cousin who loves you regardless. Isn't it actually true that raising money from big rooms of attorneys is pretty much a choice, that you could do what we did and do it the hard way? Because I've been to those meetings, and that's the easy way to do it. But isn't it true that if you want to, I work 40 hours a week and then campaigned 5-6 hours a day and on weekends, isn't it true that you could do it that way? You don't have to go to the attorneys.
Delegate, that's exactly what we did. So we exhausted our families, our friends, bank accounts, college tuitions, 401s, whatever we had to put in. I took out the pot when I was out of options. I was making beans and rice in my kitchen, and I had a fundraiser at my house so that people could come and fundraise and donate to us. We don't have a pot to pick from. So what you just spoke of is exactly what we're doing as judges from the ground.
But respectfully, that's not the argument we hear, and that's not the argument I heard today. The argument I heard was we have to go to the attorneys, it's a conflict of interest.
Well, at some point, mom and dad get tapped out. Auntie and uncle get tapped out. They can only donate but so much. And of course, there are limits on donations that we can receive. But people don't care really about the judge's race as far as a fundraising. Lawyers, we can't make political promises. We don't have a platform. People want to know what we're going to do for them. We can't do anything but be fair and impartial and make sure that when you come to court, that you're heard, that you're respected. That's it.
I feel your pain because nobody cares about races for delegates in Essex and Dunlop.
But the lower you go down ballot, the more people, especially we felt it with the election that was going on, people were putting their money towards presidential elections and senator elections. They weren't worried about down ballot.
But it brings me to my final point. And you talked about what you can talk about. You can't talk about cases. You can't talk about how you would make decisions. That's clear. We understand that. Isn't it true that communities actually care a lot about judges in courts? Because I've never actually seen a person running for judge have a town hall just to talk about how things work. And isn't it true that you could talk a little bit about how things work without getting into particular cases or what you would do, and really engage people? Because I think the reality is people would love that, but I've never even seen someone try it.
We've done it as well in this past election. I'm sorry. We've done that as well. We've gone to church service after church service, had forums, tried to get out in the community, different events, just trying to get to the public to do that educational piece. And so, again, we're on the ground, we're running, we are trying to get before anyone that we can possibly get before, whether it's at the grocery store, whether it's fraternities, sororities, churches, what have you. We're there. FOPs, the American Legions, we were there. So we've done it.
It sounds like it's working, but thanks so much.
Yes, Mr. Chair, I will be brief because I see that Delegate Pastor and Delegate Phillips have questions, but I do also, like my predecessors, have a couple questions. And that is, my question is for Judge Barry from my own county. How many nominating committees did you go before? How many interviews did you have to sit for? And do you think that they appropriately put you through your paces, asked appropriately tough questions, etc.?
It's 14 interviews, if I recall correctly, plus the governor's interview. Excuse me, the 14 commission, 14, I think the commission is included, but 14 or 15. I was traumatized by that, so I try to not think about it too much. Did they put me through my paces? Absolutely, 100% they put me through my paces, but they're also, I mean, they're doing so much other things. It's not just about the interview. Of course, the interview is important, but they're also doing a lot of the background work to do the vetting. So yes, I would say that it was quite extensive and necessary.
My second question, and I only have 3. My second question is, it is for Judge Williams, and that is, I know that that this recommendation to get rid of the elections was not unanimous, so I'm asking what the vote was, please, on your commission.
Yeah, I don't have the exact vote, but it was an overwhelming majority of people in support of it. There were some dissenters. Some people obviously disagreed with it. But overwhelmingly, most of the people believe that this was a recommendation that we can go forward with. And we may have the numbers. Is it in there? It may be in the report?
Yes, Delegate. The numbers are in the report. I believe there were 20 members, and it was 15-3 with two abstaining.
Yeah.
Okay. And my final question, Mr. Chair, is I have a constituent who is very disappointed because he's applied 3 times to be a judge and really would like to be and hasn't made it. And so my question is, in your experience, do the nominating committees give feedback to unsuccessful candidates so that they might be able to improve their presentation for the next time?
Delegate, that's a great question, and we did consider that, and that we heard about that in several instances during the work of the work group. The content of these interviews conducted by the judicial nominating commissions are confidential. However, we have explained to all applicants that if they have questions afterwards, if they are unsuccessful and they wish to learn and they wish to get some feedback, they are instructed to contact the chairman of the commission. This is a best practice that Maryland has used for some number of years and other states have used as well. The chair then provides the information, keeping in mind the confidentiality requirements, but a constructive conversation, as far as I know, and I've served on the Appellate Judicial Nominating Commission for now 14 years, and Judge Williams chaired that commission for 8 years during my time. I believe that all of the chairs have provided helpful and responsive information to those questions.
And just to add to that, as a chair, once the deliberations were over, yes, it was confidential, but I took questions from any candidates who just wanted to know what they could do to improve themselves. So I personally talked to them after the names were sent up.
Thank you, Mr. Chair.
Delegate Pastor Chair, please.
Thank you. I'm Delegate Pastor from Baltimore County. And I point that out because that was ever so contentious. So I'm just going to get to the bottom line. Can you just give us the bottom line of what your primary takeaway was after the committee work? Because the reality is, whether anybody wants to say it, we know how we got to this point, why we're at this point, why we're even having this conversation. So what was your takeaway, the committee's takeaway, in terms of what needs to be done? Some of what I'm asking is rhetorical, but there are still people here who don't know about what we're really speaking. So can we just...
Yeah, let me say, what I took away from it is that it's not a perfect system, that there are arguments on both sides, but there has to be some changes to the nominating commissions around the state to make sure that it's diversified and it reflects people of all walks of life, not only in the big counties, but in the rural counties, Western Maryland, Eastern Shore, that sort of thing, because they've had problems also. And the other thing, as I mentioned before, my position has evolved, is that the irony is that years ago, African Americans had to run to get judgeships. Now in certain counties, African Americans cannot win in certain jurisdictions. So that's an irony there. But my take, again, is that we've got to make sure that the nominating commissions are broad, with people of all walks of life, and that when they submit the names to the governor, it's a good list of people from all walks.
Thank you. And that there's a good reason why we're so late. Would you agree? Because I have to ask a question. Would you agree as to why we have women, or let's say the diversity, because we haven't had a lot of changes for retention in the past? So we've had to come into the battle, into the storm. And that's why, when we look at the history. Okay, so when you talk about, and Delegate Tomlinson's points were well taken, I had to stand outside of Wegmans, just stand there, just pitch a tent and stand there so I could talk to people in my district, not about me, but about the judges, okay? So what folks don't understand, the education, would you agree, has to be a little different. Not that they should be out there all of the time, even though they were, okay? But that folks, unless they ever come before a judge, don't understand the gravity and the importance of what a judge does, not just for an individual, but for our society. It's critical. Can't we see it now? So, right, Delegate Grammer was right. They don't even know what we do. So, and we're probably more visible in some ways than the judges are. So what are some of the things that you're thinking about that we can do, all of us together, collectively, so that folks understand just how critical this whole system is? Because that's what America's supposed to be about, right? What the judges do, what happens in our courts. How do we do better?
You want to take that?
Aside from civics.
I can start off, Mr. Chair, that I think I agree wholeheartedly with you that we need to come up with some type of approach to inform citizens, regular people about the judiciary, what they do and so forth. Most people have nothing to do with courts unless it affects them or their child or their family or neighbor, what have you. But we've got to figure a way to not jeopardize judges, but at the same time give them an opportunity just to talk about the process and how important it is to democracy and that sort of thing.
Yes, and I agree. And this is something that state courts across the country are dealing with. There was for a significant period of time a drop-off in public trust and confidence in the state courts that actually the federal courts originally started higher and went lower. And of course, what most people see is the headlines from federal courts. But in the state courts in Maryland and across the country, we recognize that it's to us to try to enhance public trust and confidence. You had a bill earlier today that it's part of that to try to allow the appellate court to sit outside outside of Annapolis, to be in the communities, to bring people in order to see what it is that we do. We have programs. We have a program called Have Gavel Will Travel to have judges go out and make presentations. I made a presentation to a class of 5th graders that couldn't stop asking questions about what we do to try to help inform them about what we do. We have other programs like Reading in Robes, where we go into schools and interact with the children, and all of that is about trying to help explain what we do, where the courts fit into this system of government, and what our job is. And what our job is to be a neutral and impartial arbiter, where politics don't come into it, partisanship doesn't come into it, ideology doesn't come into it. Our personal preferences are shed to the maximum extent that we can to hear cases and decide them based on the law and the facts that are before us. And the greatest extent that we can explain to people that that's our role, that that's what we do, and then to bring that into the courtrooms is very important for how we're able to have public trust and confidence in the decisions that we make. And I agree completely with those who have said there is no perfect system, and all the concerns that have been raised are legitimate, and I understand that, and we don't discount that at all. This system is one that we think will enhance public trust and confidence in the judiciary by getting out from under some of the things that might raise political-related questions for a job that is inherently and must be apolitical, because that's what our job is, and we have a responsibility to explain that to the people, and we're trying to do that.
Thank you. Thank you.
Thank you.
Delegate Phillips now, please, and then Delegate Valentine, and then I think we're going to move to the next panel. There are several more. Delegate Phillips.
Thank you, Mr. Chair. And it was Delegate Griffin that I wasn't going to say a word, trying to be quiet, but it was Delegate Griffin's line of questioning and also Delegate Thomason that's really got me thinking about this. Currently, if I heard you correctly, the nominating commission process is an EO, right? And it's been an EO. Did the commission consider codifying the nominating commission process? And if not, would that potentially answer some of our concerns about maintaining some certainty between administration to administration to administration? Any thoughts on that?
I don't think we did. Yeah.
The issue was raised. There was no support within the work group for codifying this, and I think part of the reason is that each governor makes this determination. They've been largely making this very similar determinations over many years now, more than 50 years, to make a recommendation to interfere with the current discretion of the governor. Did not seem to be part of our charge. So it was not one of our recommendations. It is certainly possible that this could be done, and some states have taken that approach, but we did not see a reason to include that in our recommendations, mostly because of the current discretion. Didn't want to change the current discretion that governors in Maryland have enjoyed these past 50 years.
Would it take away the discretion to codify the governor would still have the discretion as to who he places on? I mean, I'm just trying to understand if we're relying on the process and we trusted the process, why we wouldn't codify it.
All I can say is that it was discussed briefly, but it was not a recommendation that our work group made. we just did not see the merit of it nor the importance of it compared to the other issues that were before us.
Thank you.
Delegate Valentine.
Thank you, Mr. Chair, and thank you, Chief Justice Fader, and all of your distinguished colleagues on the panel. All of my questions had been answered up until we got to the work group vote that was just touched on about I believe you said it was 15-3 with 2 abstentions?
Yes.
The only question I had is I've received a lot of documentation, a lot of testimony that I've tried to review, and it touched on, one of the comments was stated was, of the judges on the work group, a majority were appointed circuit court judges, including judges who had lost their seats due to a contested election, and the minority were circuit court judges who had successfully unseated gubernatorial appointees and were appointed despite the vetting process of not recommending their appointment. Is that an accurate statement as far as the makeup of the work group?
I don't think so.
Delegate, I think you're reading from the report itself, from the executive summary?
No, I'm reading from some written testimony that was provided to our committee by a constituent.
Yeah. Well, the intention was for there to be all viewpoints on this work group. And so judges who had been appointed and who survived a contested election were a part of the work group. Mm-hmm. Judges who were appointed but then defeated were part of the work group. Judges who applied by way of getting themselves onto the ballot and won their elections, they were included in this work group. All perspectives were invited and did participate and comprised the 20 members of this group.
But was it an equal composition, or was it more of one side or the other?
I'd have to go back and look to see what those exact numbers were, but I think the intent was that there be a mixture of all of those different perspectives among the judges, the sitting and retired judges who were serving on this work group.
Thank you.
Okay, that was the first panel. Thank you all very much.
Thank you.
Going to go now to the next panel in favor of the legislation. Dean Donald Tobin, Kelly Hughes Iverson, Janelle Ryan Colbert, Grayson Wiggins, Ron Jarischow, and then we are going to have the last panel of virtual people, people who are testifying virtually, and we'll hear from all of them in the next group so we don't have to switch back and forth. I see 3 of them. If it's only 3, then I will start to call some of the virtual people. All right, I'd like Amanda LaForge, please. All right. And Raphael Santini. Okay. We'll start, Mr. Wiggins, we'll start with you, move across, and then we'll go from there, please.
Good afternoon, Mr. Chair, members of the committee. Grayson Wiggins here on behalf of the Maryland Chamber of Commerce. I'll be quick. The Chamber was a participant in the work group, and on behalf of our membership, which includes businesses and nonprofits across the state, many of whom are plaintiffs and defendants in court, we just wanted to say us too and be here in support of the bill. Thank you, Mr. Chair.
Thank you. Good evening, Mr. Chair and Madam Chair Bartlett. I'm here on behalf of the Prince George's County Bar Association. My name is Janelle Ryan Colbert, and I am the current president. Really, most of what we had incorporated in our written testimony has already been stated. I'll really just highlight the 3 major components that we wanted to make sure that the committee was aware of. We can't really overstate the importance of the vetting process. Me personally, having served as a practitioner, practicing law before judges, being a part of a judicial nominating committee, and being a constituent for many years in Prince George's County, it's really important to make sure that that vetting process is intact and preserved. It's a very rigorous process. asks not just surface questions, it asks questions about your experience, about your character, about your demeanor. All of that is a part of the vetting process. Prince George's County, in particular, the Bar Association has their own judicial committee, and there are a plethora of other committees throughout the state of Maryland that also offers their recommendation as it relates to circuit court judges. So we believe that this vetting process is thorough, it's fair, and it ensures that the government can select from a pool of candidates who are not only technically qualified, but possess the temperament, the character, and the integrity. Additionally, an important component is making sure that judges that are appointed aren't upseated by judges who may not be as qualified and certainly have not been through the vetting process. And so we believe that this legislation would aim to serve that. We have seen it happen firsthand, and we understand how that impacts the residents of the particular counties that these judges serve. And finally, we believe that this bill will enhance safety of the judges serving in this state. We've seen the catastrophic consequences when judges are personally targeted by disgruntled litigants. Judges who serve in this state deserve to be protected, and we do believe that this legislation will improve their safety and reduce the risk associated with contentious elections. In conclusion, the Prince George's County Bar Association believes that the passage of this legislation is a vital step forward to creating a more efficient and just process. It will enable the governor to appoint highly qualified circuit court judges in Maryland. It will promote safety of the judges that serve, all while ensuring the excellence of our judiciary. Thank you.
Thank you very much. Mr. Jerichow.
Thank you. Members of the committee, my name is Ronald Jerichow. I am a former circuit court judge in Anne Arundel County. I lost in the 2010 election and went back into law practice. I was also a member of the work group. As you heard, it was a diverse group. As to Delegate Bartlett's question about checks and balances, a judge has really no actual checks and balances like you have in the legislature, the governor and the legislature. The only check against the bad judge decision is an appeal, which is expensive, takes a year or more. There's, unlike what you have here, which is a much better balanced system. But I've done in my position papers, I'm testifying on behalf of both the Maryland Association for Justice and myself, and in the MAJ paper, I did a study of how many votes there were. 1867 is when contested judicial elections were adopted by the Constitution. At that time, there were 72,000 voters in that 1864 election. Now we have over 3 million. In Anne Arundel County, for example, there were 1,900 voters in 1864. Now there are 311,000. I looked at also a study which I forgot to attach, which is the study of the 2024 election. In Anne Arundel County, for example, there were 204,000 people that voted for judge. I did a study across the state. Only about 30% of people who vote for the top ticket, either governor or president, vote for judge. We're a down ballot thing, and people just don't pay attention to it. And to answer the question I think Delegate Grammer was asking, which is, if we campaigned and spoke to maybe 5,000 people, 10,000 people, that is a fraction of anybody. We've got to raise money. Attached to my position paper is a chart I did in 2020 showing how much money has to be raised between $200,000 and $400,000. With that, I will say that we support the work group, the conclusions, and support this bill, and would ask that you give it a favorable report.
There should be some people here virtually. We'll go to see if Dean Donald Tobin is there. And that's fine. We'll hear from you for 2 minutes.
And I was there in person and had to get back to teach a class. So you all are more aware than I about your long days, and I appreciate all the work you do. President Schmoke also wanted to be here. He was a member of the committee and could not, but he has submitted written testimony to the committee. So you only have to hear from one of us. But I'm here, or I was there in person and now here because of how important I think an independent judiciary is. And we have excellent judges in Maryland. We have a system that's working. So you might say, well, why are we doing this? We're doing this to ensure our excellence, but also to ensure an independent judiciary. And one that is not subject to politics. Like I worked for a Maryland politician for 8 years early in my career. I know what it's like to campaign, but I also worked for a judge. Judges are not politicians. That is not their role. It is not what we want them to do. They are not there to be responsive to the citizenry. They are there to be fair, nonpartisan judges applying the rule of law. And our current system has those judges go through an incredible vetting process to make sure they're learned, thoughtful, nonpartisan, able to do the job. But when candidates run for election, they are not going through that process. So if we want to maintain the excellence of our judiciary, it's really important that we maintain a merit-based, non-political process. And that's what moving away from elections does. It provides an opportunity for a check through retention elections and through Senate confirmation. I understand that retention elections are usually successful. They should be. Our judges are excellent. They are doing their job. Retention elections are there when there's an abuse of power, when something is going wrong. And then you bring in the whole process to contest that. We don't want judges being politicians raising money from lawyers. We want fair, honest, nonpartisan judges. Thank you.
All right, Amanda LaForge, please. There she is, Amanda LaForge.
Thank you, Chair Clippinger and Vice Chair and all the members of the committee. It's a pleasure to be here with you all this evening, and I know you're all having a long day. I will be brief. I'm Amanda LaForge. I'm Chief Counsel to Governor Moore. And in my role, I have the privilege and honor of assisting the governor with performing his constitutional duty to appoint judges to Maryland state courts. He takes that responsibility incredibly seriously. He often says he knows that long after he is gone, the judges that he appoints to the bench in Maryland will be a lasting legacy of his. One of the first executive orders that the governor issued when he came into office was the executive order creating our trial and appellate court nominating commissions. And as you've heard from a number of other speakers today, we worked very hard to ensure that that executive order was focused on sort of expanding the universe of folks who make recommendations to the governor for judicial candidates. The governor instituted the first code of conduct that has ever been required of JNC members. And that's really to try to ensure that process is, whichever you've heard discussed, is quite an onerous process for the applicants. I think it should be, but the code of conduct preserves or ensures the transparency of that process. And I do want to give my thanks to the members who serve on these judicial nominating commissions, lay people and lawyers who spend a lot of time ensuring that we get the highest quality candidates. One other thing that I would like to touch on regarding judicial elections is I do hear a lot from very well-qualified lawyers throughout the state that they choose not to apply for judicial vacancies simply because they are concerned about going through elections, and sort of that process is something that they're not interested in doing. We ask our judges to be neutral and unbiased, and I think campaigning for many of them does not seem to fit with that mission. And then I'll just say finally, this body last year passed the Andrew F. Wilkinson Judicial Security Act, which was greatly appreciated, I know, by many of our judges, and of course supported by the governor. We unfortunately live in a time when threats of violence against the judiciary are becoming increasingly common, and I do feel that being out and campaigning is something that puts judges at risk. So I appreciate again your time today and urge a favorable report on this bill. Thank you.
Thank you very much. We will take questions for the people who have testified up to here. There are some more people who are going to testify virtually, but I think we've gotten to about 5 or 6, and so that's fine. Delegate Williams.
Thank you, Mr. Chair. I was going to ask Ms. LaFord, is there anything else she wanted to add? I know the governor has been. Oh, sorry.
Now it is.
Okay, it might help if the mic is on before I start talking. Thank you. Hi, Ms. LaForge, it's good to see you. I know the governor has been very diligent about the individuals that have been appointed to the nominating commissions through his executive order. There was some conversation, and even in some of the written testimony that we had received proposing codifying kind of that process. And I don't know if you all have a thought or with regards to that comment that was stated earlier or in any of the written testimony.
Thank you, Delegate. I think I agree with the earlier witness who said that, you know, these judicial nominating commissions have been used in Maryland since the 70s. They really are considered kind of the gold standard for vetting and screening judicial applicants. I think that each governor who has come in to office has been able to make them their own in a certain way, and I think that that's a privilege that the executive should have. As we know, the governor is constitutionally the one responsible for appointing the state's judges, and I will say, based on my experience working with Governor Moore, he has been incredibly well served by the JNCs, and the quality of the candidates that we receive through the JNCs are really, really exceptional. It's a real testament to not only the work of the JNCs, but also just the legal community in Maryland, which I think is really top notch.
Okay, thank you.
Further questions? I now, after shutting some people down a little bit, have to take a little bit of indulgence. Dean Tobin, I have a question for you. I went to law school at night, and I know how difficult it can be working with law students who have to work during the day and then come in and take classes at night. Is it true that one of your students is a gentleman named Hunter Marsh?
I think I'm probably not supposed to comment on our student body under some disclosure, but I teach at 635, so I could probably. I also went to night school, so I understand.
I can appreciate that. Well, if perhaps he was one of your students, you let me know if he's any problem, would you?
I'll happy to do it.
That's fine. Thank you very much. Thank you for
having us.
No lobbying for grades for Hunter. All right, seeing no more questions for this panel. Thank you very much. Thank you very much. We'll go to the last panel who are testifying virtually. Thank you very much. Kelly Iverson, who I saw pop up, Elizabeth Hewlett, Tim Maloney. Ralph Watkins is testifying virtually and is favorable with amendments, so we'll bring him up. I think that's everybody. So if we could, okay, so Mr. Watkins popped up first. He is favorable with an amendment. So we'll hear from him first for 2 minutes, and then we'll make our way through the remaining people. Mr. Watkins, and then Mr. Santini. I missed Mr. Santini. We'll get to him too. Mr. Watkins, please, for 2 minutes.
Thank you, Mr. Chairman, members of the committee. My name is Ralph Watkins, and I'm speaking on behalf of the League of Women Voters of Maryland. We just want you to focus on what is the role you want the voters to play in this process. And in our testimony, we noted that there is a need for judicial evaluation commissions to provide information to the voters. Otherwise, voters are left in a vacuum with no information about the candidates for judgeships. And I'm speaking of retention elections here. Our experience has been that judges do not respond to our questions for the voter's guide. So when we send out the voter's guide in Montgomery County, it's 100,000 people get it. We have nothing to say about the judges. And the most frequent questions we receive from voters are, where can I get information about the judges? Or, why are we even voting on judges? There's a very strong sentiment, even among voters, that judges should be insulated from the political process. So that is what I want the committee to pay attention to, is what is the role you're asking the voters to play, and please take some action to ensure that they are provided the tools to play that role meaningfully. Thank you for your attention.
All right, Mr. Santini, please.
Good afternoon, Chair Clippinger, Vice Chair Bartlett, members of the committee. My name is Raphael Santini, and I am president of the Maryland State Bar Association, where we represent thousands of legal professionals across the state and serve as the voice of the profession. I am testifying today to support House Bill 778. Also, I appear in front of you as a naturalized citizen, an attorney who's been practicing for over 3 decades, and past president of the Hispanic Bar Association. I have 8 points that I want to stress. The only judicial officer that has to run for a contested election is a circuit court judge. That's not appropriate or fair. An administrative judge does not have to run for a contested. A district court judge does not have to run for contested. An appellate court judge does not have to run for contested. A Supreme Court judge does not have to run for contested. 2, the appearance of impropriety by accepting donations in order to run a campaign fund. How ridiculous is it that a person who's been appointed a judge has to go begging for money from lawyers who will appear in front of them? That creates an appearance of impropriety to the citizens of Maryland. 3, the contested judicial election is not a true election. The basis of a contested election is debate. A judicial officer cannot debate under the canons of judicial ethics. 4, the loss of respect and legitimacy in the judiciary. When an individual who is not vetted and has been elected by the citizenry is determined to be unqualified, that individual has to be removed. The problem is that that becomes a public event. And for example, the example, unfortunately, is Judge April Dumali, who was on the Daily Record many, many times. The Supreme Court actually had to remove her. That person was not qualified, was not vetted, and won election. 5, contested elections create judicial security issues. Judges who run for election do not have security around them. Also, judges do not have security. And the example there with Judge Wilkinson, contested elections have a chilling effect on applicants. Many a district court judge, many of an attorney has told me, I'm not going to go run because if I run and I lose the job that I used to have. Lastly, creating judicial elections do not reduce diversity in the judiciary. Recent elections have had the opposite effect and actually removed female judges and people of color from the bench. And the examples are Rodney Warren in Anne Arundel County, Judge Jackson Stevenson in Anne Arundel County, Judge Stanton in Howard County, and Judge Alexander Wright in Baltimore County 2 times. And 8th, retention elections do give the citizenry an opportunity to have a voice. Thank you. We appreciate your time. And Maryland State Bar supports House Bill 778. Thank you again.
Thank you. Ms. Iverson, please.
Thank you, Mr. Chair, Madam Vice Chair, distinguished members of this committee. My name is Kelly Hughes Iverson, and I appreciate your hearing me today. As it happens, I also went to night school. I serve as co-chair of the Maryland State Bar Association Laws Committee, which is an arm of the MSBA that reviews and advocates on bills in our ongoing efforts to advocate for the legal profession, preserve the integrity and the independence of the judicial system, and improve access to justice. And as such, we urge a favorable report on HB 778. From the perspective of the MSBA, elimination of contested elections is essential to public trust and judicial independence and to maintaining those values. Judges must be able to apply the rule of law in an impartial and unbiased manner without even a perception of undue or improper influence. When my clients walk into court, they don't want to know if they have a Republican judge or a Democratic judge. They want to know that they have a fair judge, an impartial judge. Yet under this current system, appointed circuit court judges must run in an election within 1 year of their selection to remain on the court. Judges, therefore, must immediately focus their time and their energy on fundraising and campaigns. Those are things that are not unknown to the members of this body, but they're unlike the legislature, which is an inherently political and policy-making body. The judiciary is inherently apolitical and should not be a policy-making body. So when the courts are fundraising, the appearance of sitting judges accepting campaign donations from contributors, which includes attorneys and litigants who have cases before them, undermines the public trust in an independent judiciary and may discourage candidates from applying for the bench at all. HB 778 provides a balanced approach to selection, maintains the important element of public review from retention, and maintains a check on getting judges that way. And we would report. Thank you.
Ms. Hewlett. Go ahead.
Okay. Good afternoon, Chair Clippinger and members of the committee. I'm Elizabeth Hewlett, an attorney in Prince George's County in Maryland for over 40 years. I'm former chair of the Sitting Judges Committee in Prince George's County and over 20 years on the Maryland State Bar Association Judicial Selections Committee. I wholeheartedly support the House Bill 778. This is such a critical bill because the current dual approach is very, very problematic, the appointment and the contested election approach. In addition to the reasons you already heard, the judicial fundraising conundrum, et cetera, here's my main reason. One approach mandates extensive vetting to ensure that we get the highest caliber, best of the best serving our citizens in Maryland. The other approach, no vetting or evaluation required. Let's take the judicial appointment process. Applicants complete a 20-plus page application disclosing comprehensive professional and personal details, where they live, number of jury trials, bench trials, a number of personal information, lawsuits, divorces, things of that nature, key cases, opposing counsel, all of those things to be evaluated. Then they are interviewed by 14 bar panels, state, county, women's, trial attorneys, minority bars, evaluating their intellect and their preparedness. They then go to the Judicial Nominating Commission, who reviews the applications, assesses their intellect, integrity, work ethic, timeliness, reputation for fairness, the respect with which they treat people. That judicial temperament is critical. And then they evaluate the breadth of experience, private sector, public sector, civil, criminal, jury trial, and all of that. And then they go on to the governor if they make the cut from the Judicial Nominating Commission, and the governor makes his or her own assessment. Juxtapose that against the vetting process, against the current election approach. Candidates need only be 30 years old, be a registered voter, live in Maryland for 5 years, pay a filing fee, that's it. No experience required. It bypasses all that vetting. And how does that benefit Marylanders? So this bill provides the best of both worlds, and I wholeheartedly support this bill. Thank you very much.
Questions for the panel. Delegate Arikan.
Thank you, Mr. Chair. There's been a lot of really impassioned arguments for this bill, but I just have to say I feel the constant invoking of Judge Wilkinson on an election bill to be offensive. He was not killed because of judicial elections. He was killed because he did the right thing. That needs to be said. And going forward, it'd be great if we could hear about just judicial elections and not invoking a man who can't talk for himself any longer. So we don't really know how he felt about this, and who died for completely unrelated reason because he stood up for a family who desperately needed his help, and he did the right thing.
Delegate Kramer.
Thank you, Mr. Chair. I have a question for the young lady on the nominating committee. We keep hearing about the conflict of interest and having attorneys donate to judges. Isn't there a conflict of interest when the attorneys community is pretty much the only group selecting a judge in a fairly closed system? If we have such a problem with those attorneys donating, what we're proposing here is to have the attorney community nominate the judge in a closed system and have every other part of the process eliminated. Isn't there a bit of a conflict there?
I'm sorry, I don't want to jump in. I'm not sure. Was there a question directed to me?
It was directed toward the young lady on the nominating committee. The young lady dressed in red, please.
Oh, you know, when you say young lady, that kind of threw me. I'm sorry. Okay.
I'm sorry, I can't see your name.
No, but I'll take it. I'll take it. Your question is the fact that these judicial nominating commissions evaluate people in a closed session. You think that's, are you asking, is that unfair to the public?
Well, anyone who's actually criticized the process, they've criticized it and saying, and it's been Democrats and Republicans, and they say, you know, you need to know a lot of these people. And I think there's value in judging a person by a lot of these qualities, but it becomes, you know, you're going to a closed community who therefore is nominating you, and the public doesn't get to say anything at all. And if we have so much of a problem, if we have to go to the attorneys to donate money, which you don't have to do, and that's a conflict of interest, you're essentially going to a small group of people who is therefore choosing you to be the nominee in our judicial system. And I think there's a bit of a hypocrisy there.
And I respectfully disagree with you. Number one, these people, by the time they get to the Judicial Nominating Commission, which I wasn't on, I was on the State Bar Judicial Selections Committee, two different things. But having said that, by the time you get to the Judicial Nominating Commission, you have been before 14 other bar associations or entities, and you have been really evaluated. That questionnaire is so rigorous and comprehensive. All of your personal business is out there, and that application gets sent everywhere to all these different associations, to the Judicial Nominating Commission. And so you are really and truly vetted. I mean, comprehensively, your personal business, your spouse, your kids, you have to name all of that in those applications. Any divorces that you have, any lawsuits that have been filed against you, anything that you have been through is all on that application. And so when you get to, by the time you get to the Judicial Nominating Commission, they are reviewing the reports from all 14 of those other entities, plus your application, plus your references, plus the letters that have been submitted. And some of those letters are for and against these people, because people can send in letters unsolicited or call people unsolicited. And so then they evaluate and try to make the best of the best. They don't choose somebody to be a judge. They evaluate everyone to see who's eligible, who's qualified to be a judge, and they leave it up to the governor to then pick based on all of the information that took place beforehand. And
I'm sorry, please finish.
And I just think that, so it's not just that they're choosing a judge, but it's everything that's filtered to them, and they are really trying to evaluate the best of the best, because they live or work in the jurisdiction too. We want the best of the best. We all do.
But
I'm sorry,
even
I'm
including,
very passionate about it.
I know, I get it. I appreciate your passion. Even including all of those other associations, isn't it still a very, very minuscule world, considering the breadth of the public who, frankly, doesn't get any input at all?
Well, okay, two things. You heard Judge Simpkins mention earlier the town halls. You asked that question, and she did town halls, and I heard your response to that the system works. But it was very, very, very hard for them. Very hard. I attended those town halls. I saw delegate tolls at some of those town halls. So it's very, very, very hard for them to do this, and particularly when they have to be on the bench. They do a disservice to the citizens that the bench is supposed to serve, because they're taking away from sitting on the court during that time, and the other judges have to cover for them. It is very, very, very hard. And so people get to, but the main problem is education. I agree with that. We do need to educate the populace, because they're really not interested. You heard someone say that by the time they get down after the president and all these high positions at the top of the ballot, it's only 30% of the people voting for judges at that point. They just don't know. And the judges can't really campaign as well as other advocates can, as other candidates can.
If you see this gray hair, sometimes things are very, very, very hard, and I don't think we always get to eliminate that, but I appreciate your answers.
Thank you.
Thank you, Mr. Chair. And my question is also for Ms. Hewlett. You've talked extensively about the vetting process. I've heard about this over and over. I've talked to judges in both of the counties that are within my district over and over about this process. But my question pertains to, they go through this process, they're not selected. They go through this process, they're not selected. They do this 3, 4, 5 times. What other recourse do these candidates and these very qualified applicants have if you take out the election process?
Well, you know what? I heard the question asked a little earlier, and I think Chief Justice Fader tried to answer it, or someone tried to answer it, in terms of what happens, what should happen if persons go through that extended process and go through the vetting and aren't selected. But usually, and I think Delegate Toll said the same thing, there are usually very few positions open, and there may be a pool of several very, very highly qualified candidates, but there may be a limited number of vacancies. So that's not to say that that person who applies over and over again isn't qualified. It just may mean that this other person was more qualified. But also, the question was asked earlier about whether the commission can provide feedback on what an applicant could do to improve their success. It may be that somebody else was more qualified, or there may be something in that person's past that makes them ineligible, and we just don't know about it. I can't speak to it, but it would be helpful if they were able to have some feedback.
May I respond to the delegate's question? Mr. Delegate? The response to your question is you keep on applying. I know around the state, 2 circuit court judges that had to apply 7 times to get accepted. That's the solution. Thank you.
We had one in Prince George's County. She referred to herself as the Susan Lucci of the bench. It took her like 7 or 8 times, but she got there. She was eminently qualified, but so were others.
Okay. Delegate Tolles.
And I think, I'm going to say Betty, because we're friends. You could call me Karen, you know that. Talked about it. I was at those town halls. So can you talk about, and I was at town halls, Judge Simpkins, so I understand the importance of that. Can you talk more about that education process? Because I want my colleague on the other side of the aisle to hear more about the education process and what that looks like as we educate the community on the work that the judges do, the very important work that our judges do. Thank you, Ms. Hewlett.
Thank you, Delegate Tolles. Thank you, Mrs. I think it's imperative. I think we're working on it, and this has been more in more recent years, honestly, to be candid, in terms of the judges getting out there and trying to explain the importance of what judges do, because a lot of people, I've talked to people who say, okay, what's the big deal? Well, you get in somebody's courtroom, God forbid someone in your family was murdered, or something tragic happened, or you have a custody battle and you're fighting for your child, and you want somebody with tremendous expertise. So it's important for the public to know the magnitude and the complexity of the cases that these judges hear, and why it's important if you find yourself in court one day. It's critical. But, it's not on the forefront of people's minds all the time, because most of us don't go to court all the time. I mean, most citizens don't find themselves in court all the time. So it's important to have that education. And I think we're increasing the opportunities to provide that education. And I applaud this last panel in Prince George's County, in which Judge Simpkins was one of them. And I went to those town halls. As I said, I saw you. They were powerful, but we do need to have more. We do need to increase it so that people understand, hey, this really is important to you. Don't think this is something over there that should be kept in a vacuum. This is relevant and important and critical.
Absolutely. Thank you, Mr. Chair.
Seeing no further questions for this panel, thank you all very much. Now going to hear the panel in opposition. Rob Daniels, Claudia Barber, Maria Osterreicher, Mary Lynn Pierre. Also on the list is Ricky Jones, but he was going to be virtual. We don't have him. So everybody else, if you want to come to the table, please. Everyone's going to get 2 minutes. And normally I start with the person who's on my right, your left. So please, if you'd like to begin your testimony.
Sure. I'm just going to read so that I don't run out of time. My name is Maria Oestreicher. I am a judge on the Circuit Court of Carroll County. I was a member of the work group to study judicial selections. I am here today in my individual capacity and not as a spokesperson for the judiciary. I was elected to my position after running against a gubernatorial appointee in November of 2018. I did so to become the first female in the history of Carroll County. The county nominating process, or whatever it was, from 1775 when the county courts were formed, had failed to ever put a female or any other underrepresented party on the circuit court. It was not an off-the-cuff decision. It was a very difficult decision at great personal expense to myself. But I believe that this bill does not do what the proponents indicate or believe that it will do. It does not require the governor to choose from one of the vetted names on the list. It does not remove, all it does is remove any opportunity for anyone to challenge the person that is named by the governor. This bill could have started, we could have started by codifying the judicial nominating process, which was discussed by members of the work group, but I wasn't a chair and able to submit the questions that we voted on. So that was not a question that was voted on. So I don't know what would have happened if we had voted to codify the judicial nominating process, which is one of the recommendations that I believe the minority, I don't know without a vote, so I don't want to speak for them, but I certainly was advocating for that process for the exact reasons that these questions were asked today of the other panels. I'm also here today, I think, at great expense to myself. I'm not saying that I expect ramifications, but please understand the difficulty that my boss is sitting right behind me and was on the other side of this issue. So, well, my time is up, but my point is that I think that there are many other options that would address the concerns that people have about judicial selections. I personally applied 4 times. I went to those 14 interviews 4 times. I've put myself through the process. That's one option. Require anybody that runs to first have applied. That's an easy solution. But we've jumped right to the extreme, which I think taking the rights out of the voters' hands is not the right way to fix the problem of judges campaigning, if that's the problem that people want to fix. Thank you.
Esteemed committee members, my name is Rob Daniels, and I'm here in opposition to HB 778. I'm the current president of the LGBTQ Bar Association of Maryland, and I was a 2024 candidate for judge of the Baltimore County Circuit Court. In its 366-year history, Baltimore County has never had an openly gay person appointed to the bench, despite highly qualified and thoroughly vetted persons having applied, myself included in that group. And that's exactly why I took my argument directly to the people, just like the Maryland Constitution permits me to do. The impetus for this bill seems to be the false conclusion by the work group that we've resolved the diversity issue, so popular elections are no longer needed. But the work group has moved the goalposts in the diversity fight by ignoring the dearth of LGBTQ judges in the state. Governor Moore's executive order regarding judicial selections directs that individuals of diverse sexual orientation shall be encouraged to apply, and that the commission shall consider the importance of having a diverse judiciary. But this isn't happening in most counties. If LGBTQ people aren't being appointed to judgeships by the most progressive governor the state has ever seen, when will we be? Sometimes it falls to marginalized populations to fight for their own rights in a way that political figures simply cannot or won't. This bill is a rushed effort to soothe a vocal minority in the legal community. The people deserve a comprehensive approach, and the work group recommended this comprehensive approach if the judicial selection process is to be changed, not a piecemeal quick fix. I'm not going to relitigate my campaign. I'm simply going to say that homophobia is insidious, and there are people who will do or say anything to make sure gay people do not ascend to positions of prominence within society. In conclusion, in a time when so many are worried about our nation's slide toward autocracy, this is the time to reaffirm the powers reserved to the people. Sometimes the boldest action is no action at all. I urge you to vote against this bill.
Ms. Barr.
Thank you. Today, our state legislature seeks to replace the state circuit court's current open judicial election process to a more limited judicial retention process where voters would not have the same input as voters have now in the current open process. I appreciate and applaud those who raised questions about the fact that there are 5 and 6 times that people have gone up for an application and gone through the Judicial Nominating Commission process and have not been picked. Well, if they keep doing that year after year after year after year, first of all, there has to be a vacancy. Secondly, they have to be picked. And if they're not picked, they've lost. So that open process should remain there. There are many county circuit courts in the state that lack diversity. They include the circuit court for Anne Arundel County, right down the street at 8 Church Circle. It has no Hispanics, no Asian Americans, no Native Americans on its bench, and no African American males. Other circuit courts lacking African-American male judges include Charles County, Montgomery County, Carroll County, and rural counties. The real problem is that the trial court judicial nominating commissions continue to keep it that way by practicing exclusion when it shortlists candidates for the governor to appoint. When Governor Marvin Mandel created his executive order decades ago establishing these judicial nominating commissions, someone recognized it was not an imperfect process. It is and remains so. The fact that there have been less than 6 African Americans, no Hispanics, no Native Americans, and no Asian Americans in the 300+ year history of the Anne Arundel County Circuit Court exemplifies the insidious glass ceiling created by the Judicial Nominating Commission process. We don't need to switch to a closed process. Thank you.
Yes, Mr. Chair, is just a yes or no question for Ms. Barber. And I'm not taking a position, I just want your opinion. Do you think that part of the issue, yes or no, is that the legal establishment, the nominating committees, the legal establishment is somewhat clubby?
Yes, it is clubby, and to a certain degree, it also is political. It's cliquish. It's all of that, which is why oftentimes the best is not always chosen.
Thank you.
Thank you, Mr. Chair. Mr. Daniels, do you think that if we close the system, it would be prohibitive to for the LGBTQ community to participate in the system? Closing the system by going to retention elections? It would certainly be tempting for a governor who has no scrutiny to face to do what he or she would want to with the process. I'm not here to minimize the fact that there might be a little bit of shame. Sometimes, lawyers are supposed to pretend in these processes that the people actually appointed are the best, and then that's the end of discussion. These things happen in real life, and conversations happen in real life, and even in my campaign. We're allowed to talk about the fact that some of us are more qualified than some of the folks that are judging us now. And so no, yes, I do think that closing the process would insulate that criticism aspect that many times keeps us honest. Excellent, Beard. Thanks so much. Thank you.
Thank you, Mr. Chair. Just kind of piggyback off of what Delegate Kaufman asked. I'd like to ask that same question to you, Judge Oestreicher, about is it a little clubby inside, an inside baseball kind of game Obviously, like you said, you're the first woman to get elected to the circuit court.
To ever be on the circuit court,
yes.
elected or appointed.
Yes, yes. And this was in 2018.
18.
Yes, not 18.
Right.
18, yes. Yeah, so anyways, can you comment on that?
I can. I will add that I campaigned next to the delegate as he campaigned for the sitting judge. No hard feelings, because I signed up for that, and I understood that. And until I decided to run, I always supported the sitting judges, which is why I say it was not an off-the-cuff decision. I only did it because on that list, which I was not on, were qualified women who were, again, not appointed. And it was literally a last resort if we wanted to see a woman on the bench in Carroll County. And it's difficult for me to answer that question honestly. I'm going to, but please understand the difficulty that I'm going to have in doing it. I ran against someone who was the third member of the same law firm to be on the bench that only has 4 seats. So when you talk about just running again, and with all respect to Mr. Santini, just running again isn't an option when you have a county with only 4 seats, and it's a 15-year term. You can't just keep running again. I ran as many times as I could. 4 times is a lot in our jurisdiction. We only have 2 district court judges and 4 circuit court judges. So I personally believe, I don't get feedback from my commission. I know word of mouth and I know rumors, and I was a very effective domestic violence prosecutor. I was called a man-hater. I was called aggressive. What I was an effective, well-spoken, strong, independent woman. That's not allowed. And so I just kept being told it's not your turn. So I decided that it was my turn. So yes, it was clicky for me. Can't speak for everybody.
Thank you.
Seeing no further questions, thank you all very much. And that concludes the testimony on House Bill 778. We're now going to Delegate Wu, who's been exceedingly patient on the front row, House Bill 44. Delegate Wu, I think it's Delegate Wu. Delegate Wu, please.
Thank you, Chair Clevenger and Vice Chair Bartlett, and members of the Judiciary Committee. This is my first opportunity to come to this great committee. I waited here for 2 hours already. So. And I applaud all of you sitting here the whole afternoon. Thank you very much. I got a coffee, I got a snack from your kitchen, and Dennis is so graceful there. Thank you. Okay, I'm going to. For the record, I'm Delegate Chao, District 9A, presenting Bill HB 144. The bill requests that circuit judges to be elected in a non-partisan way during the primary election. I feel this bill is much less controversial than the bills that come before me, and it's a tiny change, but it can have a big impact to both the election result and the voter participation. Unfortunately, a representative of Maryland Board election who originally scheduled to provide information could not show up due to incremental weather and have a schedule conflict as well. HB 44 resolved a long-standing voting concern in the circuit judge election in the primary process. Right now, voting for circuit court judges in Maryland are conducted in a partisan manner. We have a Democratic ballot for Democratic voters. We have a Republican ballot for Republican voters. However, we don't have a ballot for unaffiliated voters. The bill is going to change that. Our judicial system must inspire trust and confidence in every Marylander. Yet under the current law, around 900,000 unaffiliated voters who make up almost 25% of our registered voters are completely shut out of the judicial primary elections. judges should not be seen through the lens of political affiliations, but of the partial steward of justice. House Bill 44 ensures that all Marylanders can select judges based on qualification, experiences, and character. Let's look at some numbers. In and around the county, out of 417,000 voters, there are 105,000 unaffiliated voters. In Baltimore City, out of 404,000 voters, there are 65,000 unaffiliated voters. In Baltimore County, out of 587,000 voters, there are 122,000 unaffiliated voters. In Carroll County, out of 131,000 voters, there are 31,000 unaffiliated voters. In Frederick County, out of 208,000 voters, there are 55,000 unaffiliated voters. In Howard County, out of 241,000 voters, there are 64,000 unaffiliated voters. In Montgomery County, out of 699,000 voters, there are 176,000 unaffiliated voters. In Prince George County, out of 625,000 voters, there are 104,000 unaffiliated voters. Look at the numbers here. There are a huge portion of voters who are not able to vote in our primary election for judges. Maryland Circuit Court handle the majority of our state's most serious criminal cases and complex civil matters. These courts touch the life of countless Marylanders each year, making decisions that affect families, businesses, and individual rights. However, our current system prevents unaffiliated voters from participating in the primaries. This means hundreds of thousands of Maryland voters are denied a voice in choosing the judges who may one day preside over the cases that dedicate their lives.
Delegate, thank you. If you would wrap up, please.
Yes. So I would say House Bill 44 makes three key improvements over the current judicial system. First, and most importantly, guarantee all the registered voters can vote in our primary. Second, and this legislation established two nonpartisan judicial elections. Third one, the bill creates an inclusive election process where top candidate goes forward. So basically, I'm urging a favorable report on this bill. This reform represents a significant and necessary step.
Thank you.
Thank you.
Thank you very much. Delegate Congolo with a question, please.
You know what? I guess I'm just seeking clarification. Thank you, Mr. Chair. Okay, so just so I'm clear, the circuit court judges are not on the ballot for unaffiliated voters during the primary election.
Yes.
They're only on either a Republican or a Democrat ballot.
Yes.
Okay, and I wasn't aware of that because I know the Board of Education is nonpartisan, but that race is on the unaffiliated
Yes. So
ballot.
right now, board election is nonpartisan, and so every voter will get a ballot. But for circuit judge, only Democratic voters and the Republican voters that will show up on their ballot. So independent unaffiliated voter couldn't vote because they don't have ballot.
Right. Okay, thank you.
Yes, thank you.
Thank you, Mr. Chair, and thank you, Delegate Wu, for this bill. This is exactly a bill that I was trying to put together, but ran into an issue. Pretty much what my colleague said here is that in some spaces, the judges are not considered nonpartisan because of the way they run for office. When they, I believe, sign up to be candidates with the Department of Elections, they actually have to say whether they are Republican or Democrat, which I ran smack dab into a wall and, just could not put the bill forth. But I'm hoping that you've worked through all the kinks and we're there now. In a primary, our unaffiliated voter can't vote unless they walk in and ask for an unaffiliated ballot. Is that right?
No, isn't the circuit judge names are not showing on their ballot.
Right, and that's
even
that's
yours, they were not showing on your ballot because they are unaffiliated.
And they don't get to vote for judges until the general election.
Yes, exactly.
And your bill changes this how?
And then, like, circuit judge elected on nonpartisan base, like school board member, right? So every voter will get a ballot. The judge's name showing on their ballot, whether you're Democrat, Republican, or unaffiliated.
In the primary or just the
In the
general?
primary.
So no matter, you know, if I'm unaffiliated and I'm participating in a primary, where do I go to get this ballot?
Just go to polling station, right?
Any polling station I can go to, and I can say that I'm unaffiliated, and they should be able to give me a ballot.
It's not that you're saying, because you register with a party, right?
Yeah,
so
I get
based
that.
on that registration, they will give you a ballot. So if you're unaffiliated, if there's no school board member, probably you don't have ballot because nobody was showing on your ballot because judges are only showing on voter for Democrat or Republican.
I think you've worked it out. Thank you. Yeah.
Further questions? Seeing none. Thank you very much. We'll now hear from one person in opposition, Claudia Barber.
Thank you.
Thank you. Ms. Barber, please, for 2 minutes.
All right, I have a brief opposition. The bill is designed to deny independents and third-party voters the right to use the open process to run for certain elected offices. This may be in violation of constitutional rights of voters to freely join third parties of their choice. I chose to join a third party in 2024 and advance in the general election in 2024. This closes that opportunity automatically. It serves no useful purpose other than to target independents and third-party voters so they no longer have free access to voting. It further demands that they become members of one of the two major parties. Otherwise, their rights to run for all offices is no longer available. It simply penalizes independent voters. Before voting yes on this legislation, please reconsider the impact this legislation has on the community and on individuals.
Questions? Seeing none. Thank you very much. That concludes the testimony on House Bill 44. And we say good evening now to our good friends from Ways and Means who have been here for the better part of the afternoon. Sad to see them leave. But now, everyone, don't be too sad because here are our friends from Environment and Transportation who are here, including Delegate Deborah Davis, who is back in the Judiciary Committee, Delegate Ziegler, and Delegate Jacobs. Now, Delegate Phillips. We have quite a few ready to go here. We have 4 people who signed up virtually. I'm going to name them first just to make sure that we still have them. I am. Charmin Leon? No. Chris Burbank? No. Tia Holmes? Yes. Scarlett Neath? No. All right, so the first panel will include the public defender, Natasha Dartig, Debbie Levy, Daniel Boda, and then we have Tia Holmes, who is virtual. Join me. Well, I think we're going to just stick with these. We'll stick with the people I called here, and then we'll do that next group of virtual in a second, because this is what the delegate asked for his first panel. These are the people who are still here, and we appreciate it.
Thank you.
Delegate Phillips for 3 minutes.
All right. Good evening, everyone. Chairman Clippinger, Vice Chair Bartlett, and members of the committee. I'm jumping right in. Today, I'm requesting a favorable report on House Bill 635, the Secondary Enforcement and Admissibility of Evidence Bill. You have my written testimony, and I ask you to refer to it instead of just reciting my written testimony. I want to share a brief story. In 1983, I graduated from college. I was really fortunate. I was hired by a Fortune 100 company and earned enough money in my first year to buy my first home. Following that first home, I bought my first new car. That new car was a 1983 Nissan Maxima. It was one of the hottest vehicles on the market at the time. The car was before its time. It actually spoke to you. A voice would say, your door is ajar. Your lights are on. Your fuel level is low. This car brought me all kinds of attention, both wanted and unwanted. Over the course of about 6 months, I was stopped at least 8 times. I was stopped for headlights, turn signals, rolling stops, speeding. I deserve that. The most embarrassing moment of my life, literally to the day, occurred one evening when I came home from work, dressed in a suit and tie. I got out of my car, and a police officer pulled up beside me. He told me to put my hands on the roof of my car. He got out, he patted me down, and asked me for my license and my registration. This is 1984. When he realized I was the owner and I was standing in front of my house, he told me I was driving a car that was frequently stolen, and he was doing me a favor. While I don't believe pretextual stops are as common today as they were 40 years ago, the statistics suggest that these stops still occur, where 46% of all Maryland registration and equipment stops involve African Americans, while African Americans make up only 30% of the state of Maryland. When in my county, Baltimore County, according to the 2023 traffic stop data, 65% of these administrative stops involved African Americans, when African Americans make up 32% of the population. This is not fair nor equitable. This bill seeks to reclassify certain non-dangerous, mostly administrative vehicle violations. A police officer would need a primary violation like speeding, reckless driving, dangerous lane changes, or some other probable cause to pull a vehicle over. I'm going to skip down. You'll hear from opponents who will argue that such stops can lead to discovery of other legal infractions, such as guns and drugs. While I understand law enforcement's perspective, I ask you to consider this. Shouldn't African Americans and all individuals have an expectation of being treated fairly, respectfully, and without bias during traffic stops? Equal treatment under the law is a fundamental principle of democracy protected by the Constitution, specifically the Equal Protection Clause of the 14th Amendment. There are a number of amendments, and I'll offer those when somebody asks me a question. Thank you.
Good evening, Chair, Vice Chair, members of the committee. The Office of the Public Defender supports HB 635. Thank you to Senator thank you to Delegate Phillips for his leadership in bringing forth the bill. The truth is, almost every African American or Latino Maryland can tell a story about being pulled over by the police for no apparent reason other than perhaps their skin color, especially if it happened to be driving in the wrong place at the wrong time or the wrong car. Victims of these racially motivated traffic stops find themselves in situations that we call driving while black. Legislation is needed to fight this racial injustice. 2022, Black Marylanders made up 30% of the state population, accounted for over half of the arrest, and 70% of the prison population. The racial disparity is also seen in traffic enforcement. The problem continues. 2023 data reveals that police stop black drivers at a rate 10% higher than white drivers. Research also tells us that non-safety related traffic stops lead to unnecessary escalation and use of force, disproportionately affecting black drivers. Black drivers are 2.9 times more likely to experience use of force incidents during traffic stops. Data from Maryland highlights that this significant disparity as well. Black people account for 43% of all traffic stops and are more likely to be searched or arrested during these encounters than white drivers. Research is clear that HB 635 will help in 4 key areas: improve traffic safety, improve community trust, spare drivers the dangers of traffic stops, and reduce harmful racial disparities. I ask that you take steps to erase racial disparities, elevate policing, and please enter a favorable report to HB 635. Thank you.
Okay, thank you. Good evening. My name is Debbie Levy with the Office of the Public Defender. In 2023, almost 500,000 people were stopped in Maryland for traffic violations. Nearly half of those stops, 211,714, were for registration and equipment violations. That's over 200,000 people who were stopped in a year for a registration or an equipment violation that could be addressed in another way. These stops are not an efficient use of law enforcement resources. Of the 482,299 people who were stopped for every violation in 2023, only 4,110 of those resulted in an arrest. That is a 0.008% arrest rate. And the low-level violations, that's just for equipment and registration, only 1,300 of those ended in an arrest. That's a 0.006% arrest rate. To imagine the number of people affected by low-level violations, it's like filling Raven Stadium 3 times and stopping every person there and arresting less than 1,000th of 1%. These are, as they say in baseball, terrible batting averages. And these stops are expensive. In 2023, Maryland spent over around $115 million in overtime for law enforcement officers. This number could be significantly reduced if we allow law enforcement officers time to focus on more serious crimes and moving violations rather than whether a registration has been expired for 30 days or a piece of equipment is malfunctioning. It's common sense. Eliminating low violations as primary offenses would also address racial disparities in policing. Maryland's population is 30% Black, yet 46% of people were stopped for registration and equipment violations in 2023. When similar legislation was enacted in Philadelphia, stops went down by over half, from 215,000 to 64,000, and gun seizures went up because law enforcement was able to focus on more serious crimes. The gun seizures in less than half the stops increased. We would urge a favorable report for HB 635.
Good evening. Thank you, Chair Clippinger, Vice Chair Bartlett, members of the committee. My name is Daniel Boda. I'm from the Vera Institute of Justice. We are a national policy and research organization, and I work with law enforcement, legislators, community members around the country, and in efforts to improve roadway safety, to end harmful racial disparities in traffic enforcement, and increase public safety. The Vera Institute supports HB 635 because policies of this type promote traffic safety and keep communities safe. So I want to highlight those 2 points. I'll refer you to my written testimony for some additional points. The first point, HB 635 will not end traffic enforcement in Maryland. It will make it more effective at saving lives. So it's a question of the efficient use of resources. Under the status quo, over 1/3 of all traffic stops in Maryland in 2023 were for equipment violations or registration defects that traffic safety officials have conclusively established are not connected to crashes. While police were focusing on these non-safety related infractions, injuries and deaths from crashes increased. So Maryland, like much of the country, has been facing carnage on the roadways. And that is caused, we know, from traffic safety research, extensive research, that's caused by excessive speeding, distracted driving, and driving while intoxicated. So the second point I want to make is that the traffic stops themselves are dangerous, both for drivers and for police officers. So they should really only be used when there's a significant benefit. The National Law Enforcement Officers Memorial Fund reports that the 5th most common cause of line-of-duty deaths for police officers is being hit by a passing car while conducting a traffic stop. For all these reasons, we'd urge the committee to give a favorable report to the bill. Thank you.
All right, we'll go now virtually. We'll go to, let's put it down, Tia Holmes, please. Tia Holmes. She was here. All right. Go ahead, 2 minutes.
Hello, everyone. My name is Tia Holmes, and I'm an appellate attorney at the Office of the Public Defender. I am testifying in support of House Bill 635 because this bill offers a solution to a problem that has existed for far too long. Time and time again, I watch body-worn camera footage of dangerous traffic stops that began based on a low-level traffic violation, such as driving in a bus-only lane momentarily or driving with expired registration, for example. So what do I mean by dangerous traffic stops? I mean traffic stops where the stop escalates due to either the officer or the driver acting on some fear of the other. As an example, consider Philando Castile's traffic stop. These traffic stops disproportionately affect drivers of color, particularly Black people, as everyone has already said. I've been in search of a solution to this problem for the past 9 years. As of 2 years ago, I realized that other jurisdictions have tackled this issue through policy reform, and I see no reason why Maryland cannot. Other jurisdictions such as Philadelphia and Virginia have made these policy changes, and they have seen the benefits. As I mentioned in my written testimony, those include a reduction in racial disparities in traffic enforcement and an increase in traffic stops that cause an immediate threat to public safety, such as drunk or reckless driving. So freeing up Maryland's police resources to focus on more risky and dangerous driving keeps us all safer. Instead of pulling over drivers for a short list of low-level violations included in the bill, other officers or another administrative body could send a violation notification letter, much like the pilot that's going on in Ramsey County, Minnesota. There, an officer can send a notification for equipment-related violations without stopping the driver. Policy reforms like these help police and citizens avoid needless encounters that allow us to remain safe. And for those reasons, we ask that this committee issue a favorable report on House Bill 635.
Scarlett Neath.
Hi,
she is.
thank you so, yep. Hi, thanks so much. My name is Scarlett Neath, and I'm with the Policing Project, an organization dedicated to ensuring democratic accountability in policing by giving communities and their elected representatives a voice in how law enforcement agencies operate. We think that HB 635 is a common sense measure that limits police enforcement of a series of non-safety violations. And at least 12 state or local governments have passed measures to limit similar non-safety stops, as we've heard. These low-level stops don't move the needle on roadway safety, and they don't move the needle on broader public safety either. We at the Policing Project have studied traffic stops in Nashville, Tennessee, where just 0.7% of stops resulted in an arrest for something that might have an impact on future crime. When the Nashville Police Department reduced its traffic stops for non-moving violations significantly, it not only used its limited policing resources better, but crime rates remain unchanged. We've seen this repeated time and again in other jurisdictions. Fayetteville, North Carolina, St. Paul, Minnesota, Philadelphia, Los Angeles, Seattle, and several Connecticut cities. These jurisdictions have shown that limiting traffic stops for non-safety offenses is associated with reduced racial disparities, increased arrests for moving violations, fewer serious crashes, and either unchanged or reduced crime rates. For all of these reasons, we urge this committee to support this important measure, which will make Maryland's roads safer and more just. Thank you so much.
Chris Burbank.
Thank you very much. My name is Chris Burbank. I am the former police chief in Salt Lake City, where I spent 9 years in that position. During that time, I was the vice president of the major city chiefs, the 70 largest agencies in the US and Canada, as well as president of the National Executive Institute, police leaders who have graduated from the FBI Academy. As I considered this, I've spoken on this bill throughout the country, or bills like this throughout the country. And I think the thing that is most important is that traffic laws in this country are created and designed to keep the public safe and to ensure the flow of traffic. In these particular circumstances, NHTSA has said that the violations cited in this bill do not contribute to negative outcomes on the roadway. They do not cause accidents. You will hear that this is a tool for law enforcement. Less than 1% of the time do these stops result in someone being charged with a crime. I dare say, if I walk into any of your offices as a police chief and say, I want you to change the speed limit to facilitate my officers being able to write more tickets and to search more vehicles, that you would laugh me out of your office. The other thing that we need to consider is that these types of stops increase the disparity in the outcome of policing across the country. It is time for us to do a better job in policing. I look at a limited resource and want the very best for that resource. I want them to enforce the law while still providing equal access under the law to all members of the public and to ensure the safety of our roadways, not to generate false claims or inaccurate statistics. Thank you.
One last time, Charmin Leon. Okay, we'll take questions now. We'll start with Delegate Taylor.
Thank you, Mr. Chair. This question is probably for the public defender, more than likely. We've heard that less than 1% of traffic stops end in an arrest. Do you have statistics for that 1%? How many of those included, less than 1%, how many of those included illegal guns repossessed, or do you know how many?
So Joanna Silver is going to testify also on this panel, and the data that they collected in Montgomery County is more granular than that. We are limited by the data that is collected on the state race-based stop traffic data dashboard, and it doesn't get that granular. So we can't say for sure. We can only base it on, in Montgomery County, it was a very low number, and we wish that we had that data. The amendment that the delegate offered asks also for additional studies, and we would say to increase that with additional data. But either way, I wish we could give you a better number. Anecdotally, what we've heard from law enforcement who support this across the country is a very small number. And I can give you the statistics from Philadelphia.
Okay, I'll wait till you hear the testimony.
Okay.
Thank you.
Delegate Conaway.
Chairman, thank you, delegate and panel, for coming in to testify. How do you get to a gun seizure from a traffic stop?
We don't have any law enforcement officers on here. Let me give you anecdotally.
I believe someone said that in the panel.
How do you, I think if you're asking how he searches a car.
Now, how do you get to no, I think, what's the process, likely process?
Well, so a law enforcement officer would pull somebody over on reasonable suspicion of a traffic violation. And then if there's a couple different ways. And what this bill is not targeting is consent to search. And so there is data across the country that when somebody is stopped, particularly Black people are subject to search more often, even though those searches don't result in seizure of evidence. And that is actually even true in Baltimore County. What we're not addressing, and so a lot of searches come, Delegate Conaway, by consent. So people will be stopped for something and then somebody will ask to consent to a search. It's a very common way. This bill doesn't address that. There are traffic laws across the state that are introducing removing consent. We did not do that in this bill, and we are not doing that here.
I understand it, but somebody testified to this. I wrote it down as you were speaking. And how will this help save lives? Whose lives are we talking about? The police officers' lives or the driver's lives?
Everybody's lives.
Everybody's lives. And how is that?
Well, the traffic stops, if I may, are dangerous for everybody. So you think about if you're pulling somebody over, a police officer has to approach a car on the side of the road where there's traffic moving. Folks have to move out of the way so that they don't injure the law enforcement officer who's standing outside of the car. When people interact with the general public in a traffic stop, you've seen circumstances where that has resulted, unfortunately, in death. In Maryland, the Attorney General's Independent Investigations Division, when they were enacted, I believe starting in 2021, has collected data on fatalities involving law enforcement. Traffic stops are the second leading cause of death for interactions related to law enforcement. The first would be force, and the second is a traffic stop.
So are you saying the percentage would be higher for the officer maybe getting hit by someone, or from them having an encounter and it turned out bad?
All of those things.
All of those things. Okay, well, you know I'm a co-sponsor of the bill, right?
Yes, sir.
Okay. So I'm not satisfied with the way you're answering these questions because there's a thin line between the truth and something by omission. And a lot of times I believe that the officers are trying to help you. For example, they might stop you because you have the fuzzy dice in your rearview mirror, and they really believe that that you can't see, or your tires might be bad, or your axle could be bad, or your tail light could be blinking and someone else might not know. So I don't want to be bashing the law enforcement for helping you with your safety equipment. And you said, someone said something about not stopping you for an equipment violation. Well, how would you get the violation? What, they're going to record your tags and send it to you in the mail? Is that what you're suggesting?
That is an option.
Okay, all right. Thank you very much.
From Environment and Transportation, Delegate Jacobs.
Thank you, Mr. Chairman. Delegate, you said when you began your testimony, you had some amendments and you would answer those if the questions came up.
Yes, sir.
So in recent years, there's been laws passed about exhibition driving, and it takes 2 or more penalties in order to qualify for a charge in exhibition driving. And in this, I think it's 16 different stops listed here, and I can see where at least 2 of them could be considered. So how does that work into this, into your bill? Have you got any amendments that will address that portion of it? Because if you were found guilty of 21-1117 and 22-602 at the same time, that could be considered.
Which ones are those?
One is engaging in skidding, spinning of wheels, excessive noise making. The other one is excessive sound limits.
I believe the only thing that excessive sound is something that's in the.
But if you put the 2 together, that could put you in an exhibition driving scenario, which we passed laws in the last couple of years over. So I'm just wondering if you had amendments that clarified that.
I don't believe we have amendments that specifically clarify that.
Okay.
But the only thing that would be covered in this bill that would not be considered a primary violation would be the excessive noise. That would not be considered a primary violation as we have it described today. But if I could, since you asked me about amendments, let me tell you what we have done, because I wanted to not be deaf to some of the concerns that have been raised by law enforcement and by others. So there was administrative disciplinary language listed throughout this bill. That has been removed. The discarding of debris would remain a primary stop. Clarifying when headlights or taillights infractions can be enforced, clarifying language. Turn signals, because I listen to folks in the biking world and pedestrians, turn signals would remain a primary infraction. And to your point about how might you enforce some of these issues with faulty equipment, we've added a study to require MVA to review alternative means to enforce non-safety related stops using technology. Because I really believe that there are other ways to effectuate some of these challenges that we have with bad registration, faulty equipment, et cetera, where it's less invasive. So we're not saying you just get to ride around without addressing those issues. We just believe there are other ways of addressing those issues, and we've asked MVA to come back. Those are some of the things that were done in other jurisdictions.
Yes, thank you, Mr. Chair. And I just briefly want to say, I think the racial profiling that you have experienced at the hands of law enforcement, Delegate Phillips, from what you shared with us at the beginning, is abhorrent. But my question is, I'm sure we're going to hear from the opponents as to, oh, this is absolutely essential, safety will decline, we have to have these stops. So my question is for Madam Public Defender. Are there other criminal and traffic laws that address serious violations in Maryland?
So the short answer is yes, and I highlight when we're speaking about these offenses, we are primarily speaking them in the singular. So when there are examples of the different things that are happening in combination, then they're usually indicative of something else. So for example, we speak about the weaving or crossing the lanes, changing or moving without proper signal. That is significant because that signals, for example, negligent driving. That is an offense of which an officer can stop an individual, for example.
Thank you, Mr. Chair.
Delegate Conaway for second bite, and last bite here.
Thank you. What would driving too slow, would that be a primary stop?
It's not included. The bill does not really include moving violations. So mostly, primarily like registration and equipment.
Mostly, oh, thank you very much.
Seeing no further questions for this panel, thank you very much. We'll go now to the remaining people who are going to testify, and if I talk long enough, I can find my list of names again, and that'll be fine. Joanna Silver is virtual, I see her. Jordy Diaz is virtual. Jordy is there. Davon Love, Robert Vega, Thomas Williams. Mr. Vega is not here. Mr. Love is. Mr. Williams is not. All right, let's do this. Mr. Love, if you're ready, we could take you first, and then we'll take the people virtually. So, Mr. Love, for 2 minutes, please.
All right, Davon Love, Director of Public Policy, Leaders of a Beautiful Struggle. You've already heard a lot of data and statistics about the disproportionate way that Black folks are stopped by law enforcement via traffic stops. I want to talk a little bit more, though, about the way that societal propaganda around notions of Black folks being inherently criminal are a part of the collective American consciousness. For decades, social psychologists have demonstrated an association between race and crime. Not only are Blacks associated with violent crime, but also the more stereotypically Black a person's physical features are perceived to be, the more that person is perceived to be criminal. And if we think about many of the pop culture references that many of us may, be familiar with, I'm sure some folks may be familiar with the show Pimp My Ride, and you think about many of the ways that notions of race, crime, and then you think about that combined with other pop culture references, this contributes to the way that notions of inherent criminality amongst Black folks are rational beliefs given the societal propaganda. Pair that with the fact that Black folks are 2.5 times more likely to be killed at the hands of law enforcement, the 2016 DOJ report of Baltimore City, the 2021 SEPTA report, Baltimore City's Police Department, the 2020 Graham report of Prince George's County Police Department, evidence all the range of abuses from disrespect to brutality that Black folks are disproportionately subject to. So this is just a figment of people's imagination. This is evidence of people's actual experiences beyond anecdotes. What I want to do briefly is just talk about the fact that law enforcement has characterized this as an anti-police bill. The Maryland General Assembly commissioned the Restoring Trust in Policing Commission a few years ago. And the Johns Hopkins Center for Gun Violence Prevention did focus groups in communities most impacted by gun violence. And what they found from the respondents, 52% of respondents say they witnessed law enforcement being disrespectful, 68% say they witnessed law enforcement engaged in excessive force, and 70% of them said that they don't think that their complaints against law enforcement will be investigated fairly. So I just want to say that the importance of curtailing the interaction of law enforcement with Black folks is essential. As was mentioned, the sponsor mentioned that there are amendments to try to figure out which things make the most sense to stop people for. And so I think this is an important and essential measure in dealing with the real problem that at this point there are barrels of evidence to demonstrate that this is a real problem.
Ms. Silver, please.
Thank you, Claire Clippinger. I am testifying on behalf of the Silver Spring Justice Coalition in support of HB 635. In 2023, SSJC advocated with the Montgomery County Council in support of a bill that was similar to HB 635. Unfortunately, that bill was preempted by state law, so we are grateful to Delegate Phillips for sponsoring this bill. Racial disparities in traffic enforcement have long been a problem in Montgomery County. Over 20 years ago, a civil rights complaint led to a memorandum of agreement with the Department of Justice based on our traffic stop practices. Recently, a report by our Office of Legislative Oversight revealed that significant race-based disparities persist. While our police department blames these disparities on drivers from DC and Prince George's County, this racist trope was disproved by the report's findings that disparities were comparable for county residents and non-residents. The report also revealed that the greatest disparities in traffic enforcement were seen for non-safety related traffic violations. For example, equipment violations had a racial disparity score that was 20 points higher than the score for moving violations. Not only are drivers of color stopped more frequently in my county, but the OLO report revealed that 74% of all searches during traffic stops were of Black and Hispanic drivers. Despite claims that these searches are necessary to fight crime, they reflect a needle in a haystack approach. To illustrate, in 2022, less than 0.5% of all traffic stops in Montgomery County resulted in gun seizures. In 2023, Montgomery County lost 45 people to fatal car crashes, and there were almost 3,900 crashes resulting in injuries. We don't want to use racially based fishing expeditions to try to keep us safe. We want equitable traffic enforcement that focuses on dangerous driving. My county can't legislate in this area, so we ask you to use your power to do so and issue a favorable report on HB 635. Thank you very much.
Mr. Diaz, please, for 2 minutes.
Good afternoon, Chair Clippinger, Vice Chair Bartlett, and members of the committee. My name is Jordy Diaz. I live in Montgomery County, and I am an organizer with Young People for Progress. I am testifying in support of this bill. Young People for Progress is a civic and social justice organization of youth and young adults in Montgomery County. We have been working to decriminalize young people and address racial disparities in traffic enforcement. In 2023, we supported the STEP Act, a bill similar to HB 635, which aimed to reduce unnecessary traffic stops but was ultimately preempted by state law. From 2018 to 2022, in Montgomery County, Black drivers made up 30% of traffic stops, and Latinx drivers made up 21%, despite comprising only 18% and 19% of the county's population respectively. These disparities cause significant harm, putting people of color in stressful and sometimes dangerous situations. During the STEP Act hearings, we heard powerful testimony about these harms. 40 people submitted testimony in favor of the bill, and only 9 opposed it. A Montgomery college student shared how he was surrounded by multiple police cars and interrogated over a broken taillight, leaving him feeling targeted and humiliated. Another driver, a young Haitian immigrant, was stopped for an expired temporary tag, surrounded by police, handcuffed, and searched without consent, only to be told that it was a case of mistaken identity. Both experiences left lasting trauma and highlighted the need for change. They revealed the fear and humiliation these stops create, especially for young and undocumented individuals. HB 635 addresses these issues by limiting police authority to stop drivers for minor offenses and ensuring evidence from such stops isn't admissible in court. This will help prevent unnecessary escalations, reduce racial disparities, and build trust between law enforcement and our communities. Young People for Progress urges the committee to issue a favorable report on HB 635. Thank you.
All right, seeing none, thank you all very much. I'm going to go now to those people testifying in opposition. Michael Shire. Scott Schellenberger virtually. Daniel Franklin. Jermaine Jordan. David Morris. I don't believe he's still here, but O'Brien Atkinson. Not here. Okay, we have a second panel we'll have after this one. We will begin on my right, moving across, so the person on the left. Mr. Shire, please, for 2 minutes.
Good evening. Thank you, Mr. Chair, Madam Vice Chair, and members of the committee. Thank you to Delegate Phillips for pointing out some of the things that we're going to be saying tonight. I, by the way, had a 99 Maxima. It was an awesome car. Oklahoma City bomber Timothy McVeigh killed 168 people. He was stopped, captured by law enforcement after they noticed he had a registration violation. Forrest Gump said it best, traffic stop is like a box of chocolates. You never know what you're going to get. Well, he said something like that. Yes, traffic stops are dangerous. They're dangerous for police officers. They're dangerous for everybody involved. That's part of our job. We take on that danger every day. We call them unknown risk traffic stops, not routine traffic stops. Okay, what you are calling a minor violation, there is no such thing as a minor violation. Every traffic stop is different. These traffic stops lead to recovery of drugs that are poisoning our communities, the firearms that are killing our citizens, and the drunk drivers that are putting everybody at risk on the roads. They might lead to the capture of an actual or potential mass murderer. I've heard the public defender in our state say that police officers don't prevent crime. We only respond to crime. That is simply not true, and there's much more to it. Every time we take a gun out of a car, we're preventing a shooting. When we take heroin and fentanyl out of a car, we're preventing an overdose. When we take a drunk driver off the road, we're preventing a crash. When we stop somebody for not wearing their seatbelt, something that used to be a secondary offense, we may be preventing that person from dying as an unrestrained occupant. We stop people for everybody's safety, and every part of the vehicle code is aimed at public safety. That's the entire point of these laws, whether it's wearing a seatbelt, speed limits, lights, licensing, registration, which funds our ability to keep our transportation infrastructure from collapsing. Every part of the vehicle law is aimed at public safety. If you, the legislature, do not believe that part of this law is safety related, then please repeal those particular laws. We won't enforce them anymore. Limiting the government's ability to enforce its own laws that are designed to keep the community safe doesn't make any sense. And limiting an officer's ability to uphold the community's expectations that we enforce those laws creates confusion and frustration. We understand what the sponsors are trying to do here, and we applaud their goals and their ideals, but this is not going to be the way to achieve those goals. It will hinder our ability, and we ask for an unfavorable report. Thank you. Thank you.
Good evening, Mr. Chair, members of the committee. I'm Jeremy Jordan, member of the Fraternal Order of Police and an active law enforcement officer in Maryland who has spent a significant amount of my career focusing on traffic enforcement. My testimony today is in opposition to House Bill 635. While the intent to increase accountability and transparency during traffic stops is commendable, proposed legislation introduces significant concerns that could undermine public safety and effective law enforcement. Limiting certain traffic offenses to secondary enforcement hampers an officer's ability to address violations proactively. Many seemingly minor infractions, such as improper signaling or expired registration, often lead to uncovering more serious offenses, including impaired driving or stolen vehicles. By restricting enforcement to secondary action, the bill removes critical tools officers use to ensure safety on the roads. The mandatory exclusionary of evidence obtained in violation of procedural requirements risk creating loopholes that could allow serious offenders to escape accountability. For instance, evidence of illegal weapons or drug discovered during a traffic stop for an infraction could be rendered inadmissible, weakening the efforts to combat crime. While accountability is vital, solutions should focus on balanced reform that maintain public safety without impeding an officer's ability to perform their duties effectively. For these reasons, we urge an unfavorable vote on House Bill 635 to avoid unintended consequences that could jeopardize the safety of Maryland residents.
Good evening, Chairman Clippinger, Vice Chair Bartlett, members of the committee. Chief Dan Franklin, Morningside Police Department, Prince George's County. I want to speak on a couple of provisions that this bill puts forth. First is requiring an officer to display a valid identification during a traffic stop it's a complete distraction, just plain unsafe. Takes the focus of the officer off of the driver or the occupants of the vehicle. As has been beaten to death here, traffic stops are dangerous. We know this. This provision does absolutely nothing to make them any safer. Nothing. Absolutely nothing. Another thing, requiring a reason for a stop to be documented on a citation or a police report removes one of the ways that traffic stops become less inflammatory, and that takes away our discretion in providing a warning. The way that this bill is written, we have to do a citation or a police report. With regards to the minor stops and minor violations, I'd like to bring to your attention a young lady named Nicole Michelle Johnson, July 28th, 2021, was stopped by the Baltimore County Police for driving without current registration, for having expired West Virginia temp tag, no insurance, host of other violations that would probably be considered minor. Officers during the stop interrogated Ms. Johnson. By some of her statements that she made and also the smell of decomposing flesh that was coming from the vehicle, they made a gruesome discovery of Ms. Johnson's 7-year-old niece and 5-year-old nephew decomposing in the trunk. They had been dead. They were killed by her, and they had been dead for over a month. Johnson was found guilty, sentenced to 50 years in prison for the deaths of her niece and her nephew. Without the ability to stop for those minor stops, that heinous and disgusting crime goes undiscovered. Let's not make any mistake. Reducing the ability of law enforcement to enforce any of the traffic laws, it increases the likelihood of the laws being broken. For these reasons, I ask for an unfavorable report, and I thank you for your time.
Good evening, Mr. Chair, Madam Vice Chair, members of the committee. David Morris, representing the Maryland Chiefs of Police, Maryland Sheriff's Association, asking for an unfavorable report. I'm going to be very brief since much of what has already been stated is in the position paper from the Maryland Chiefs and Sheriffs. I'll just say that any suggestion that operating with inoperable tail lights, brake lights, headlights, particularly late in the evening, is a public safety issue. Traffic safety is an essential part of any good public safety program. Likewise, it is our experience that while, yes, expired tags may simply be caused by someone who failed to renew their tags, and we recognize that. But more often than not, registration plates that are canceled, suspended, or revoked are not canceled and suspended or revoked for failure to pay. They're canceled, suspended, or revoked more often than not because of a lapse of car insurance or motor vehicle insurance, which exacerbates the problem as it relates to investigation of motor vehicle crashes that cause serious injury or death, particularly when it's caused by uninsured motor vehicle drivers. So for those reasons and all those that we outlined in our position paper, we'd ask for an unfavorable report. Thank you.
Mr. Schellenberger. There he is for 2 minutes. Go ahead.
Great. Thank you, Mr. Chairman. Good evening to everyone. I had a lot to say, but I guess Delegate Phillips read my written testimony, and that's when the amendments came about. Because I have not seen the amendments. I was outlining what I thought was a very dangerous situation, and that is you're a police officer and somebody's driving a car on a rural road, it's 2 lanes, your left headlight is out, and you pull them over. You're doing so to protect public safety. If this bill were to pass, and I have not seen the amendments, if this bill were to pass the way it is, the officer could have to go down the road and wait until he hears a car crash to turn around and find out that the person without the headlight had crashed into a car coming the other way. What's more important, I had pointed out that I had never seen another statute where administrative disciplinary action would be taken. So I'm very happy about the steps that have been taken on these amendments. I look forward to seeing them, and I'm certain that I will offer other commentary on that. And the reason for these changes is not having a blinker, not having 2 headlights are directly linked to public safety. And so we have to take a look at that. And one of the questions I think was asked earlier about, pretextual stops. Well, now everybody's got body cameras. We know exactly why people are being stopped, and it's being recorded and making sure everyone will be able to see it, including my friends in the public defender's office. And if anything inappropriate happened, they will be able to file a motion to suppress because it didn't match up, which is why it doesn't make sense that you have to write all the reasons down on the citation when in fact we have body camera footage that you will see. So I'm urging an unfavorable report. Happy to look at the amendments.
I see you too. Okay, we'll go around, going to go around the horseshoe, starting over here with Delegate Cardin and then making our way down. I see you, Delegate Davis. We'll make our way pretty much down this side of the room.
Thank you,
Delegate
Mr.
Cardin.
Thank you very much. Thank you for your testimony. To the gentleman on the left, I forgot your name already, Officer.
Mike Shire.
Officer Shire. It was already said, I think it was said by the gentleman on my left, but if you have expired registration, is it possible it could be because of insurance, because your insurance lapsed?
There's lots of reasons why. It could be an insurance lapse. It could be a suspension due to your emissions not meeting spec. It could be all sorts of things. It could be because you just didn't pay the fees for the registration that again, we use to fund our infrastructure. And if you want to put a 4-month kind of gap in it, well, I'd say, well, you already have a year, 2 or 3 years to renew your registration, because that's how long the registration period is. If you want to make them a year and 4 months, then just make registrations a year and 4 months instead, or 2 years and 4 months. It doesn't make sense to say, oh, we're going to have this grace period extending it. It's like you have to draw a cutoff line somewhere. So just pick what the cutoff line is going to be and let the registration go that long.
Thank you. I'm concerned that insurance lapses could be a very big danger to all of us and to the costs to the state as well as the.
As somebody who's been the victim of an uninsured motorist, then yes, I can say for sure that I had to pay out of pocket, plus, my insurance costs paying for the repairs on my car.
Maybe we can talk about that language, perhaps. Yeah. Thank you.
Thank you. Any of you can answer this, or state's attorney. It's been mentioned a couple times about drugs and guns that are seized for in these kind of stops. Can you just expand a little bit on that, on like how much we're talking about, or maybe specific examples of anything memorable, I guess?
I've many memorable instances, but I go through my agency. I work with Anne Arundel County. I go through our agency's daily reports, weekly reports, and daily we are pulling guns and drugs out of cars from these types of stops. Officers make it what starts out as, in just unknown risk traffic stop, and we develop reason to maybe do a Carroll search of the vehicle, which permits us to do warrantless searches based upon probable cause. We get consent to search a vehicle, whatever the case. But these are the ways that we are getting the guns and the drugs out of cars. And I would say it was called fishing expeditions earlier. Well, we sometimes catch fish. And that's kind of the point of a fishing expedition, is to go out and catch fish. And every time you cast your line, you might not catch a fish. Does that mean that you just stop fishing? No, you cast your line again, and you go out in there and you find the drunk driver, you find the gun, you find the drugs, the things that our citizens are expecting us to do. We go out and our citizens want enforcement of our traffic laws. They want to see us out there. It's an opportunity for positive community contacts. It's an opportunity for people to see us. It's a deterrent, seeing those red and blue lights flashing on the roadways that say, maybe I'll go do crime someplace else, or maybe not at all. So there's lots of reasons why and ways that we can get into those vehicles, and it happens every day, all the time. I would say 1/10 of 1%, that's a good percentage. I don't want to reduce that to 1/2 of 1/10 of 1%, because that's half as many times that we're getting guns and drugs out of cars.
Yeah, and I think to expand on that, a lot of data has been thrown out there about, only 1% of the stops lead to an arrest. Well, I can say, as a person that lives in my community in Prince George's County, stopping one person and getting that one gun or getting that one bit of drugs off the street, that's saving at least one life each time you're making that stop. So at the end of the day, yeah, it's 1%, but I'd rather make my county 1% better with every stop that I make.
If I might just add to that, we are very particular, and Lieutenant Shire has spent a considerable amount of time in training our officers. He holds a law degree. Don't hold that against him. I don't. But we preach, we practice, we train, we educate. Every traffic stop constitutes a seizure under the Fourth Amendment to the Constitution, and therefore it has to be a reasonable traffic stop, and it's got to be based on probable cause and/or reasonable suspicion, whichever is appropriate for the particular time. Both of which are legal traffic stops. And bad people do bad things, and bad people operate automobiles. And that's where we get the guns. And every day at 8 o'clock, Prince George's County Police Department produces a 24-hour report, and I shake my head at the number of guns and the amount of drugs that we get off of traffic stops in just one 24-hour period. And every one of those guns that we seize is a life saved.
Thank you.
Thank you, Chair, and thank you all for being here for this extended amount of time. I know we've heard a number of statistics and a number of bad Forrest Gump jokes tonight. However, I do have something serious that I want to ask Mr. Jordan. Do you talked about saving lives. Do you have specific statistics on officer-related deaths regarding these traffic stops?
Yes, and I don't have the specific for traffic stops, but in 2023, 8 officers were struck and killed by vehicles across the United States. 20 were killed in crashes, 24 for job-related illnesses, and 46 were shot and killed.
And how many in the state of Maryland?
To my knowledge,
How many was in Maryland in 2023? I'm not sure there were any traffic-related fatalities in Maryland in 2023. The last one I can remember might have been 2020 or so in Greenbelt. A Greenbelt officer was struck and killed during a traffic stop that she was making. But I think to the point is that I'm not sure where these statistics are that, you know, traffic stops are somehow more dangerous than other things we do. To be clear, everything that we're doing when we're out there is dangerous, and, you know, we're putting our lives on the line and our safety on the line. I had an experience where an officer that I was working with got hit by a car, and hearing him screaming on the radio as we're trying to get there, that was his second or third time getting hit by a car. So it does happen, but that's part of this job. And if you want us to stop making traffic stops, just repeal the transportation articles and we'll stop making traffic stops.
Yeah, I know we've passed some bills to move over law, from 2 years ago to help with some safety concerns there.
Yep.
So hopefully that's doing its job. Thank you.
Thank you.
Delegate, the Police Officers Memorial webpage lists every line of duty death in every state with the specific circumstances, dates, times, and the circumstances that led to that officer's death. And you can disaggregate that by state. So if you want to see specific to Maryland, it's a very quick and easy website to navigate.
Excellent. Thank you, sir. Thank you, Chair.
Thank you, Mr. Chair. We're here because Marylanders across the state are concerned about racial profiling. We don't have no problem with you fishing. We just want to know why all the fish look like us. Racial profiling is a real thing. The statistics don't lie. And I have a question. Could you offer another solution? Thank you.
I'll say statistics lie all the time. 52% of statistics are made up, but I understand what you're saying. Racial profiling is an issue that we tackle in Maryland. We have extensive training on implicit bias and other issues. Every police department is required to train on race-based traffic stops and how we're not allowed to make stops based on race, religion, all those protected classes. We have laws in this state that require us to report. The way you get that data is because for every traffic stop we make, excluding LPR stops, license plate reader stops, and radar LiDAR stops, we have to report why we stopped the person, what county they live in, their age, their race. All these things go into this data. The problem with that is it doesn't show, based on the communities, what is actually going on there, what is driving this. I work Anne Arundel County. I've worked in Anne Arundel County for many years. We have communities of color that are socioeconomically depressed. There is no doubt about it, right? But do you disagree?
Nothing to do with crime.
What? No,
You associate race with crime.
No,
poverty
I'm
with
saying,
crime.
I'm saying those communities are socioeconomically depressed, okay? And what we see is there are issues. I would disagree with you that in many of those communities, whether they're white communities that are socioeconomically depressed or minority communities that are socioeconomically depressed, we see higher crime rates in that community. That's not, I don't believe, the police officer's fault, okay? We are in those communities every single day, dedicating our lives to the vast majority, overwhelming majority of people who live in each one of those communities that are law-abiding citizens, that want to send their kids to school, that want to go to work, that want to live their lives. And when we come down here and are portrayed as we are somehow the cause of the crime in those communities or the disparities in those communities, that is extraordinarily hurtful to me personally. I have dedicated my life to protecting every single community, regardless of race, religion, ethnicity. These are my communities, okay? I live with these people. I know these people. My family has dedicated their lives to protecting those communities and uplifting those communities, but to remove the tools that police officers use to protect those communities, to have positive encounters with, and those traffic stops should be a positive encounter. And if they're not, then we have the Maryland Police Accountability Act, and those people should make complaints. It's on body-worn camera, what they're doing, and those investigations will be done. We have mechanisms in place, but this bill is not going to solve the problems, in our belief, that we seek to solve. But that said, we are in those communities every day with social programs. We have crisis intervention teams for those who are who are struggling with substance abuse and other issues. Our police officers are out there every single day making positive community contacts, trying to help those communities. And if there's other ways that we can do that, then we are absolutely open to it. We will use every resource possible in order to improve the lives of our citizens. Every resource possible.
And so what I can say on that similar note, as I'll say it, the only black guy up here, we are raised to be fearful of the police, right? But if you preload an individual with a belief that you should be fearful of the police, then they're going to continue to believe that. But if we start to teach our young people that the police aren't people that you should be afraid of, they are people that you should trust. They are people that can help you. Then the vilification of law enforcement will go away. And our young black and brown people and minorities will understand that they shouldn't be fearful, and that when they are stopped, you can have a conversation with that officer. You can talk to them. They are part of your community. Many of them live in your communities, and they want to help you regardless of the reason why you're having that contact. When you call 911, it's typically the worst day of your life, right? Whether you've been in an accident, whether you've been injured, and you want a face there that's going to be someone that you can trust. And if you already have preloaded your mind and saying, when the police show up, I'm probably going to go to jail, then how are you going to feel when they actually get there?
I have one idea. School resource officers. It goes to what was just said, right? Putting officers in the schools helps create those early connections and build the bonds of trust that we need between those that are out there trying to help and those that need our help. That's one way that we can help, but we just don't have enough officers to put them in every school. We don't have enough officers to go to every community policing event. Delegate Bartlett she called me in the summer. She was having a major event with the health department doing outstanding outreach to our communities for health-related things. And she wanted a couple police officers there flipping burgers and cooking and being able to make connections with people. And me and one of my fellow FOP board members went there, and we brought out our grill. We got a grill. We get grills with grant money and other things like that so that we can do these community events and we can come out and meet the people that are not just police officers, but health department people and others, outreach people who are making connections in our community, and they know that we are all there. The community members come out and say, yeah, it's not just making traffic stops. It's not just running lights and sirens. Okay, we are out there making connections with people on a regular basis, and there are many ways to do that, and we are struggling to be able to do that because we just don't have enough staffing. We're not able to make as many traffic stops in general. We don't have enough staffing. We're running call to call to call. Staffing is down across this entire state, and we want community policing, but it's hard to do community policing when you don't have time to engage with the community. And traffic stops can and often are positive interactions. As a supervisor in my police department, I get compliments all the time from citizens who call in and say, you know what, I got stopped, but your officer was very, very kind and professional. We don't see those things as much as we see the misconduct. Hopefully we will start to see them more. Hopefully there are more of them as we train our officers, as we teach them, as we improve. Nobody's perfect, If you want robots doing your policing, I'm sure AI's coming up, we can get there. But I don't think that anybody in this room or anybody in this state wants unfeeling robots doing their policing as opposed to somebody who will bleed when they're cut, who understands empathy and sympathy and things of that nature. Those are the people that you want coming out and doing your policing. Thank you. Sorry.
Thank you, Mr. Chair. And I appreciate the comments that you all have made, but this really isn't about just a police relationship issue. That's really not what we're talking about. What we're talking about is a disparity in stops. And no one has suggested along this panel why that disparity exists. You suggested something which actually concerned me, almost alluding to the fact that in our communities we're more heavily policed. And you kind of alluded to that. No, but I don't want to go there.
Okay.
What no one once again has explained to me this huge disparity in Anne Arundel County, just for equipment and registration stops. In 2023, and this is data that the police department report, all the police departments around the state. In 2023, just for equipment and registration stops, there were 24,037 stops. Of that, 132 arrests were made, 0.005. For a county that's only 20% African American, 42% of those stops were African American. And I get it. You just can't help me justify that disparity in stops.
I'm not going to do that.
Okay. So let me ask this question. When many years ago, if you wanted money from your financial institution, how did you get it? Many, many years ago. You're probably not as old as me.
You're talking about getting a loan?
No.
Walking into the loan
Walk
office?
into the bank.
Right, you go into
and you went to the
bank.
teller.
Right.
Right? And then we got ATMs. And then how do we get our money now? ATM.
I was thought you were going to say Venmo or some of these other.
So that's next.
Right.
So then we went from ATM to now Venmo, PayPal, all that stuff. Technology is changing. So some of these things, why do we need a police officer to address some of these issues if in fact we find alternate ways of doing it using technology?
Great question. One of the violations that you have in here is registration violations. Okay. 13411 of the transportation article says that your license plate needs to be easily visible, right, so that everybody can read it. How is an automated system going to read a license plate that is not easily visible and actually figure out who owns the car? If the system can't read it, then it can't track down the driver. So by saying, okay, we're going to automate enforcement of this part of the traffic code, but the traffic code specifically deals with making sure that such automated enforcement systems work by not having foreign debris on your tag, by not having plate covers. Those things are the things that foil even our Easy Pass and our automated speed and stop sign, red light and school bus enforcement, because you can't read the tag. If you can't read the tag, then you can't run the registration and figure out how to send the violation out.
Let me ask you a question, because I hear you on that one. That doesn't seem to be a large number of stops when you look at that. And we've got the stats. That's not one that has a very large number of stops. So if you give me that, I'll give you that one.
Okay. Thank you. I'll say this. The question is the stop the cause of...
Let me tell you what I'm concerned about. Because when I look at the stats, there's simple registration violations that seem to be the bulk of the stops. A person's tag is expired. They've got a bad sticker on their tag. It should be 25 and it's 24. All of which, if you run the tags, you know that relatively quickly. This legislation says you give a person a 3-month grace period. So when you look at those, many of these stops are actually falling into a category that in my mind, and I know you will differ with me, But the 24,000 stops are falling into a different type of a category, most of them.
So things like expired registration, people are on notice that their registration will expire, right? It's on your license plate, the month and year are there. If you want it to last 4 months longer, then it seems like you just make the registrations 4 months longer. What does the grace period get you if somebody's not going to pay their registration on time at the expiration date? What is going to cause them to bother paying it when it's 4 months later?
Wouldn't the notice do that?
The notices go out before the registration. I just got one for my car.
Right, and then you get another notice because MVA has explained that to me. If you don't, then you get another notice. And ultimately, what I've gotten from MVA, and they're not here to testify, is that most of the collections are not because somebody got pulled over. They're collecting because people realize I didn't pay my bill.
I'm not sure how you track that. Because there's no.
Well, they know they know if there is an infraction.
Right, they know if there's an infraction, but we don't know if the infraction causes them to pay the bill, right? And on top of that, they don't always know if there's an infraction, because sometimes, probably most of the time, if your vehicle's only a few months expired, I'm giving you a warning, and the MVA will never find out about that. Hey, your registration's expired, you need to get that fixed. Oh, geez, I've got the notice, I see it right here, officer, and it's a warning. But that stop might lead to an arrest if I walk up on the car and I see heroin in the front seat or a gun or something like that. We develop something more. But the stop itself and the reason for the stop is not the causative factor of the arrest. The causation of the arrest is whatever the offender, the suspect did wrong that caused the arrest. They have an open warrant, they have contraband in their car, they're under the influence. That may or may not have any relation, something like an expired registration has nothing to do with somebody being under the influence of alcohol. But how do I find the person under the influence of alcohol? Well, look, they've got an expired registration. I cast my line. And I pull them over.
But wouldn't you know that because that individual's driving, that's how you would know, right? Because he's driving impaired.
Sometimes it's not obvious, right? So you could have somebody who, drives normal, obeys the speed limit, and stops at stop signs, and stops at red lights, and doesn't cross any lines, and they're a .08. And maybe they were, doing okay, but how long do I have to wait?
I'm going to cast the net. Not because they were driving improperly, but because they had a registration. And then I'm going to get them for the.
Right, I've made many traffic stops for a broken tail light, and I don't mean like, they didn't turn their lights on. I mean like it's malfunctioning, it burns out or whatever. A registration violation, equipment violations, whatever the case. Hey, if I make the traffic stop, then there's no DUI, I don't see anything else, then it's have a nice day. That's the very basis of almost a checkpoint is like, take a quick look. If they're good, then on with them. So when you're out there looking for those things, this is just, sometimes it's us casting us, and it's making a positive community contact. Hey, maybe the person didn't realize that because maybe they changed their address and they forgot to update it with the MVA, and MVA mail doesn't forward. So they didn't realize their registration is expired. So that kind of thing happens too. But the stop, we've heard a lot of correlation, I think, without causation. The stop itself does not cause the arrest. None of these things that we've talked about are on the list of things that are arrestable in and of themselves. You need something either more, like the person can't be identified, or something pretty extreme to trigger an arrest, or a criminal violation, a DUI, things like that to actually cause the arrest. As far as why there is that disparity that you mentioned, that's worthy of looking into and better understanding, and that's going to take some data collection. I'm down for that. Good for that. Let's do it. But just saying that these stops cause that disparity, I think there's a break in that chain somewhere.
Can anybody, one more, thank you.
Since to be fair, the committee is kind of riveted by this back and forth.
So
here for a good conversation.
Yes. Are any of you familiar with either the changes in law in Virginia, Philadelphia, or even with the former police chief from Salt Lake. And clearly, in those cases, no one has suggested that the sky is falling. But are any of you familiar with what they've done?
Delegate, let me answer a couple things. One, as it relates to Salt Lake, what I am familiar with is that the change in the law out there that chief did not specifically reference was jaywalking and making it a secondary offense. I've been a police officer 40 years in Prince George's County. I've never written a jaywalking ticket, so I'm not sure how that would apply here. As it relates to Virginia, I'm aware that they've recently changed their laws, but let me kind of go back to what you said, because the Maryland chiefs and sheriffs fully support automated enforcement technology. And to the degree that that can be expanded upon, only helps to serve our communities better by allowing that automated enforcement piece of a program to assist in the public safety to the degree that it can. Mr. Chairman, you may or may not be familiar with the out-of-state motor vehicle improper registrations report that was provided to the governor on January 25. I'll make sure that Ms. Mansfield gets that to you for review by the committee. But it details over 47,000 Marylanders that are registering their vehicles in Virginia. And there's no reciprocity on registrations like there is driver's licenses. So I can only believe that, we can only believe that it's an intent to deprive Maryland of the titling and registration fees, emissions fees, automated enforcement fees, tolls and facilities and toll facility fees and things of that nature. So the use of automated enforcement is only as good as the program and as good as those that are obeying the law. Likewise, I recently testified in both the Senate and over here in the House on the obscured tags to remove the intent portion for obscuring tags, because we see that more frequently than not. And again, I can't walk into a courtroom and unequivocally state that an individual has obscured their tags with an intent. It's a very difficult bar to achieve. So, what I would suggest is, yes, we, the Maryland chiefs and sheriffs, agree that the use of technology is an important piece. As it relates to that data, this committee or another committee in the House will soon be hearing next week as it relates to the retention of that data and the use of that data. And we would ask that you carefully consider the testimony of the Maryland chiefs and sheriffs as it relates to evidence, use of that data as evidence in other crimes. Because if we're going to use that automated enforcement, we should be using it across the board for public safety so that it helps us solve crimes like homicides, rapes, robberies, carjackings, and things of that nature. And as it relates to where I get my money, I get it from my wife. She gives me an allowance.
Chairman, thank you, panel, for coming in to testify. I'd like to start with Mr. Schellenberg, just real briefly. Do motorcycles typically have two headlights?
Not to my knowledge.
Okay, I always enjoy your testimony. So now on to my business. Does the DMV suspend people's license for failure to pay, or suspend tags for failure to pay child support? Does anybody know?
Licenses, driver's license.
Not registrations, I believe.
Not the registration or the tags?
Just the license, I believe.
Just the license, okay. Now, in reference to the headlights being out, I don't understand, and maybe the sponsor of the bill can put an amendment in, but I don't understand how a citation will be given if a headlight is out. So
Delegate.
An automated.
An automated one, okay.
Yeah, the automated.
Yeah, so as it relates to the automated, that would be the challenge because it's picking that up.
Sure.
And keep in mind that more often than not, when those violations, when individuals are stopped for equipment violations, more often than not, they don't even realize that a brake light is out or a tag light is out or the tail light or the headlight. And the effective measure for taking enforcement action is an equipment repair order. So it's not a traffic citation. It imposes a fine. It's a repair order that notifies them that they've got the equipment violation and subsequently gives them 30 days in which to get that citation, that equipment repair order corrected and mailed back to the state.
Okay, so you didn't, in reference to the tags being obscured, you didn't mention the bicycle and bus lanes and the complaints that are coming now where the traffic is being bottlenecked. So I just wanted to add that, but I wanted to thank you officers for your work. Why you didn't mention the 4 years that it took us to get the police-worn body cameras. I mean, I don't remember you guys supporting that bill, and that was my bill. Did you want to make any comment about that? No. So what about the jaywalking? Jaywalking, no, it's getting deeper. Jaywalking generally leads to stop and frisk in the hood or in the city. Any comment on that? No, or you look surprised. Well, let's move down to this. What about, so the officer made a comment about being black and all of this, that's fine. And we need to be friendly with the police officers. When I came up, we had officer friendly. And when I came up, we had officers in the PAL centers that were good friends with the children. Now, on the flip side of that, you didn't say anything about the effect of the gun trace task force in Baltimore City. That's causing the distrust, okay? Now, you mentioned 52% of the statistics are a lie. So on your fishing expedition, you're saying that you stopped how many people to catch one person?
I stop one person to catch one person. I catch them with whatever violation I stop them for, but perhaps I so to speak, throw them back with a warning. But you're talking about how many people, what's the ratio of my traffic stops to the number of people I arrest?
No, you said that you do fishing expeditions, and I believe you said that you get about 1% or 2%, something like that.
No, I'm sorry.
1%.
So I was using a turn of phrase that the advocates of the bill used, calling them fishing expeditions. So just to piggyback off that, and the percentages that I was using were the percentages that the folks that testified before us used. So my point was with that if 1/10 of 1% result of traffic stops result in an arrest, well, that's that many people that have been arrested and charged. I wouldn't want to reduce that. That's every reduction in that is one less gun that's pulled off the street. It's one less DUI that's pulled off the street.
I'm not that good at math, so what you're basically saying is if you stop 100 people, you might get one?
That's conceivable.
Okay. And then what about the 99 other people that you stopped that you didn't get?
So I don't like to use the terms get or things like that, right? If I arrest 1 out of 100, right, then maybe that person had an open warrant, maybe they had drugs, maybe they were drunk. Those other 99, if they were doing 90 miles an hour in a 30-mile-an-hour zone, they probably got a citation.
Well, that's why I asked the question earlier, because I got a citation for driving while being old and trying to keep my insurance. I was doing 50 and a 55. I was trying to not get caught speeding. So the officer said, how long you been driving? I said, what, 40 years? He said, don't you know it's a 55? I said, I'm doing 50. He said, you're driving too slow, you're impeding traffic. I said, there's nobody out here but you and me in a two-lane road. But I thank you very much for your testimony.
All right, seeing no further questions except for Delegate Valentine, who has brief questions. Delegate Valentine.
Thank you, Mr. Chair, and thank you all, the entire panel, for being here with us this evening. My questions are directed towards Lieutenant Shire. Can you define, it came up earlier, what is the definition of a low-level traffic stop?
A few different terms were used. That was one of them, low level. I heard administrative violations, and I heard minor traffic stops. There's no minor violations. There's no classification. All traffic violations in the state of Maryland on the transportation articles are misdemeanors. Most of them are punishable by a fine of up to $500, no more than that. But there's no ranking of them as, one is more major, minor than another. If you want to look at the penalties, all the violations that we've been talking about, I believe, are the $500 limit. The greater ones are things like DUI, driving on a suspended license, reckless driving, I think is $1,000. But these are all on the $500 or less levels.
Last question, Mr. Chair. The bill states a police officer shall document all reasons for a traffic stop or other stop on any citation or a police report resulting from the stop. My question is, either by policy or statute, are officers currently required to document the reason they make a traffic stop in this state? And if so, what does that look like?
So for every traffic stop, as I mentioned earlier, we have to do the traffic stop data collection unless it's by use of radar or LPRs, license plate readers, and or VASCAR, some other minor exceptions like that. That includes the initial reason for the stop for all of those. If you're making a traffic stop based on radar, LPR, et cetera, and you do issue a citation, usually it's going to be the citation for that stop. If you're making an arrest, then you're definitely, in your police report, you have to put, not necessarily by policy or anything, you have to put that information in there in order to have a successful prosecution, because the first thing a defense attorney is going to want to know is what was the reasonable articulable suspicion for the officer making the stop, because if they can defeat that and say that violation did not occur or it was not enough suspicion to make the stop, then everything that comes after that is so-called fruit of the poisonous tree and becomes inadmissible. So a lot of the defense motions in court are going to be based upon the original reason for the stop, therefore has to be documented to avoid issues with that. And as was also mentioned, we also have body-worn cameras. Most policies in our state require, and I think we passed a law that requires when an officer approaches a vehicle, we have to give our name, our ID number, tell them their body-worn cameras on if we have body-worn camera, and the reason for the stop. Sometimes just telling the person helps diffuse the situation. Sometimes there's some safety reasons why we might not, but we do have to tell people. Hope that helps.
It does. Thank you.
Thank you all very much. We actually have one more panel on this bill. So thank you all very much. Angelica Bailey Tupari, Mimi Schwartz. Either one of them here? Going once? All right. That concludes the testimony on House Bill 635. Delegate Embry, 3 more to go. Delegate Embry. Not sure who's still here, but we'll find out. I see Mr. McFarland, Mary Rowley, Joseph Griffin, maybe. There we are. Jim Snyder virtually. Jim Snyder? Thanks for seeing me. No, absolutely. Okay. And that will be everybody. So let's hear from Delegate Embry for 3 whole minutes.
Thank you, Chair, Vice Chair, my long-suffering committee members. I'm asking for a favorable report again on an identical bill that passed out of the House and Senate last year, was vetoed, and I'll talk about that in a second. The bill is identical, and what it does, as a reminder, is in the limited category of probate, there is a requirement currently that notice be published in a physical newspaper, and the purpose of that notice is for creditors and heirs, to let them know. The registers came together and created a single website where all notice is posted. It is tremendously effective, and one of these witnesses will talk about exactly how effective it is, and it costs no money. And in fact, is arguably more effective because creditors are not local. They're big banks, they're credit card companies, so they're accessing a website is probably easier for them. And heirs, people are mobile, they're all over the country. And so we think it's actually a better product than a local paper for this purpose. I want to now turn back to why we're here again. The governor was concerned because a lot of these notice requirements predate the internet. So he said there should be a larger conversation about notice in physical papers. And Delegate Foley has brought a great bill that addresses part of that piece. What I want to argue today is the issue this bill addresses is unique. We asked the librarians and DLS to give us all of the statutes that require notice. There's 190 of them in the Maryland Code that require notice in a physical newspaper. This is one. The vast majority, over 150, are applicable to state agencies. So it is a cost borne by taxpayers, but it is distributed over all taxpayers. So no one Marylander is bearing the cost. The majority of the remainders are businesses that are seeking to take some action. And so it is borne by someone, again, seeking action by the state. This applies to Marylanders who have no choice. If they're subject to probate, they're subject to probate. And they range all over the economic spectrum. And for them to have to pay hundreds of dollars out of their own pocket, which may be reimbursed out of the estate, but that's still coming out of their pocket or the pocket of the people who are inheriting, for no good reason, just isn't right. So I respect the newspaper industry tremendously. This is a very limited bill. It's not getting at any other notice provisions in any of the other 189 places in the Maryland Code. It's just one. And I think I'm happy to work with them on other ways of supporting the newspaper industry, but I just don't think it's fair for people who have no say in the matter to have to pay money for no good reason. So with that, I will turn it over to my panel. Thank you.
Thank you.
Well, good evening, Madam Vice Chair, members of the committee. My name is Byron McFarland. I'm the Registrar of Wills for Howard County, Chair of the Legislative Committee of the Maryland Register of Wills Association. I'd just like to quickly recognize some of my colleagues who have stayed with us for the entire day. Margaret Phipps, our Dean from Calvert County, Rita Watson from Garrett County, Paul Zimmerman from Carroll County, and Delegate Conaway is not here, but he might recognize the Register of Wills for Baltimore City. But we're all happy to be here again. I want to thank Delegate Embry for her continued leadership on this bill, and I'm going to keep this as simple as I can. Number one, we need to and will protect due process and probate. Under current law and under this bill, every interested person in an estate in Maryland has and will receive a notice mailed to them by the Register of Wills informing them of their rights. That is an affirmative duty on us that we are required by law to comply with. There is no such duty on anyone else, including the newspaper industry. Two, let's make probate more efficient. The print publication of requirement this bill would discontinue, which, as Delegate Embry said, predates the advent of the telephone, much less the internet, will save people time and money. Not all newspapers publish daily. Many make chronic errors that require republication, and that delays probate and closure for families. Three, we shouldn't be nickel and diming people in grief. Many papers require families to pay these notices out of pocket before they can access any estate assets, and some notices cost over $300. Four, let's be honest, no one reads these notices. We know that because that's what our constituents tell us, and we know that because we can't identify even one estate where someone has told us that they are going to that they're objecting to the appointment of a PR or the probate of a will because they read about it in the paper. And lastly, we should not be playing the role, the registers, the state that we all pay for, should not be playing the role of copy editor and bill collector for private corporations. And that is something my counterpart from Frederick County will discuss further.
Good evening, everyone. I know that you're all waiting for that pizza that I saw being drugged in. I tried to get at least one half of it, but it didn't work. Anyway, good evening, Madam Chair and the committee. I am Mary Rowley from Frederick County Register of Wills. And I just want to briefly, because I know there's pizza back there, indicate that what our office has ended up being is basically editors of the publication and the collection of fees. My staff ends up proofreading 2 to 3 hours, which is taking time away from people that are grieving, that need to get the process done. The paper that we use in Frederick County at one point had the highest fees, and also constant mistakes that were being made. I did have a meeting with them. At that point, they had indicated that they would lower the fees. And then I thought it was interesting when they said, I guess we'll proofread, at which I was kind of shocked. So I said, all right, we will continue with the Frederick News Post. And I kind of told my staff, they're going to proofread now. Try not to spend as much time, but kind of watch. And 2 weeks ago, again, mistakes started coming in. And then 2 weeks ago, one of the staff came to me and said, I think we have a problem. There are 2 publications going out, and the name is Register of Wills is Sharon Keller. who was the previous Register of Wills. And I'm at to the point, what do we do? And especially when we have these people, again, very shortly, a little 80-year-old man who's lost his wife, and I tell him he has to put this money up. So thank you.
Yes, Vice Chair Bartlett, members of the committee, thank you for having us. My name is Joe Griffin. I am the Register of Wills for Montgomery County, and I respectfully urge a favorable committee report on House Bill 623. I want to conclude our testimony by saying this bill will discontinue the costly, time-consuming, logistically problematic, and superfluous publication of estate notices in print newspaper. It will replace this antiquated requirement with a centralized online statewide database for all estate notices to be maintained by the Register of Wills and made available for free. This will save over 10,000 Maryland families over $1.3 million per year in publication costs. This database is already up and running and has been since March of 2020. This website has nearly 12,000 hits per month and has had nearly 360,000 since its inception. And it is the top Google search result for Maryland estate notices. This bill was heard last session as House Bill 1258. There was no opposition in either chamber, and it passed unanimously. It was vetoed by the governor, who indicated a desire for a more robust debate with the newspaper industry, who unfortunately did not participate in the process last year, leaving us here repeating this entire exercise. We again ask the General Assembly to pass this bill. Simply put, you passed this last year without one single dissenting vote. You did the right thing for the people of Maryland and should do it again this year with House Bill 623. Thank you.
Thank you. I'm going to go ahead and go to Mr. Schneider, and then we'll ask questions. Mr. Schneider, you can take yourself off mute.
Hi. If there ever was sorry about my voice. If there ever was a government subsidy, that's a good example of what economists call rent-seeking. It's the legal subsidies for Maryland's politically powerful publishing industry at the expense of unorganized and poor Marylanders who cannot defend their interests and so are easy prey for exploitation. I don't dispute that the press provides a worthwhile service. I do dispute that the legal ad fees imposed on the families of deceased Marylanders provide such a service, and is that narrow issue you should be focusing on here. The newspaper lobby will tell you that their technology is an excellent way to provide public notice to potential beneficiaries and creditors of the deceased. But anyone who seriously examines this claim in the year 2025 knows it's laughable. Imagine if today's newspaper told Maryland's commercial advertisers that to reach potential customers via the newspaper, they would have to use legal ad-like ads. It would be financially suicidal because unless the government forced them to purchase such ads, commercial advertisers would avoid them like the plague. To be sure, 150 years ago, commercial advertisers were happy to pay for such ads, but we're no longer living in the 19th century. The newspaper lobby will give you a big song and dance about how committed they are to legal ad transparency and accessibility. But communication scholars have for decades been trying to get information from the newspaper industry about the revenue brought in by legal ads. And the industry, including Maryland newspapers, won't provide it because they treat that information as a trade secret. So here they are once again asking to preserve or expand a government handout at the expense of the politically weak, but they won't reveal how much money they receive as a result. I've randomly asked many people over the years if they looked at legal ads to find out if they were a beneficiary of a deceased relative. Not one of them has ever answered yes To conclude, please support this bill and bring an end to this industry subsidy that preys on the politically weak. Thank you for your time.
Thank you, Mr. Snyder. I'm going to open it up for questions. Delegate Tolles, I go to the left. He goes to the right. Actually, I go to the right. He goes to the left. Delegate Tolles.
Thank you, Madam Chair. I have a question. You said, I'm sorry I didn't get your name at the end. You said that the website is already in existence?
Yes, it has been since 2020.
Okay, so I guess I'm trying to figure out, do folks not use it, or what's the emphasis behind the bill if the website is already in existence?
The problem is it's required in the code right now that it be in print, and that's what we're trying to change, that being on the website constitutes giving notice to the public.
Okay, so if you, so right now you can decide if you want to do print, well, you do print right now.
We have to do print.
So you have to do print.
Yes.
If this bill, I guess, was to pass again, then could you still do print, or you have to do website, or you have to put it on the web?
Well, we put everything on the website, so it's always going to be on the website, but they would not be required to pay for it in print. I guess if somebody wanted to pay extra to put it in print, we would do that for them, of course.
Okay, so you automatically put it on the website already?
Yes, every estate. Mm-hmm.
Okay. And what information is on the website?
Sure.
I've never known.
Delegate, so I want to, a couple quick things is that, as I mentioned, everyone gets a notice.
You have to use your microphone. You speak softly.
I'm sorry. I don't want to yell into the microphone.
That's okay.
So everyone in the state gets a notice mailed to them directly.
Yeah.
In addition to that, right now, they can look at those notices on our website. We still have this print notice publication, and that's what we want to do away with. We've had this online site up and running for a long time to demonstrate that it is a viable additional resource in addition to the print notice that we send to everyone. And Mr. Griffin noted it's growing traffic. Every month, the traffic on this site goes up, so it's easy to find. But the information that's included is the name and address of the personal representative, the estate number, when the estate was opened, the name of the decedent, whether they had a will, and if it's a regular estate, that's an estate that's worth $50,000 or more, it gives the date by which someone has a right to file a claim against the estate, to challenge the appointment of the personal representative, or to challenge the will.
Okay, and what's driving the traffic to?
I'm sorry, could you repeat that, please?
And what's driving the traffic to? You said you have a lot of traffic hits?
We'd have to go back and look at it, but I mean, we know we get a lot of traffic through Google. You know, when people just go and look at register of wills or estate notices in Maryland.
Who do you think are looking at those at the website more?
It's a lot of folks. It's creditors. It's people who are doing genealogical research. It's heirs research.
Who you think the most hits are from?
I'm not.
Is it
I'm not
50%?
exactly sure.
Is it 20? Is it evenly divided? Is it 50% more individuals that are?
I think it's probably mostly people who are looking for information online about. I think it's not people, I'd say it's a lot of people who don't necessarily have active estates. It's people who are doing research on family members who have passed away in the past. So it's on active proceedings. It's a lot of genealogical research.
So this is I don't want to say it's a dumb question, but you work with the courts, but are the courts, I mean, you know, obviously you work closely with the courts, with estates and stuff, but do the courts actually, like, how can I phrase this? Do individuals that have the court orders actually go to this website? Because I find that they say that they are not aware that this updated information exists on those that are passed. So you saying that this website exists, but say creditors may say, oh, I didn't know that, you know, there was an estate. Like, do you find that happening a lot? Like, So you,
No, I'll tell you, creditors are really good about finding out if someone's passed away. The vast majority of claims that are filed
I'm
in
saying,
our
so you
states.
have the address, so, okay, so you have address and everything on there.
Oh, yeah, mhm,
Okay,
absolutely. yeah.
because what I'm hearing is that they're not, oh, I didn't know that existed, or I didn't know what the correct address was, but you're saying with this website, you update it and put this information on there.
Yeah, I mean, we have our notices part of our website, but also anyone, anywhere can go onto our website and look up any estate that has ever been opened in Maryland and see the entire docket for that estate and request copies of all of that as well. So, I mean, I think that it's an extremely transparent system.
And how long do you keep it up?
Forever.
So it stays in perpetuity, you don't ever take it down?
If you go onto our website now, you will see every notice that we've ever published. And it will be up there forever. And under this bill, it will be an affirmative obligation, a duty of the registers to keep that in perpetuity. It's actually already a duty of ours to maintain the docket, and eventually these notices have to be sent to the state archives. That's in contrast, I would say, to the newspaper industry, who has no duty to archive, no duty to publish whatsoever. And especially when newspapers go under, who's to say that their archive notices will ever see the light of day? Our records will be public forever.
What do you say to those individuals that do prefer sort of the newspaper way of doing it? What do you say to those individuals that will prefer that?
I think I would come back to what Delegate Embry said, which is that, everyone already gets a notice. The purpose of this notice in the newspaper is not to satisfy people's curiosity. It's not a general notice to everyone. It's specifically designed to look for unknown heirs and creditors who did not already get a notice directly from us.
Can people opt out of a website? Can individuals opt out of a website?
Could they opt out of having their estate notice on the website?
Correct, with the state, what county are you in again?
Howard County.
Howard County? Yeah, so if you have a Howard County resident say, I don't want my information on website.
The probate process, just like every other legal process in the state, is a public process, so it's all public record.
Okay, so the individual could not, so you're saying they could not opt out of it if they choose?
You can.
Because it's their estate, so they would have to put it on the website?
Well, it's a decedent's estate, not their estate. But this is all public record. The only way that.
Well, let me back up. It's not their estate, but if they are the executor, then if they are the executor, they could, so you were being specific. I was making a point that if they are the administrator of that decedent's estate, it is now, they are controlling that estate. If they wanted to opt out of the website, is that a possibility?
Again, this is all public record. The only way that.
Yes or no? Is that a possibility?
The answer is no.
Thank
The
you.
answer is no.
Thank you.
Yeah, the answer is no.
Thank you.
Delegate Kaufman?
Yes. Delegate Embry.
Yes, sir.
I'm your friend and I want you to succeed. Therefore, I fear I'm glad I'm entertaining the staff. I fear a Groundhog Day scenario. So have you had conversations with Mr. Baker, Mr. Miles, to assess whether they will have an allergic reaction to your bill again this year?
I have had conversations with the governor's office. I think the issue was, despite it being a public process and all the ways that people learn about bills, the newspaper industry was not able to weigh in last year. They did not. They can talk about why they didn't. But in any event, so I think the goal was to allow, I think it was two goals, as I understand the governor's motivations. One is to allow the newspaper industry to have another chance to be heard, which is about to happen. And I, again, have the greatest respect for the work they do. But I do think this is distinguishable from other forms of notice. And the second was, they talked about sort of the broader issue that all of these laws were written before the internet existed. And so, like I said, there may be other bills, but I know that Delegate Foley came in with a bill that specifically added website requirements of notice, would add websites, newspaper websites. So that, I think, was accomplished. So I know that's a long-winded way of saying I think that the purpose was to have another bite at the apple, and that is happening.
And just very briefly, quick follow-up, Madam Chair. Couldn't the newspaper industry have signed up like any other Tom, Dick, or Harriet has the opportunity to do so?
Thank you. Yes.
Delegate Conaway.
Thank you, Chair. Thank you, panel, for coming in for this bill. So I just wanted to ask a quick question, because sometimes we get beat up on. Do you know that sometimes we ask questions in anticipation of future legislation, and that could be yes or no? Would anybody like to answer yes or
Do
no?
members of this committee ask questions? Sorry, I think the answer is yes.
Thank you so very much.
All right, seeing no further questions, we're going to move to the unfavorable. We have Mr. Craig Burke and Rebecca Snyder. Come on down.
We also should have Orestes Bias.
Oh, yes, you're absolutely right. We have Orestes, pronounce your name, Orestes?
Orestes, yes.
Orestes Bias.
Thank you.
Thank you. And if you want to start, Ms. Snyder.
Yes. Thank you, members of the committee, Vice Chair. My name's Rebecca Snyder. For the record, I'm the Executive Director of the MDDC Press Association, and we are opposed to House Bill 623. As Delegate Embry noted, this bill was vetoed by Governor Moore, and that veto was sustained by the House just a couple weeks ago. We believe very strongly in serving notice to the wider public. You know, we heard about creditors, we heard about heirs, but we also believe that there is a responsibility to inform the wider notice. This bill would upend the public notice that's been in place for 150 years, over 150 years. And it's not where, website traffic notwithstanding, the one website of the Register of Wills pales in comparison to the audience development of news media. And people look for these notices in their community papers, which are also publicized on their own websites and aggregated on the Press Association's website. But moreover, and I think Mr. Snyder discussed this, there's a huge economic impact to local news. If you look at the fiscal note, the small business cost alone is massive. This will have a devastating effect on your local news media. In every jurisdiction, there is a local newspaper. You can read in our testimony, aggregated for anonymity, some of our publications will close, some will consolidate. This is it is a revenue stream that is necessary to our members, and I urge an unfavorable report. Thank you.
Thank you. Mr. Chair, Madam Chair, and the committee members for persevering into the evening with us, and I hope the pizza is wonderful. My name is Orestes Baez. I'm Regional President for Adams Publishing Group in the Chesapeake region. I oversee a dozen newspapers, more than a dozen websites, magazines, digital products, over 20 newsletters, a whole host of products that we produce for the Chesapeake region. We believe that this bill will have significant economic impact on us as a business. It will cost some of our employees their jobs, and it may cause me to shut down some of my news publications. It is a significant revenue stream. We have had digital representation of the content in multiple places for a ton of years. This is nothing new. Ms. Snyder mentioned there's an aggregated website for the Press Association. We send these notices there. We also produce it ourselves in our own digital editions. So the landscape is being touched in a multitude of ways through processes that are already in place. The financial impact of this is pretty significant. It's estimated that there are 2.7 jobs impacted by every job in a news media operation. I have 10 offices in Maryland. I have landscapers. I have service technicians. I have phone technicians. I have cleaning crews. I have all kinds of businesses that my employees spend money on. taking this revenue stream out and shutting our businesses down not only impacts my business, but impacts all the other ancillary connected businesses in Maryland. So I ask you not to impact the Maryland economy and make this decision, and not to be favorable in any way, shape, or form with this bill going forward. It is a significant impact in a bunch of ways. So I ask that you create an unfavorable report, and thank you for your help.
Yes, thank you, members of the committee. My name is Craig Burke, and I am the publisher of Baltimore Jewish Times and also Washington Jewish Week. Our publications have been papers of record accepting legal notices for multiple decades. Our distribution spans throughout the Baltimore and Washington area Jewish communities with over 100 newsstand locations, enabling the legal notices to be accessible to the general public. The Register of Wills uses our publication titles because they're affordable and they are efficient. And by the way, we do check for errors and we correct errors that we find. We have a very good process. We oppose the proposed bill HB 623 to eliminate the legal notices in print publications. Our readers for Baltimore Jewish Times and Washington Jewish Week have an average age of 62. I believe we all can agree that not everyone has access to the internet, specifically many people in the senior communities and also the disadvantaged that are in those communities. Additionally, if legal notices are no longer run in our publications, this decision would negatively affect one of our major revenue streams. This will cause many to lose jobs, and the survival of our venerable publications will be in jeopardy. We ask you that you give HB 623 an unfavorable report.
Okay. Delegate Embry.
Is it possible, you've all talked about the impact on jobs. Could you provide us some breakdown of the revenue, what percentage it is for your publication, what the revenue specifically from this statute is, or any of the publications? Some data to support those.
Oh, absolutely. I can tell you sort of in aggregate. I don't think anybody knows, I don't know specifics, but I do know when we were polling, when I was polling our membership on this, it would be a $3.5 million hit, and the average cost of a estate notice is $129.
But the number of 1.3 million that the registers have, do you know why the number is different than that?
It could be, and the registers did say that sometimes the costs are asked to be paid up front by the person opening the estate. I don't know, and I'm sure I don't discount what the registers of wills are saying. I'm also not discounting what my members are telling me when I literally asked them how much it represents to them.
Thank you.
Mm-hmm.
Thank you, Chair.
Seeing no further questions, thank you all very much. That concludes the testimony on House Bill 623. And if I talk slowly enough, the Vice Chair will be able to walk all the way up there and get ready to present her bill, House Bill 629, the penultimate bill of the night. Not the last one, but the next to last one. So for this one, I think some people are going to be virtual, so we'll look over there real quick. But Lisa Jordan, Elizabeth Tang, Debbie Feinstein are all virtual.
Else to be here with me.
Stefan Turkheimer, are you here?
What's your last name?
Catherine O'Malley?
Roberson, okay.
Victoria Burke? Lauren Pruitt? John Cundliff?
Oh, I can't read.
All right, Melissa Spurn?
It's going to be Brooke Roberson.
Great.
Hold on, I'm in.
I think that's everybody. So we're just going to put everybody up there. This is going to be one big panel, and it'll be great. And Delegate Bartlett, you have 3 minutes.
Thank you, Mr. Chair, and good evening, members of the committee. I am here to present House Bill 629. For the record, I'm Delegate Sandy Bartlett. So, as we know, sometimes the old saying, no good deed goes unpunished. Well, we had the Me Too movement. And it was great. People felt empowered. Survivors felt, that they had a community of individuals who could support them. Well, what later became in retaliation to the Me Too movement were defamation or some type of lawsuit against the survivor. So the answer to the Me Too movement was to haul people into court, make them get an attorney, make them come down, take time off their jobs, and only for perhaps the case to be dismissed. And it was supposed to be it's meant to be a scare tactic, so people will stop coming forward and telling their truth. In Maryland, more than 1 out of every 4 adult women have been victim to rape at some point in their lifetime. Nearly half of Maryland's adult women have experienced other forms of sexual violence. In recent years, this body made a concerted effort to reform and support victim services in our state. And I'm happy with the progress that we've made. However, we can do more. Some states, like California, Rhode Island, Tennessee, New York, and Washington state, have passed laws to stop retaliatory lawsuits. By protecting survivors from these types of lawsuits and rewarding them for being brave enough to share their story, we send a clear message to victims that we support them. This bill does not arbitrarily protect anyone who falsely claims to have information about sexual violence incidents. As written, the language requires the establishment of good faith, and you have to have a proof of good faith by clear and convincing evidence that the disclosure is in actual malice towards the alleged or intentionally, recklessly false. So it's a nice high standard. As a state, we have decided that sexual crimes deserve our attention. I'm happy to state that the Women's Caucus the Women's Legislative Caucus supports House Bill 629, and I've also received several emails in support of the bill. Thank you.
Please, then we'll go to our virtual.
Good evening, Mr. Chair and members of the committee. My name is Brooke Roberson, and I am a law student and an extern at the Aaron Levitas Sexual Violence Prevention Initiative, operating through the University of Maryland School of Law. I'm here to testify in support of House Bill 629. First, Bill 629 will help make college campuses where sexual assault is at its highest safer by encouraging victims to come forward without fear of further repercussions. As president of a sorority, the sisters felt more comfortable sharing their sexual violence experiences with me rather than reporting to law enforcement or Title IX officials. Their assaulters would use phrases such as, "Your shirt's already off, let's keep going. I promise I'll stop asking if you just do it this once. I know you've done this before." While the conversations were disheartening, they were not unique. One survey found college-age women were 3 times more likely to experience rape and sexual assault compared to women ages 12 to 17 and 25 or older. Second, Bill 629 will help reduce the chilling effect of potential civil liability for reporting sexual assault to campus officials and police. This chilling effect means survivors refrain from reporting incidents to law enforcement or Title IX officials out of fear of enduring further trauma, potential civil legal consequences, or damaging social relationships. As a society, we want to encourage the reporting of sexual assault because we can support the survivor to reduce the trauma, prevent harms to others, and work on solutions. Third, Bill 629 protects those who file charges in good faith against their assaulters from being sued in civil court. Without Bill 629, survivors may face additional court costs as well as the psychological trauma of another trial. I therefore urge a favorable report on House Bill 629. Thank you.
Thank you.
Now we're going to go to the people who are on virtually. We'll start with Lisa Jordan for 2 minutes, please.
Thank you, Mr. Chair. Madam Vice Chair, I'm Lisa Jordan with the Maryland Coalition Against Sexual Assault. We're here in strong support of House Bill 629. Vice Chair Bartlett, thank you for your continued leadership in this area of the law. The Maryland Coalition Against Sexual Assault represents all the rape crisis centers, but we're also home to Sally, the Sexual Assault Legal Institute, where we provide direct legal services to survivors all across the state of Maryland. And House Bill 629, it balances two competing interests. On the one hand, sexual assault is wildly underreported, and we have to encourage survivors to come forward. We encourage them to speak out, to refuse to be silenced, to help put sex offenders in jail and keep our communities safe. And civil lawsuits are being used to silence survivors. We see it at Sally, we see it throughout Maryland, we see it throughout the country. There's actually a cottage industry of law firms, of attorneys who are seeking people who have been accused and encouraging them to file suits. When survivors are sued, they're put in the position of having to prove that the assault occurred. So it places the burden on them. Truth is a defense. And the whole process, it's re-traumatizing, it is very costly, and it forces many survivors into silence. On the other hand, access to the courts is important. People who are falsely accused should have a remedy. And House Bill 629 really balances those competing interests. It allows recovery when there's proof that a person intentionally or recklessly disclosed false information or acted with actual malice. It makes civil lawsuits kind of a less attractive weapon to silence survivors. You're going to hear stories from some of the other witnesses, but I'm going to conclude with one in our written testimony. Our client was sexually assaulted by her doctor. And like many women, she decided not to report. Then she was watching TV and she saw on the screen a prosecutor and a picture of the doctor. And the prosecutor was saying, if you've been assaulted by this man, please come forward. And so she did. House Bill 629 would make it so that doctor wasn't able to sue her, which he also did. It would create more of a barrier. For these reasons, and I'm sorry I'm talking slow, it's so late, we urge a favorable report on House Bill 629.
Debbie Feinstein for 2 minutes, please.
Good evening, Chair Clippinger and Vice Chair Bartlett and members of the committee. My name is Debbie Feinstein. I'm the Chief of the Special Victims Division for the Montgomery County State's Attorney's Office. I'm testifying in support of this bill because we have so many cases that come through the criminal justice system that we can perhaps prove beyond a reasonable doubt or perhaps not. And our standard is such that we, as prosecutors, we have an ethical obligation not to proceed if the case is one that we don't believe that we can prove beyond a reasonable doubt. But that has nothing to do with whether someone is telling the truth or coming forward in an honest fashion. And this bill will protect those victims who are true victims, even when we can't prove the case beyond a reasonable doubt, which should not be the standard. I just want to relate a personal story as well. I have a friend that I know from college who was sexually abused by her stepfather. She has elected to express her experience through an art form. And prior to expressing her experience through that art form, she had to consult multiple lawyers. And she knows that she's at risk of being sued. And that is a calculated risk that she's going to take. This is not a risk that a sexual assault survivor should have to take. And this bill corrects that. Thank you for your time this evening.
Ms. O'Malley.
Good evening, Chair Clippinger and Vice Chair Bartlett. Vice Chair Bartlett, thank you so much for bringing this bill forward. HB 629 will expressly protect survivors of sexual assault from frivolous and retaliatory lawsuits aimed at silencing them by their attackers. The bill grants a survivor immunity from civil liability if the survivor discloses the information in good faith. And as already stated by Ms. Jordan, the bill balances this access to court by having a presumption of good faith, but if the moving party can prevail, that they are able to show that the survivor acted in malice or intentional disregard for the truth or recklessly disclosed the information, they would still have access to the court. So it's balancing the rights of the survivor with also the individual who wants to seek redress if they're saying that they're being defamed or there's an intentional infliction of emotional distress. Sexual assaults, as already stated as well, are underreported in our state as well in our nation. And at the Women's Law Center of Maryland, we represent many survivors of sexual assault in Title IX cases across college campuses, and also survivors seeking final protective orders. So many times these survivors are fearful coming forward because of these retaliatory lawsuits. And it already takes so much for a survivor to come forward, to go to law enforcement, to report these crimes, to go through forensic exams and all that they have to go through if they go through a trial, but also making them go through civil lawsuits and facing this type of litigation is really outrageous. So I am seeking and asking for your favorable report on H. Bill 629, and I thank you for all your patience this evening.
Elizabeth Tang for 2 minutes.
Is she here? Oh, there she is. Okay.
But unmute yourself. There you go. Ooh, do it again. There.
Good evening, Mr. Chair, Madam Vice Chair, and the committee. I'm Elizabeth Tang from the National Women's Law Center. I'm a civil rights attorney and I'm a survivor, and I'm here in strong support of the Stop Silencing Survivors Act, HB 629. Here in Maryland, nearly 2 million residents will be victims of sexual violence in their lifetime, but most of them will never ever come forward. And one of the biggest reasons why survivors stay silent is the very real fear of retaliation. 1 in 5 student survivors are targeted or threatened with a defamation lawsuit. Defamation suits are the 3rd most common type of retaliation faced by survivors in the workplace. As you heard earlier, these retaliatory lawsuits against survivors have become a cottage industry. Now, abusers do not necessarily expect to win these frivolous cases, but they know that their victim must still incur immense financial and psychological costs to defend the lawsuit to the very end. We're talking about anywhere from 5 to 6 to 7 figures to defend these lawsuits. This is how many victims are coerced into staying silent or withdrawing their claims. And I have seen many of these terrible cases at National Women's Law Center. In 2023, I co-authored a toolkit with survivors who have been sued for defamation for other survivors who are sued for defamation on how to fight back. I've also submitted numerous amicus briefs to state courts in Connecticut, the District of Columbia, Illinois, Massachusetts, and New York in support of survivors who were sued for defamation after reporting sexual assault. HB 629 is critical because it would ensure that abusers can no longer weaponize our legal system against their victims, and they will protect Maryland survivors' right to speak out in good faith. HB 629 is also nothing new. In the past few years, states like California, New York, Rhode Island, Tennessee, Vermont, and Washington State all have passed laws to explicitly protect survivors from being targeted by defamation suits and other abusive lawsuits. I hope Maryland will join them. For all these reasons, I ask the committee to issue a favorable report on HB 629. Thank you.
Stefan Turkheimer? No. But Jack Codliff jumped when I said, okay.
Mr. Chair and Madam Vice Chair, thank you very much for allowing me to testify this evening, and I thank you for staying so late to consider this very important bill. I'm a partner at the firm of Levin & Gann. I've been an advocate for victims of child sex abuse, child physical abuse, and for the last 7 years for the Maryland Coalition for Rape and Sexual Assault Victims. To my shock, most of the work that I have done for them has been, in fact, defending defamation cases, not seeking damages against perpetrators of sexual assault. For these sexual assault victims, the mental injury along with the physical injury is severe depression, severe anxiety disorder, post-traumatic stress disorder, which can take years to treat. But even for those who do not suffer severe mental injury, it goes without saying that what has happened to them is going to be with them the rest of their life. It is not something that they're ever going to forget. I'm currently defending a young woman who is being sued, who went through a Title IX proceeding at one of our universities in this state. She did not realize immediately that she'd been raped because she was put under the influence of a severe amount of alcohol. Her memories were not good. When she did report it, she was assured by the university that the process would take about 3 months. The process took over a year of having to relive the events over and over. Subsequent to the Title IX hearing committee finding that she was raped by this person, the person then turned around and sued her for defamation. because there are no protections in this state for res judicata. In other words, even if the university follows all the requirements of due process, and there is a Connecticut case on point, Maryland still has not recognized that she is protected. The only way to protect her is through this bill. Just to follow up on what Ms. Tang said, I recently had to report my time and hours to MCASA. Over $70,000 of my firm's time has gone into just this one case, and I'm sure for all the cases I've defended, well over six figures.
Thank you.
This law is imperative. There are, as you said, are firms that are specializing in suing people who are victims of rape. Please pass this bill. Please try and make it emergency legislation, and please make it effective.
Thank you very much, please.
Yep.
Thank you. Thank you. Victoria Burke.
Good evening. My name is Victoria Berg. I am an attorney and adjunct law professor. In December 2019, I went out with a male friend who I believe drugged my drink. 1 minute I was in the restaurant, and next moment I am in the ER, waking up from a severe coma, not knowing how I got there. Paramedics had found me unresponsive in a parking lot, lying in a pool of my own vomit with my top undone. I went to the police immediately, expecting an arrest to be made. However, the police had lost my blood evidence and the video evidence, making an arrest nearly impossible. I was telling a friend what had happened to me, and she cautioned me not to use his name, not to use anything that could identify him when I'm talking about what happened to me. She warned me that I could be sued for defamation, and my friend was also a defamation attorney who's telling me this. She told me how there's an uptick in all these litigations against people. And I said, well, how could that be? Because the defense to defamation is truth or opinion. So it's either true he drugged my drink or it's my opinion. And so when she told me this, I was very much outraged that not only would my abuser have gotten away with what he did to me, he can now control how I discussed it. So he was essentially gagging me. So I felt this is a continuation of the initial attack. If he still has control over me about what I can say and cannot say, and I don't think it's the role of the survivor to protect the abuser's reputation and having to shield them from when you're speaking out about what happened. So I encourage you to favorably vote on HB 629. Thank you.
Lauren Pruitt.
Good evening. My name is Lauren Pruitt, and I'm the legal director at Free State Justice, a nonprofit organization dedicated to serving LGBTQ+ Marylanders. According to the Bureau of Justice Statistics, reports of sexual assault to police increased from 21% in 2022 to 46% in 2023. Despite this increase, and as others have stated tonight, sexual assault remains one of the most underreported crimes in the United States, especially among types of violent crime. When victims do come forward, they may be met with retaliatory defamation suits from their abusers, intended to silence them from speaking out, a trend that has been witnessed across the country. HB 629 addresses this by shielding survivors from liability for disclosing information about alleged sexually assaultive behavior in good faith. Studies by the Williams Institute found that LGBTQ+ individuals are nearly 4 times more likely to experience violent victimization than non-LGBTQ+ individuals. Additional research indicates a heightened risk for LGBTQ+ people of color and transgender and gender nonconforming individuals. In Maryland, transgender individuals report alarming rates of physical and/or sexual assault. The 2023 Maryland Trans Survey found that 46% of respondents reported at least one such experience, 23% reported 3 or more. Given the rates of sexual violence experiences among this community, HB 629 is crucial to support LGBTQ+ victims in speaking out and seeking support. Economic insecurity leaves individuals more susceptible to experiencing sexual violence. Victims of sexual assault often struggle with maintaining employment, housing, and education following the experience, as well as struggles with mental and physical health. Such factors perpetuate a cycle of violence and insecurity. Sexual violence often leaves victims with little financial resources, making it challenging to defend themselves against the potential legal and financial repercussions of speaking out. The impact of this economic insecurity on victims is profound and should not be underestimated. I urge the committee to issue a favorable report on HB 629. Thank you.
Now, questions, starting with Delegate Arakan.
Thank you, Mr. Chair. Thank you so much, Delegate Bartlett, for bringing this bill. I just have a couple questions. Maybe one of your panelists already mentioned it, but could you just say what, again, other states already have a policy like this in place?
Sure. 1 second. We've got California, I remember. We've got California, Rhode Island, Tennessee, New York, and the state of Washington.
Okay, so it's kind of new. My main question is there any scenario where this can end up getting potentially weaponized against the victims? A lot of times in court policy, we try to help victims and then it gets turned around and used against them. I can't see anything in here in the text of the bill, but I just want to make sure there's nothing that I could be missing.
I don't think that we have missed anything. You know, what we have done is even allow the defendant to receive attorney fees.
Yeah, I saw that.
So that if, you know, if the survivor is hauled into court, the prevailing party gets to receive attorney fees. And so it's not, I don't think we've missed anything. Personally, I think that that given the nature of a defamation suit, and you know, truth is the best defense. We put in the actual malice standard because that is already in the rule. That is already the standard in order to get attorney fees. So that wasn't anything, you know, new or crazy there. So no, I don't think there's anything that we've missed, but you take a look at it, and if you find anything, I'll take it as a friendly amendment. If there's something,
I appreciate that. No, I think this looks, I mean, it looks like you've struck a chord where you've sort of balanced the needs of both parties, and there's only a tiny bit of opposition testimony that I don't personally think is relevant.
Thank you, Mr. Chair. Ms. Jordan, you mentioned your client had gotten sued. Can you kind of articulate on that for us a little, please?
Yeah, thank you, Delegate Grammer. I appreciate that question. I think it's an important question because although it is true that our client was sued for defamation, she was also sued for intentional infliction of emotional distress, for malicious prosecution, for interference with contract, and more. There were, I believe, 12 or 13 different counts. So it's very important to note that House Bill 629 really covers all of those causes of action, any cause of action. Because if we do limit it to defamation, it is so easy to get around that it really will not be an effective tool. So we encourage you to keep that broad. Thank you.
Thank you.
Yes, and can I just add one little thing to that? And I'm glad that Ms. Jordan mentioned that, and Delegate Arakan, just, I don't know if you heard that, but it is a broader bill than defamation, which is very good. Yeah.
Seeing no further questions, we thank you all very much, and that concludes the testimony for House Bill 629. Thanks for being with us tonight on the Judiciary Show. Now, the last bill. Only one bill. One person in favor, 2 people against. Delegate Grammer, House Bill 353.
Thank you, Mr. Chair. With your permission, I'll get started. Thank you, Mr. Chair, Madam Vice Chair, members of the committee. For the record, Delegate Robin Grammer here to present House Bill 353, the Maryland Constitutional Carry Act. House Bill 353 strikes the permitting requirement to carry a firearm for lawful Maryland owners. Maryland laws regarding the carry of firearms have been and continue to be oppressive for Marylanders' right of self-defense. For decades, the Maryland good and substantial or proper cause requirement denied the carry rights for Marylanders. Although it was struck down by Bruin, Marylanders continue to face administrative hurdles and personal costs to exercise what is universally accepted to be a right. The concerns about the availability of Marylanders carrying firearms for purposes of self-defense have been completely unfounded, as expressed by the Maryland State Police, as they have testified to this in this committee over the past several years. Knowing this, we should do what we can to tear down hurdles so that Marylanders can exercise their rights without consequence. House Bill 353 does that by removing the permitting requirement for lawful owners in Marylanders to carry a firearm. The Crime Prevention Research Center reports that active shootings in the United States were prevented by armed citizens. Those rates are as high as 34.4%. And not only does requiring a permit hurt those who are poor, it puts average people through a politically driven adjudication process, which removes or delays the right of self-defense of potential victims. But it does nothing to stop criminals who are already determined to break the law. We can protect the right of self-defense of Marylanders by passing the Maryland Constitutional Carry Act. With that, I'd be happy to take questions, and I'd ask for a favorable.
Questions? Delegate Valentine and Conaway there.
Thank you. Thank you, Mr. Chair, and thank you, Delegate, for bringing the bill. I think I heard somewhere in there regarding the laws being maybe driven politically or to the detriment of public safety. Can you explain or expand upon that?
Yeah, very briefly. You know, good and substantial was the rule for decades. What we heard over and over again was Marylanders carrying firearms for self-defense would result in more violence. We heard it during the testimony in 2013 when fairly substantial laws were passed to criminalize ownership. That was all, it turned out to be unfounded. As you know, the Maryland State Police have said that for the second time this year. We had an amendment here in this committee we voted on regarding carry on private and public lands that was shot down in the Supreme Court. And you know, in the coming days or weeks, we're gonna be voting on another such piece of language in the contraband bill. There's evidently a need. In your email, there's an amendment to that bill to strip out the felony count for the illegal sale of stolen firearms. And so evidently there are still folks who think the argument for that amendment was that there are some folks who need to carry these stolen firearms to protect themselves. So I think ultimately these arguments we hear are very practically silly. I think it's been proven over and over again as the expansion of carry is now in the tens of thousands of Marylanders. And I think for those people, we should do everything we can to protect this right.
Delegate Conaway.
Thank you, Mr. Chairman. Thank you, Delegate, for bringing this bill.
You got it.
Are you saying that the average citizen who is able to purchase a firearm should be able to carry their firearm?
If you can, this bill says if you can lawfully purchase, you can lawfully carry.
So the answer is yes.
What do you think about that?
The answer is yes.
The answer is yes.
So are people who are disqualified from getting a permit, would they be disqualified from purchasing a firearm?
If you can't purchase, I don't know what you're going to carry.
Well, that's very interesting.
What do you think about that?
Well, I'm trying to help you with your bill, but I don't know now, so I have to think about that.
Yeah, and you know, just to clarify, you know, this bill doesn't touch on the handgun qualification license, which is a lot more stringent than any purchase requirement.
What I'm saying is, if someone is not allowed to purchase legally a firearm, then they wouldn't be allowed to carry a firearm, right?
Correct.
But if they're allowed to purchase the firearm legally, go through the hoops and all of this, then they should be able to carry their firearm.
I believe so, yeah.
Thank you very much for clarifying that for me.
You got it.
Delegate Valentine, because I cut him off.
Thank you, Mr. Chair. I just wanted to clarify the tens of thousands of permits. I remember some of the testimony from the state police is the spike in crime hasn't risen with the rise in permits, correct?
Correct.
And you mentioned tens of thousands. I believe, and I don't know if you have it in front of you, but is it not correct that there's actually probably over 100,000 permits in the state of Maryland?
Oh, absolutely.
Well, I believe it was over 100,000 now. To 200,000, I believe.
It's well over 100,000. I don't know what the current number is.
Thank you.
Anyone else? Delegate Schmidt.
Thank you, Chair. Besides a few questionable co-sponsors on this bill, Delegate Valentine, I do have a question regarding
We're all tired.
I can see here with the 21 years or older, is that?
So in drafting of this bill, it had to conform to other parts of the law.
Okay.
And that, frankly, is conforming this language to language elsewhere in the law.
Okay. And I know you quoted some statistics since the Bruin decision. I know some crimes have changed in the state of Maryland or gone down. Is that?
I'm not sure what you're referring to there.
Okay. All right. Maybe I'm referring back to the Maryland State Police reporting, but thank you.
Second and last bite.
Would the people who paid for their permits and all, would they be reimbursed, or do you think they should?
No, this bill doesn't
No, but
require.
I'm saying, do you think they should be reimbursed? Is that fair? Or you didn't think about it, so?
Well, I think that the people who want to exercise their right shouldn't have to pay for it.
Yeah, but I was asking about the people who've already paid for it and gone through the
This bill
course,
does
so.
not require reimbursement.
I understand that. So you keep taking it away from me.
Do I think they should be reimbursed? Yeah.
Thank you very much.
Thank you.
See a fiscal note. Anyway, seeing no other questions, thank you very much.
Thank you,
We're
Mr.
going to the person in opposition, Aaron Earp. We also had Ramya Swamy. No, okay. Ms. Earp, for 2 minutes, please, in opposition.
Good evening, Mr. Chair and members of the committee. My name is Erin Earp. I'm a senior policy attorney at the Giffords Law Center to Prevent Gun Violence. I'm also a resident of Calvert County. Thank you for the opportunity today to testify in opposition to HB 353, which would entirely eliminate Maryland's concealed weapons permitting system. This bill is dangerous. Our system ensures that individuals who are allowed to carry firearms on their person in public have undergone a background check, are not legally prohibited from possessing firearms, and do not have a propensity for violence or instability that may reasonably render them a danger to themselves or someone else. They also are required to complete a firearm training course, which includes a live fire qualification. This bill would eliminate all of this, which would lead to a significant increase in the number of dangerous and unqualified people carrying firearms in public. And research shows that repealing concealed carry permitting increases violence. States that ended live fire training requirements when adopting permitless carry saw 32% increase in gun assaults, and weak concealed carry laws are associated with 11% higher rates of homicide committed with handguns compared with states with stronger permitting systems. And these impacts also extend to non-fatal injuries, including a 9.5% increase in rates of gun assaults in the first 10 years after states adopt weaker standards. And there's no evidence to suggest that expanding public carry has any public safety benefits. Further, Maryland currently does not recognize concealed weapons permits from other states. Only those with a Maryland permit can carry publicly. Repealing this permitting law opens floodgates for dangerous individuals from outside the state to carry here as well. This concealed weapons permitting system was amended in 2023 following the Supreme Court's ruling in Bruin, and it fully comports with that decision and with the Second Amendment. The Supreme Court was clear that shall issue permitting systems like the one currently in place are constitutional, and that the state can take these steps to ensure that people who are permitted are safe and responsible, and I urge an unfavorable report. Thank you.
Questions? Seeing none. That concludes the testimony. Thank you very much for sticking with us this evening. That concludes the testimony on House Bill 353. Ladies and gentlemen, we will be back tomorrow at 1 o'clock for more bill hearings with only about 45 witnesses, followed by, we'll say about 30 minutes after the voting session, or 30 minutes after bills, we'll have a voting session. Thank you all very, very much.